I declare open this public hearing for the Senate Legal and Constitutional Affairs Legislation Committee's inquiry into the provisions of the Religious Discrimination Bill 2021, the Religious Discrimination Consequential Amendments Bill 2021 and the Human Rights Legislation Amendment Bill 2021. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live via the web and in Parliament House. The committee has agreed that members of the media may record the proceedings subject to the standard rules and any directions from the committee or secretariat. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. I remind witnesses that it is not the role of the committee to arbitrate or resolve individual matters. If a witness reflects adversely on another party, the committee is generally required to offer the adversely reflected on party an opportunity to respond to the relevant comments. A witness called to answer a question for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode. And now, with the formalities over, I welcome everyone here today. And we are going to kick off with representatives of the Public Interest Advocacy Centre and the Australian Discrimination Law Experts Group. I would also just remind everyone that we are on a very tight time frame today. We do need to stick to time. So for all witnesses, I would greatly appreciate if they could keep their answers succinct, and that of course goes for the questions for senators. To both witnesses appearing, thank you so much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 6 and 115 respectively. If you do not wish to make any corrections to your submission, if you do so, please indicate. But for the Hansard record, would you please state your full name and the capacity in which you appear today?
My name is Jonathan Hunyar. I'm the CEO of the Public Interest Advocacy Centre.
Thanks, Mr Hunyar.
My name's Alastair Laurie. I'm the Policy Manager at the Public Interest Advocacy Centre.
And to the Australian Discrimination Law Experts Group?
You're on mute, Robin.
I think there's someone, if you can just unmute your microphone. I know it's very tricky appearing remotely, so over to you.
Robin Banks to the Australian Discrimination Law Experts Group.
Dr. Christy Clark from the Australian Discrimination Law Experts Group.
Dr. Alice Taylor from the Australian Discrimination Law Experts Group.
From the Australian Discrimination Law Experts Group.
That quiet. We need some more.
Yeah, that's fine. But sorry, Mr. Elphick, can you just restate your name?
Sure, Liam Elphick from the Australian Discrimination Law Experts Group.
All right, terrific. Yes, and Senator O'Neill has just indicated that we do need some more volume. So, thank you very much for your forbearance. In appearing remotely, it is a little bit more challenging, so we appreciate your cooperation in that regard. Could I ask either group to make a 1-minute statement, a maximum 1-minute statement, if they wish?
Thank you, Senator. I may go first on behalf of the Public Interest Advocacy Centre. Thank you for the opportunity to give evidence today. The Public Interest Advocacy Centre supports legal protection against discrimination on the grounds of religious belief in public life, consistent with protection of other grounds such as sex, race, disability, age and sexual orientation. An appropriately drafted Religious Discrimination Act could play an important role in supporting a tolerant, diverse and fair community and help prevent discrimination against religious minorities in Australia. But this, unfortunately, is not that act. The Religious Discrimination Bill this committee is considering radically departs from existing anti-discrimination law principles and norms, undermines the rights of women, LGBTI people, people with disability and people of minority faiths to live free from discrimination, fails to adequately protect the rights of children, is excessively complicated and privileges religious views in ways that we think will corrode rather than build tolerance and harmony. So we urge the committee to reject the bill. Thank you.
Thank you. Now to the Australian Discrimination Law Experts Group.
Thank you, Madam Chair, for the opportunity for our group to give evidence. We too note the importance of ensuring appropriate federal protection against discrimination on the basis of religion. However, this package is not the right way to do this. We have a number of concerns about the package that are set out in our submission, and we take this opportunity to highlight several of these. The package should not be supported because it will result in bad law. Firstly, because it will override other fundamental human rights and freedoms in the name of religious freedom. Second, because it departs significantly from the existing discrimination law framework in Australia. Third, it is inconsistent with international human rights law and thus its constitutional validity is questionable. And finally, the package will seriously undermine the existing concurrent operation of state and territory discrimination laws, and through this and its override of other federal discrimination laws, undermine access to justice. Thank you, Madam Chair.
Thank you so much. We'll now go to questions and we will start with Labor senators. Senator O'Neill.
Thank you very much, and can I thank you for the considerable effort that you must have put into your submissions to prepare such carefully produced work. Can I go immediately to give you the opportunity to hear from you in response to those submissions, because the time that we're going to have is very, very short. Is there anything that you have read or heard, either in this inquiry process or the hearings of last week, that you would like an opportunity to respond to? Might go to a person, whoever's going to be the spokesperson for the Australian Discrimination Law Experts Group. Is that you, Ms Banks?
I'm happy to very briefly address.
Thank you.
Certainly, one of the issues that has come up and which I observed during yesterday's hearings is misunderstandings about the way the somewhat now infamous Porteous case has been presented by those who oppose the retention of Section 17(1) of the Tasmanian Anti-Discrimination Act. Yesterday I heard it said that the complainant didn't turn up to conciliations. I heard that it was tens of thousands or more dollars involved in defending it, and it was a lengthy and expensive process, and that the respondents were forced to attend meetings. None of those statements, I think, are accurate, although I can't comment directly on their legal costs, but it wasn't a long and drawn-out process. There were not extensive documents, and the process designed in discrimination law is to be accessible without legal representation, and I note that the complainant didn't have that. I am concerned that this continues to happen, that case continues to be misrepresented, and it seems to be the basis of at least part of Clause 12.
Thank you for that, Ms Banks. And, not having been involved with the Porteous case in the same position as you, I've heard it reported in many ways, but the Equality Tasmania submission is very helpful in actually putting forward some documentation that actually does reveal the nature of what was considered. And I'm sure that there'll be a range of views about whether that was a good thing or a bad thing, or, which way's up, which way's down. There's a lot of debate here with opposing views. So I think that does make things a little clearer for us all. Could I go now to the Public Interest Advocacy Centre and give you the opportunity to answer the same question. Is there anything that you wanted to respond to or anything you want to add?
Alastair Laurie, Policy Manager at the Public Interest Advocacy Centre. One thing that came up in yesterday's hearings was the submission from Professor Aroney and questions about his proposed amendments to Clause 11 and Clause 12.
Yes.
PIAC expresses its opposition to those drafted amendments for a number of reasons. We don't support them in principle. That's because we don't support the Commonwealth override of state and territory legislation in this way. We don't support them in substance because we don't support taking away existing rights from teachers and other employees of educational institutions or overriding via the statement of belief provision to allow derogatory and demeaning comments against people. We particularly don't support the amendments as drafted. We note that his proposed amendments to Section 12 in fact override Section 18C of the Racial Discrimination Act, as well as anti-vilification provisions in state and territory laws, because it's not limited to discrimination under those laws, but applies to anything that is unlawful under any of those acts. And finally, we think that it would be much clearer and much fairer to remove both of those provisions so that religious belief is protected on an equivalent basis to other protected attributes.
Thank you, and that's very clear evidence. Thanks. With regard to your recommendation 1, Mr. Laurie, the Religious Discrimination Bill should be rejected. We heard a lot of pleas from religions, majority faiths and minority faiths, pleading really with the committee to advance this piece of legislation that they've been waiting for protection in line with international conventions for a very, very long period of time. Do you still believe that the bill should be rejected in toto?
As we indicated in our submission, yes, that's our primary recommendation. Listening to the evidence yesterday, it was clear that a number of religious groups, including a number of religious minorities, were frustrated by the lack of protection for religious belief in anti-discrimination law, and we absolutely support them in their call for religious belief to be protected in anti-discrimination law. However, as my colleague Jonathan made clear in his introductory statement, this is not the right way to go about it. We support a standard religious discrimination bill, which includes protections for belief on the same basis as other attributes, not the bill that is before the committee, including the unprecedented statement of belief override, the education employment in religious schools override, as well as the extreme versions of religious exceptions contained in the bill.
Can the bill be sufficiently amended to meet the concerns of those people of faith who put that frustration on the record yesterday, Mr. Laurie, in your view?
In my view, it would be extremely difficult to take the current version of the bill and render it in a satisfactory manner, but I might pass to my colleague, Mr. Hunyor.
Well, can I invite him to put that on the record? I just need to go, because I know what time's going to get the better of me. Can I just quickly go to Ms. Banks? The submission from the Australian Discrimination Law experts, that was Mr. Laurie, wasn't it?
That's me.
Oh, okay, Ms. Banks, thank you. So you seem to have a different view. At page 5 of your submission, you indicate that parts 3, 4 and 5 of the bill are largely consistent with the right to non-discrimination, and if the bill proceeds, these parts should be retained. Do you want to speak to that? Is this bill redeemable? Can it be amended to provide comfort to people of faith who seek protection against religious discrimination in a way that doesn't damage the communities that you are seeking to represent here today?
Thank you, Senator. And if you want to use the acronym ADLEG, please feel free.
Thank you.
We certainly have taken a slightly different position, but I think you'll see from our recommendation 6 that our view is that the consultation process and the opportunity for members of affected communities to participate and really to engage with what is, as Mr. Hunyor said, a very complex piece of legislation. We really don't think the bill should proceed until we have had a proper opportunity to examine all of the interactive details, because we had very short timeframes. So yes, we think that there are certainly parts of the bill that reflect conventional discrimination law, and to that extent, it is redeemable. But we are concerned that there are there might be micro details that in fact have a different effect to what we see in existing law, and so it really needs a much more fine-tuned examination to determine whether or not those provisions should all proceed.
And that failure of consultation, I think, is now a matter of record. The 13th of December, the Prime Minister announced that the government was going to enact this legislation in 2018. And then on 29th of August 2019, we had the first release of the exposure draft. And then another on the 25th of November 2021, we got the introduction of this. So the delay has been extraordinary. And then this collapsed time for consultation doesn't augur well for good governance and good lawmaking, in my view. But if I can go to both groups, ADLEG and PEAC, in relation to Section 12, the Australian Human Rights Commission has submitted that it is not aware, and I'm quoting from them now, is not aware of any cases where a genuine statement of belief genuine statements of belief have been held to be contrary to anti-discrimination law. Are you aware of any such example?
I certainly am, and that is a case that went to the Supreme Court of Tasmania, Durston and Three Wise Monkeys, or Williams against Durston and Three Wise Monkeys. Mr Durston and his group circulated materials by mail that were extremely homophobic and derogatory not only of LGBTI community members but also of single parents and others. That was challenged under 17.1. He claimed it was his religious belief and he challenged the finding against him in the Supreme Court on the basis it breached his freedom of religion and his freedom of expression, and the Supreme Court held that 17 was an appropriately proportionate and responsible way of protecting people from discrimination and discriminatory conduct balanced with those other freedoms. So it has been tested in the Supreme Court of Tasmania and upheld, and that case is absolutely on point to your question.
Thank you. PEAC? Mr Laurie?
Apologies. I would take a slightly different interpretation of the Australian Human Rights Commission's submission in that their surveys of 2019 and 2021 reported a number of instances where complaints involved simple statements which could constitute discrimination, in which case there's a clear case that providing the statement of belief defence or override in those areas could therefore deny access to justice for the victims of that discrimination.
Okay. Now, I don't know if you'll need to take this one on notice because I'm getting the sort of the wind up on the time here. While the Australian Human Rights Commission recommends the removal of Section 12, it argues that Section 12 would not confer much, if any, additional protection to statements of genuine religious belief. Do you agree with those submissions? That is, that Section 12 would not confer much, if any, additional protections to statements of genuine belief? And if not, why not? And if so, doesn't it also follow then that Section 12 would not undermine existing protections under anti-discrimination laws? Mr Laurie, you want to kick us off?
Do you want to, look, Senator, I'm just wondering whether that could be taken on notice because we have reached the end of your time. And
well, I'd actually like to ask the Australian Human Rights Commission about this, so I would prefer to get it today, if I could, Chair.
Well, you've gone over your time, so that's going to mean that someone else, one of the other senators, has lesser time. Yeah, so
I think it's important evidence for us.
So if we could just get a very quick
Laurie?
answer, that would be terrific.
I think on that question,
could jump.
actually, I think my colleague wishes to speak.
Yeah, thank you, Senator. Part of the concern we've got with the way this is drafted, it explicitly seeks to permit things that are otherwise discriminatory. That's its purpose. Otherwise, there's no need to have it there. But also our concern is that it is deliberately drafted in a way that will, to capture fringe or radical views. It's entirely subjective in its approach, so it can capture views that may be disavowed by other members of that religion or any leaders of that religion, because it's seeking to really capture the most extreme views that no one else would agree with, as long as the particular individual genuinely considers them to form part of their faith. So to have crafted something so broad seems really only intended to capture views that are otherwise radical. And then in terms of whether or not it takes away other rights, I mean, that's why it's there. It deliberately seeks to do it.
Thanks. Ms Banks.
I think Liam Elphick wanted to comment.
Thank you.
Yeah, I'm happy to respond to that, Senator. So even if we were to take the view that this protection for statement of belief doesn't offer much in substance, and I would disagree with that assertion, there are significant issues with the access to justice it would deny individual claimants in state and territory systems. Our state and territory tribunals are the engine rooms of discrimination law in Australia. The vast majority of discrimination claims go through those systems, not the federal system. And constitutionally, most of those tribunals cannot hear a federal question of law. What that means in practice is if a complainant brings a case to one of those state and territory tribunals and the respondent simply raises the issue of statement of belief, doesn't have to be proven on the fact that they have made a statement of belief, they just raise the statement of belief issue, then that tribunal is going to be unable to hear that claim constitutionally. It's going to lead to significant delays, significant costs, and clogging up of the court system by having to take that claim instead to a Chapter 3 court, a Supreme Court, or the Federal Court, for instance. And it denies access to justice to the very people we are trying to protect in discrimination law.
Thank you. And if you could just take on notice with regard to the Tasmanian law in particular, Ms Banks, if you could provide an example other than something under 17.1, because really that's a vilification provision, not an anti-discrimination provision, that would be most helpful for the committee, because I'm keen to get these questions right when we get the Human Rights Commission here before us. Thanks for your evidence. Thanks,
Thank you
Chair.
very much, Senator O'Neill. Senator Bragg.
Thanks very much, Chair. Mr Elphick, I just wanted to ask you, having read your submission, so your view is that there should not be any statement of belief as part of this package, is that right?
Yes, that's correct. My very strong view.
Okay, I understand that. So in the worst case scenario, if there was to be a statement of belief that was included as part of this proposed law, do you think there's any possible way it could be drafted that could address your very serious and valid concerns?
So the first point I'd make is that certainly as a group, ADLEG does not support any form of the statement of belief provision, and that's my personal belief as well.
Yep.
But from my personal perspective, there may be ways in which the harm caused by the provision can be reduced. It cannot be removed if that provision remains in there because it is so unique and overrides other discrimination laws in a way we have never seen in 40 years of these discrimination laws. But one way and one suggestion through which it could be improved but not fixed is to apply the override only to federal discrimination laws and not to the state and territory discrimination laws and the vilification laws that we've been discussing, particularly in Tasmania. That would, on the one hand, resolve some of the issues around access to justice that we've been discussing, but it certainly wouldn't fix the myriad of other issues we have with that provision. But it would be one way in which harm could be reduced.
Okay. Well, conscious of time, I might just ask that we get that drafting from you on notice. Is that something that you can provide?
Around the federal versus state and territory examples?
Yeah, just about your position on noting your position that you don't support it in any form, but if there was to be any possible way of addressing your issues, if you could provide that on notice, I'd be very grateful.
We'll have to take that on notice. Yeah.
Thanks,
Thank
Senator
you.
Bragg. Senator Scarr, you have the call.
Thank you, Chair, and thank you everyone for joining us today. And I might at the outset know the great work that PIAC does in my home state of Queensland, in particular, to a long-standing project making sure that homeless people have access to legal advice. So I'd just like to mention that at the outset. I have a number of questions and I'll work through them as quickly as I can. The first is, this issue around what the role of courts and tribunals is in terms of what should the role of courts and tribunals be in terms of making an assessment with respect to what is a religious belief or what isn't a religious belief. Because from the reading of the submissions and the evidence we're hearing, it seems that there are differing views in this regard. And there's certainly, and I won't go through them all, but there's certainly judicial expressions of the view that it is not the role of the courts to be theologians. It's the role of the courts to actually enforce the law. And there is an issue if someone professes to have a subjective, sincerely held religious belief, that, especially in the case of minority beliefs, which may not be mainstream within a particular religious orthodoxy, that there is a concern that the courts can overstep the mark in terms of assessing whether or not an expression, a statement of belief or manifestation of belief is actually the manifestation of a religious belief, a bona fide religious belief. So I'm interested in the witnesses' views in that regard and how you respond to that, what I believe is a reasonable issue raised with respect to the role of courts and tribunals in terms of these matters. So if I could ask PIAC first.
Yes, thank you, Senator. I think the point you raise is a fair one. It is something that's been a cause of concern. One of the countervailing concerns that we have in the way that this bill is drafted is that it gives such it has such broad provisions that provide that apply to very subjective beliefs, that effectively it says that if anyone claims that their view is a religious belief, then they really get a free pass, and they don't need to comply with discrimination laws that we've had operating for decades in Australia, and those views are privileged. So very, very subjective views are going to be privileged over other forms of views and other beliefs on basis of conscience or principle that other people might have. So while I think the issue you raise is a hard one to resolve, because inevitably once the law gets involved, you need to make some assessment of bona fides and good faith and those sorts of things, which is going to require us to look at religion, the religious doctrine itself. This bill actually has real problems in the other direction, in really allowing anyone who claims to have a religious belief a free pass, contrary to, as I say, decades of protections that we've introduced to prevent discrimination.
Okay, and if I could ask for a response from the anti-discrimination experts. I can't remember what acronym we're using.
Thank you, Senator Scarr. Yeah, I mean, I think all of us have that concern, but the concern arises because religious groups seek to be exempted from discrimination law protections that apply to everybody else on the basis of belief structures. And once you ask for that kind of exemption, there should be some way to objectively test it, because we objectively test all of the other defences. And I'm going to throw to Christy Clark, because she may have something further to say.
Thank you so much, Robin. What I wanted to add is that I think that we have an opportunity to turn to international human rights law in terms of resolving this tricky issue. It is very difficult for the courts to get involved in assessing the genuineness or the validity of people's structures of belief, particularly in terms of religious doctrine. And it is something that I think there does need to be, some concerns around. But this has been looked at intently in relation to international human rights law under Article 18. And the resolution there is to place it within a system of human rights protection, which gives equal protection to everybody's right, and so that there's not a special override granted to one set of beliefs over everybody else's beliefs, and also rights to equality, non-discrimination, employment and education. And once you sit it within that system of balancing, then it's not such a concern that people do have a degree of latitude in determining their own views and beliefs.
Okay, all right, I'll move on to tricky issue number 2, and that is this differing view with respect to
Just 2 more minutes, Senator Scarr. Sorry, I'm going to have to keep you on track.
This will be my last tricky issue,
Yep.
around the boundaries with respect to where it's justified for a religious institution, say a religious school, to set expectations around compliance with the religious ethos of the institution. So on the one hand, you've got this view that if someone's seeking a job as a maths teacher at a religious school, all that's necessary is to consider whether or not they're a maths teacher and they can teach maths and treat the students appropriately in a pedagogical sense, I guess. On the other view, the sincere view has been put to us, well, no, they're in the context of a religious institution. Everyone from the gardener to the maths teacher to the person teaching religious instruction needs to share the ethos of the religious institution. And the former view demonstrates a lack of appreciation of the fundamental nature of religious faith. So I'm wondering if I can get your view on that, which seems to be, again, both reasonable, understood views in this regard. Piak first.
Senator, I guess the question for us is one of reasonableness and of balancing the different rights and the different values that we have in society. One of those is non-discrimination. We think that schools can maintain an ethos without having to discriminate. If your ethos requires discrimination, then there seems to be a lack of strength in the values and the leadership within your organisation.
But Mr. Hanyul, sorry to interrupt. It seems to me, though, when the statement moves into that ground, you're then seeking to impose your view with respect to religious ethos on others. Do you understand how I can, from their perspective, they say, well, it's not for Mr. Hanyul to decide what our religious ethos is. That should be our right to manifest our religious beliefs in communion. Do you understand that point?
No, I appreciate that. My point is that in maintaining an ethos, many organisations seek to maintain an ethos, but they don't do that through discrimination. They do that through living values, through the way that they conduct themselves, through a whole range of things. And we don't think that it requires discrimination to maintain an ethos. We agree that it can be a genuine occupational requirement for particular roles within an organisation. But otherwise, as a society, we have set expectations around how we conduct ourselves in public life, around how we deliver services and practices. And the point about manifestation of religion is that it is part of a balancing exercise.
Senator Scarr, I'm sorry, we are going to have to move to other senators.
Okay.
Could you place any other questions you have on notice?
I will. Thank you very much.
Thank you so much. Senator Rice.
Thanks, Chair. And look, I'll try and be quick. I want to talk about sort of access to justice and the interaction of the federal and state legislation with the overrides, and meaning that state bodies, anti-discrimination bodies, can't hear cases. We've heard some arguments that this will diminish over time as a body of law develops. Do you think that's accurate?
I'm happy to field that question. My answer is no, that's not accurate. I think it's a misleading representation of how cases would proceed under this particular override and this particular provision. This isn't Clause 12 and also Clause 11, which is also an override, are not simple provisions. They are complex provisions. They are not provisions that can be worked out with a little bit of tinkering here and there by this federal court and that Supreme Court. They would drastically undermine and throw into chaos our discrimination law system and the way in which victims of discrimination pursue justice through our courts and our tribunals, particularly at the state and territory level. I can't see a situation, and I've discussed this with my colleagues at ADLEG, utilising our many, many years of expertise on discrimination law. I cannot see a situation in which this naturally or automatically resolves through the court process. The provision should not proceed at all.
Thank you. And what would the human impacts be of this approach of sort of throwing our anti-discrimination sort of structures into chaos?
I guess I'm happy to answer that, but I'm sure PIAC has a view as well. Having been a legal representative for particularly people with disability, I know the levels of stress and anxiety that people go through, even with a pretty straightforward discrimination claim. And to add this level of potential to end up in a superior court where costs are awardable, people just won't go there. The risk of a costs order against you when you live on the borderline of economic stability is just not a risk that many people can take. So you have all that level of anxiety. And so instead what people will do is put up with conduct that treats them as less valid, less deserving of respect and dignity. And that, over time, erodes people's self-esteem and their sense that they have a role in Australian society. So it's both the sort of very practical impacts of the stress and anxiety of litigation, and then the more global effect of that discrimination has on people, particularly when it's seen as accepted by our society, acceptable forms of discrimination.
Thank you. Just a question for PIAC. I want to explore what the impact of this bill would be for a student who changed their religious beliefs while enrolled in a religious school, which of course, you know, if you're a teenager in a secondary school, it's a time when you are questioning your religious belief, and you might find in the middle of your time at that school that you no longer believe what you thought you believed as a 13-year-old. What would the consequences be for that teenager?
Thank you, Senator Rice. Your question goes to one of the key flaws of this bill as drafted, and that is that it allows religious schools to discriminate against children and young people on the basis of their religious belief beyond the point of enrolment. That falls short of what is considered best practice in Australia. So the jurisdictions of Queensland, Tasmania, the ACT and Northern Territory allow discrimination at enrolment but not beyond. We think that that's an appropriate balancing of the rights of faith communities to form schools to educate their children, as well as the protection of religious freedom of children and young people so that they can question, develop and explore their faith without fear of punishment on the basis of who they are. That's a core principle which is respected by this bill. And we'd also note that there's a flow-on impact potentially for LGBT students because of the ability of schools to discriminate on the basis of religious views about sexual orientation and gender identity rather than those things per se. We saw those implications highlighted by a number of the witnesses during yesterday's hearings, that they would discriminate against some gay students because of their approach to homosexuality and call it discrimination on the basis of religious belief. And so there's a longer term implication that even if the Sex Discrimination Act were to finally be amended to remove that explicit ability to discriminate against LGBT students, there's also a fear that a religious discrimination bill passed in its current form could be used to discriminate against LGBT students via an alternative means.
Thank you. And so, I mean, even then, if we removed Section 38(3) of the Sex Discrimination Act, this actually could still allow that discrimination against LGBTIQA+ students.
It could, and you'd also need to remove. You'd also need to clarify that 37(1)(d) of the Sex Discrimination Act didn't apply, as well as to prevent discrimination by religious schools beyond the point of enrolment. And again, we'd reiterate that those four states, four jurisdictions who have done so, Queensland, Tasmania, the ACT and Northern Territory, are not coincidentally the same jurisdictions that protect LGBT students against discrimination, because it is a necessary and important safeguard.
Thank you. How about for teachers? What are the implications of this for teachers?
I think the implications of the bill for teachers are even more direct and more apparent. So we see the override provision in Clause 11, which would allow for the Attorney-General to prescribe state and territory laws which have protected teachers against discrimination. Now, much of the debate to now has focused on the fact that that is in response, allegedly, to the recently passed Victorian laws, and indeed it would potentially make against teachers easier. It also has implications for Queensland, which has provisions which have existed for almost 2 decades, which use the terms about requiring discrimination not be unreasonable. It needs to be appropriate in the circumstances, as well as even potentially applying in Tasmania and the ACT. Once again, we're talking about not just discrimination on the basis of religious belief itself, but as the Attorney General's office last year confirmed via public comment to the media, it could be an alternative means to discriminate on the basis of religious belief around sexual orientation and gender identity, even if it's not about sexual orientation or gender identity per se.
Okay, thank you. I've got one last question, which if we could just get a quick response, but you might like to take on notice as a more expansive response. And yesterday we heard evidence from some Buddhists and Hindus about the level of discrimination they already face and their fears about that increasing, being legalised under the statement of belief and in employment. And I'm presuming that some people heard their evidence, so perhaps those who heard their evidence to respond. It's fair to say that, there was a bit of chatter around that, I think their concerns are overblown, they misunderstand the legislation. Could you comment on how accurate their concerns were?
I'm happy to start, although my colleague might...
and noting that we have run out of time, so yeah, really quickly.
Give us your best 15 seconds.
We support those comments by those groups, in particular noting that the religious exceptions in 7.2 and other sections are drafted in such an extremely broad way that discrimination against employees from minority faiths and who are atheists could be allowed in a really broad range of circumstances.
Anybody else like to just give a quick response?
Very quickly, I would endorse that view. It's clear that not just 12, but all of Part 2 potentially have that effect.
Thank you. Thanks, Chair.
Thank you very much, Senator Rice. Thank you very much to our witnesses, the Public Interest Advocacy Centre and the Australian Discrimination Law Experts Group for your commitment to our inquiry and your time in giving evidence today.
Thank you, Chair.
We will now move to Just Equal Australia and Equality Australia, and I welcome representatives from those groups. Thank you so much for taking time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 28 and 29 respectively. Please indicate whether you wish to make any corrections to your submission. And for the Hansard record, could you please each state your full name and the capacity in which you appear today? Can I start with Just Equal Australia, please?
Good morning, this is Brian Gregg. I'm the West Australian representative of Just Equal Australia.
Thank you, Mr. Gregg. Mr. Croom, we're not hearing you. If you could just check that you're not on mute.
Sorry, you'd think I'd realise by now. Thanks, Senator. Rodney Croom, the national spokesperson for Just Equal Australia.
Thanks, Mr. Croom. And to Equality Australia?
Hassan Kassassia, Legal Director at Equality Australia. And we have two individuals appearing with us as well. I'm sure they can introduce themselves.
I'm Pastor Karen Pack, appearing in a personal capacity.
And I'm Nathan Zampronio, also appearing in a personal capacity. Thank you.
Thank you all so much. We will. Could I ask you to make each to make a 1 minute statement if you wish, which you will need to keep to 1 minute, please. Do you have an opening statement, Just Equal Australia?
Thank you, yes. We've been told that the Religious Discrimination Bill simply protects people of faith from discrimination, but it doesn't. It allows increased discrimination in the name of faith against a range of groups, including LGBTIQ+ people. For example, the bill will override laws preventing bullying against LGBTIQ+ people, allow and encourage discrimination against LGBTIQ+ staff in faith-based schools and other services, and give the green light to anti-LGBTIQ+ conduct from members of professional bodies, government contractors and street preachers, but that's only the start. This bill is an attempt to roll back the achievement of marriage equality by those who never accepted the yes vote. It gives special legal privileges to people who already have immense privilege so they can demean and discriminate against some of the most marginalised people in the community. It says an archbishop should be able to say things other people aren't allowed, and that his umbrage at being held accountable matters more than the legal rights of people with disability. The bill entrenches a double standard of one rule for religious people and one rule for everyone else.
Thank you. We will need to leave it there. Thank you so much for your statement. Now to Equality Australia.
Thank you, Chair. I would just like to begin by saying our position is our laws should protect all of us equally, and in its current form, the bill winds back protections, LGBTIQ plus people and others, and contains unprecedented provisions that undermine inclusive workplaces, education and service settings. And over 6,000 of our supporters have also signed the People's Submission to that effect, and we're proud to submit it on their behalf. As Legal Director, I'm very happy to answer questions about our position, and have personal experience in discrimination law and policy, teach in public law and practiced as a commercial litigator for many years before joining Equality Australia. But we think that the bill's also failed to address a long-standing injustice, which has allowed LGBTQ teachers, students and staff to experience discrimination in religious educational institutions simply because of who they are or whom they love. And that's why I'm joined today by two individuals who we've yielded some of our time to, so you can hear direct experience.
Thank you so much. I apologise, but we do need to stick strictly to 1 minute opening statements. I will now go to questions, and I give the call first to Senator Scarr.
Thank you very much. And look, I was going to ask some questions about some particular matters. I can put them on notice. If I could ask, as a matter of courtesy, the two witnesses who have just been referred to today, who have appeared to tell their story, if I could ask each of you if you could give your personal experiences with respect to these matters and your perspective.
You first, Karen.
Sure. Well, my name's Karen Pack, and I'm here because I was a lecturer at a Christian Bible college here in Sydney, one of the major theological colleges in Sydney. I was employed in 2017 because I was asked to write some subjects for new postgraduate programs, and then I was asked to become a lecturer in those subjects. When I signed my contracts, I was very sure to make sure that I wasn't signing anything that I couldn't sign with integrity as a gay Christian woman. And I was offered a permanent contract 6 months later in the middle of 2018. In the aftermath of the marriage equality debate and the introduction of marriage equality legislation, the college introduced a clarified community code or community covenant that made clearer that the college's stance on same-sex relationships. And so shortly after that, when I was asked to sign another contract for another permanent role at the college, I specified to the leadership of the college, the person with whom I was signing the contract, that I am gay, that I am in a relationship. And that was, the person responded to me, "That's no problem for me. How do you feel about the community code?" Now, I explained that I accept that, the Bible teaches that marriage is between a man and a woman, and that I think that's a beautiful and a sacred thing, but that is not the limits of what I believe as a Christian, and that I believe in marriage equality. At the end of 2019, I became engaged to my same-sex partner, and the college and myself started to receive phone calls and emails denouncing me as demonic, my relationship as demonic. And so in March of 2020, I was called into meetings with the principal, where I was asked what my response to that would be. I said, "Nothing has changed for me. What's your response given the harassment that I'm experiencing?" 2 weeks later, I was informed that I no longer had a job at the college, that on the 8th of April 2020 would be my last day lecturing, and the next day a letter was sent out to all staff at the college informing them that the principal, with the support of the board, had determined that I could no longer work at the college because of my same-sex relationship with Bronte. And that document also praised the depth of my Christian faith and my excellence as a teacher and my impact on the college. So it was very clear that the problem wasn't my teaching, my theology, or my character. It was purely because I'm gay and was getting married to my partner Bronte.
Ms. Pack, can I ask you, from your perspective, one of the recommendations coming out of the Ruddock review, and the principles are reflected in the bill, there's this concept that if a religious institution, a school or a college is to have a policy which would have an impact on particular people, well, that policy should be made public. It should be made up front so that people such as yourself, and I was interested in your evidence that you considered the whatever the documents were prior to taking employment with the college to make sure you could sincerely and with integrity agree to those comments. Do you think there's, if the situation had changed such that there was a clear articulation as to what the beliefs and expectations were before you were employed, as opposed to you being employed sincerely believing you met the beliefs, but then subsequently finding that the ground had shifted under your feet? Do you think there's a difference in that situation from your perspective, and how we should consider that as legislators?
Yeah, I think the challenge to that is the reason why religious institutions such as the one that employed me are seeking to have those public statements. And in fact, in October of 2018, when I was working at the college, the principal circulated an email to all the staff explaining that because of marriage equality legislation, the college had taken legal advice to ensure that they would be able to continue to discriminate against LGBTIQ plus students, and that was the specific reason for the publication of the community code. I think what's often misunderstood in this debate, and a mistruth that I often hear spoken, is people who say, "You're gay, why are you trying to work at a Christian institution?" As if LGBTIQ plus people are trying to insinuate ourselves in community. That's not the case. I'm a person of faith. I've been an ordained minister for 12 years. My parents were ordained ministers for over 50 years. My wife, Bronte, her parents are ordained ministers. Like, I have a sincerely held Christian faith. I'm not trying to insinuate myself into anything. I am within my community of faith as a gay woman. But what is happening at the moment with this legislation and others is an attempt essentially to purge the church of people like myself.
Senator Scarr, I'm sorry to cut in here, but we are running to a very tight time frame. Are you able to put your other questions on notice?
No, I am, but thank you for joining us, Ms. Pack.
I'll now give the call to Senator Bragg.
Thanks, Chair. I just wanted to thank you very much for making your time available today. Are we able to hear from Councillor Zamprogno?
Yes, thank you, Senator, and thank you, members of the committee. I'm here this morning to testify that Christian schools can and do sack teachers because of their sexuality. I was one. Karen and I represent just two examples of very many of this phenomenon. I have to say I don't relish being here because what I need to relate is a source of trauma for me. But the goading of friends and the pricking of my conscience means that I can't not speak out. I worked in a variety of private Christian K-12 schools in the Sydney area for 20 years. They tended to be non-denominational Protestant schools who share a banner like Christian Schools Australia, and I note that you took testimony from Mark Spencer from that peak body yesterday. Schools that are typical of thousands of such schools across Australia. Now, I have to tell you that over the years I have seen other staff sacked because of their sexuality. In my own case, at the school that I worked at, the headmaster would casually say in a staff meeting, "Oh, well, I wouldn't employ a gay teacher." And I would shrink into the corner and a part of me would die inside. The chief PDHPE teacher would say, in the context of teaching on these significant mental health issues, that sexual preference was a choice and you could choose yourself into it and you could choose yourself out of it. The board president of the school pamphleted the entire staff and parent community with unkind articles at the peak of the debate about same-sex marriage, and made it clear not only that the school's position was that marriage should only be between a man and a woman, but that there was little latitude for others to hold a different view, even as a private matter. Now, I've seen firsthand the significant effects on mental health that these issues bring to students. It's significant that at the school that I taught at, 2/3 of the school body, the student body, came from unchurched families, people who were not part of the religious community, but were simply sending their kids to a good local private school, and that 71% of their funding came from government sources. In my case, when I was challenged about my sexuality, I answered honestly, and then I was told that there was no place for me at the school in the following year. The connection was crystal clear. The testimony that you have received from others that this is not the case is simply not true. I was well regarded in that community amongst my students and my peers, and I was good at what I did. I never dishonoured my employer, and I regarded my private life as just that. My sexuality had nothing to do with my ability to do my job. As a member of the Liberal Party for nearly 30 years, I implore you either to abandon this bill or at least to fix the egregious loopholes that are going to permit discrimination against people like Karen and myself. Thank you.
Thank you, Councillor. Can I thank you both for presenting your difficult personal stories today. I just wanted to, for the avoidance of doubt and conscious of time, just get on the record whether or not in both of your cases you ever taught against the theology or ethos of the school.
I'll fill that, and the answer is clearly no. You know, my ability to teach technology, which was my key subject area, that and English, had nothing to do with my own views. I was not a flag waver. I am a member of the Liberal Party and an elected local government representative. I think of myself as an upright citizen in my community. I never did anything to dishonour my employer, and yet this was grounds to exclude me from a sector that I'd worked in for 20 years. Karen?
No, very much not. In fact, knowing that I am a gay woman, my faculty asked me to teach a core subject in biblical and theological foundations and ethics for counsellors and spiritual carers. So I was actually asked to teach theology and ethics because of my integrity and my faith. And I never undermined the college's position at all, even when I was asked directly about same-sex relationships and LGBTIQ issues. I explained the position of the college and that there's a spectrum of opinion within Christianity, but I certainly never undermined the views of the college.
Okay, just final question, that's okay.
Yes.
Thank you. Do you think that there are other teachers who have been in your situation who are unprepared for various understandable reasons to come forward and tell their stories?
Yes, may I respond to that?
Yes.
In the time since I have come out publicly, and particularly since my story was aired somewhat in the media, I've been approached by literally hundreds of teachers and students from Christian schools and Christian religious institutions explaining to me either the trauma that they have faced as gay people who feel, or LGBTIQ people who feel forced to remain closeted in a very don't ask, don't tell environment. They've explained to me the trauma that they've faced psychologically and emotionally, the mental health challenges that they've faced. I've also had many of them, dozens of them, tell me about how they have been excluded from their school communities or fired from their jobs because of their gender identity or sexuality, as well as others who have been dismissed because they got divorced or because they became single parents or for a variety of reasons. So,
Senator, permit me to concur. I agree with Karen that there are very many people, and part of the difficulty is that employers will often obfuscate the reason that they're letting an employee go, even when it is clear that it is because of either their religious conviction or their sexuality. And my most important point is this: the provisions of this bill effectively empower those who want to put pressure on and ultimately purge people of a different religious conviction to themselves within religious communities. And worse, this bill would side in those debates with those who are less ecumenical, less moderate, less compassionate. And I don't think that the Parliament should be weighing in and taking sides in what are, in many cases, doctrinal differences of opinion within faith communities.
and if I can add to that as well, you asked about
yes,
the harm
very
being done.
briefly, Ms. Pack.
Sure. I just want to comment that we know from numerous studies throughout the world that people who are forced to remain closeted or feel that they need to remain closeted within their communities because of a fear of ostracism from their community, that has incredible mental health impacts. That has impacts on high rates of suicidal ideation and homelessness and mental distress. And so to Senator Bragg's question, there are many people that continue to be closeted or hiding parts of themselves that are suffering incredible mental health damage. And I actually think that that should be a great concern of our government and parliament, the ongoing harm that is being done by forcing people to remain closeted because of the harm, the detriment that they experience if they come out. And we should be concerned for the many, many queer young people of faith who are watching things like this play out and know what will happen to them if they are to come out, because they see what's happened to me, to Nathan, to Steph Lance, to David, to Elise, to so many people that I could name. They're watching, they see, and it is doing them harm.
Senator Bragg, thank you very much. I've just got a quick question, Ms Pack, before I hand over to Senator Rice. Ms Pack, I just want to clarify that you were engaged by Morling College as an openly gay woman, so there was no issue with that?
When I was when I was employed by Morling College, they approached me. There was not a question about my sexuality at that time.
But, that was disclosed and known, and there was no issue from the college. I just want to clarify that point.
Sure. It was not asked when I was employed, but in my time at the college, I was out to everyone on my faculty, including my dean, my associate dean, and members of the leadership.
So does the school had no issue with you being an openly gay woman?
The people to whom I reported did not have an issue with it. I think
just based on your evidence, it appears the issue arose when you decided to become engaged and get married under our new laws, of course. So is that the basis on which the trigger occurred, which I assume was in contravention of that school's particular doctrines and tenets in relation to their belief in traditional marriage? I'm not making a judgment one way or the other. I'm just trying to understand on the evidence what was the trigger for your departure from the school.
The particular trigger was an email that the college received from a member of the wider Baptist community saying, "I've just discovered that Karen Pack is a lesbian. That is disgusting and sick. You need to publicly denounce her because she is demonic." As I said, it was known to my friends and family that I was gay, but the trigger was it becoming more widely known in the evangelical community and then being reported to the principal and the board, who I believe had not been aware of that.
So was that before or after you announced your intention to get married? I'm just trying to understand the factual...
That was after I announced my intention to get married.
Okay, thanks, Ms Pack. I just wanted to clarify those matters. Senator Rice.
Thank you. Look, just some broader questions to Equality Australia to begin with. Your submission, thank you very much for your submission and the case studies. There have been a number of other submitters who have said that stuff that you say in your submission is wrong. I presume that you have looked at those claims. I just wanted to give you an opportunity to respond to the criticisms of your submission by some of the other submitters. I think the Institute for Civil Society, the Catholic Education Commission, there are a range of other submitters who have criticised the Equality Australia submission.
Thank you, Senator Rice. I'm a black letter lawyer, so I'm interested in looking at what the law says and how it's going to be construed by the courts in light of its purpose. And what we have done is used current law that we know, cases in ascertaining the words of particular provisions, like the good faith test in section 12, which I think people are treating as having some kind of, miracle cure to what that provision does. Which is to allow things that today would be unlawful, discrimination, to occur when people make a statement of belief. And I'm happy to respond on notice if you prefer around the detailed legal analysis around the good faith provision and that section in particular. There was 2 claims made in a submission attached to the Institute of Civil Society, I think it is, claiming that 2 statements we made and my CEO, Anna Brown, made were incorrect. The first of those statements was made in respect of the second iteration of the Religious Discrimination Bill, not this iteration of the Religious Discrimination Bill. And we actually welcome the removal of conscientious objection clauses that were in that previous draft. And so that statement's inaccurate because it misstates what we've actually said. And the second statement, that the bill would wind back existing protections, is clear on its face because Section 12 and Section, I believe it's 11, that overrides existing protections, does that on its face. So we stand by that statement. We think it is accurate that the bill does wind back protections for LGBTI people, for people with disability, for women, other groups, and including people of faith, because they are currently protected in a range of ways under state and territory laws, noting the exceptions in New South Wales and South Australia. And that's why our position has always been that our laws should protect all of us equally, whether it is you are a person of faith or not. And I mean, you've heard from Nathan and Karen today, and they represent many people who I've had the privilege to speak with over this time. And I'll leave it there. Thanks.
Okay, thank you. Look, just a couple of quick questions to Just Equal. Mr. Gregg, you're based in WA. I'm interested in your experience of discrimination against LGBTIQA plus people in WA faith-based schools. Could you give us some examples of those that explain how this bill is actually going to make things worse?
Thank you, Senator. We have two iconic cases in Western Australia. In 2015, a 7-year-old girl was effectively expelled, pushed out of a Christian school in Mandurah, South Perth, when the principal discovered that she was being raised by 2 gay dads. Then in 2017, during the postal survey on marriage equality, history and English teacher Craig Campbell was sacked from his job at a teaching college, a Baptist college in Rockingham, south of Perth, interestingly in the Premier's electorate. Those things were both able to happen because in Western Australia there is a great gap in our Anti-Discrimination Act, which says that discrimination on the grounds of this kind is permissible. But it has long been the case that the community here has argued for that to end. Public polling, for example, shows that close to 80% of people object to this. And the Premier is personally on record, Premier McGowan, as saying that he believes the law is wrong and that it should change. So there is currently the WA Law Reform Commission is currently doing a report into this and is expected to produce its documentation within the next couple of months. And there's the expectation that the McGowan government, now with comfortable numbers in both the lower and upper house, will reform this law so that this particular discrimination will end. Our great concern is that if the bill in its current form goes ahead, that the opportunity to do that will be extinguished. And I think the more important point to make here is that while this discrimination continues to go on, and everybody seems to say that it's wrong and shouldn't happen, nothing is being done about it.
Thank you. And Mr. Croom, you've said that the Tasmanian Anti-Discrimination Act has sort of got gold standard protections for LGBTIQA plus people, and obviously with the state override, they will be overridden by this bill. Can you talk about what the benefit of those protections and how things are different in Tasmania now and are different, in fact, in Tasmania compared with other states, and the benefits for LGBTIQA plus people and other people in Tasmania? You're on mute, I think, Rodney.
I did it again. Thanks, Senator, for the question and the mute alert. The Tasmanian Anti-Discrimination Act, for the entire duration that it's been in place since 1998, has prohibited discrimination against LGBTIQ plus students and teachers in faith-based schools, as well as other teachers, as we've heard from Karen and others, teachers who are in single or in de facto relationships or single mothers or whatever it might be. There's a range of grounds upon which teachers and students are protected. And those protections have had an immensely positive impact in Tasmanian faith-based schools. Those schools are now demonstrably more inclusive, fairer and safer places than they were before the Anti-Discrimination Act was put in place. I say that not only as an observer of this over many years, but as someone who's seen the research. The University of Tasmania has conducted research interviewing staff in faith-based schools who are LGBTIQ+ in Tasmania and their counterparts in New South Wales. And that work has found that the teachers in Tasmania are more able to be out. They feel more secure in their workplace. They feel that their contribution to the school community is more valued, and they do not have the levels of anxiety and fear that exist in New South Wales, where these laws aren't in place. So for a long time, it's been bewildering for us to see the debate that takes place in other states about whether LGBTIQ+ teachers and staff should be protected from discrimination, because they are in Tasmania. And it's been a wholly positive experience. I watch this issue very closely, and in the last 24 years, I have not once seen a complaint from a school principal or a bishop or any other kind of church authority about Tasmania's laws. To be clear, Tasmania law does allow discrimination on the grounds of religious adherence at first enrolment for students and in terms of staff. But it's very clear in our Act that that must be balanced with equally strong protections when it comes to sexual orientation, gender identity, marital status, disability, and the other grounds I've mentioned. It's a good model. It works well. I simply don't understand why it isn't adopted in other states and nationally. And it is beyond comprehension why the federal government would want to step in and override those very good laws. The only explanation that I and others can come up with is that Tasmania sets too positive a precedent, and the federal government doesn't want that precedent, because it says to the other states, look, it's not an issue as difficult as you think. Follow Tasmania, everyone benefits.
Thank you. Thanks, Chair.
Thank you very much, Senator Rice. Senator Pratt, who's attending remotely.
Thank you very much, Chair. I'll ask some quick questions to Equality Australia. I wanted to ask you about suggestions to amend the bill that have been put forward to address some of the constitutional and other issues. PIAC said they created more problems than they fixed. I'm keen to know Equality Australia's view.
Thanks, Senator Pratt. I'm assuming you're referring to Professor Aroney's two proposed amendments. I would endorse what I heard Mr. Laurie say about the issues that they don't actually resolve the substantive issues that the two clauses have in overriding existing protections. In fact, they try and bake it in. But in so doing, they also have a couple of problems, further problems. One is, for example, on the override of laws that protect people with different religious beliefs in religious institutions. They watered down the written policy proposal so that it's even easier for a religious institution to set and change rules, including for existing employees, as they wish, in a way that they can then enforce against those employees. And in respect of the Statement of Belief Clause provisions, I don't think that they resolve, for example, the Law Council of Australia's broader constitutional questions about whether the External Affairs power would give adequate support for those clauses. And I think there's been an analysis around Article 18 of the International Covenant on Civil and Political Rights, but I don't think that's the only article that's relevant. And I think it might have been Mark Sneddon yesterday who also mentioned other articles, and I would agree with him to this extent that there is a requirement under the ICCPR for states to provide an effective remedy against discrimination, and that is on a range of grounds, including religious beliefs. And so to the extent that that provision preferences one ground over another, I think that I would agree with the Law Council that that's actually not a faithful in implementation of the human rights framework that it's seeking to rely on for its own power.
Thanks, that's very helpful. In the context of qualifying body rules and the ability of corporations to sue, so that's both Section 15 and professional standards and the ability of corporations to sue. You've expressed some concerns about those protections. In your submission, can you give us a run through on that, please?
Yes, so on qualifying bodies, the simple submission is that that section's not necessary and actually confuses the situation. The reason is discrimination law has a twin limb test already of direct and indirect discrimination. So if a qualifying body refused, for example, like say a health body refused the registration or disciplined a doctor for expressing religious views, that could well be direct discrimination in any standard test. It could also be indirect discrimination if they imposed a standard policy that disadvantaged people of faith from expressing their views and applied it in an unreasonable way. And so what we would say is standard legislation already achieves that, and it doesn't have the unusual tests that have been inserted around what an essential requirement is, which will just clog up more time and effort in actually understanding how you respond to it. And in particular...
So the standard test for other discrimination clauses, we've had a lot of discussion about this. The way this bill varies from standard discrimination law, the tenets of what's needed for that profession are already, or to conduct a particular role, are already embedded in an ability to vary those only so far as they might come into conflict with discrimination law, and that's already established. Is that what you're saying?
Correct. So they can't set standards in the first place that discriminate, either directly or indirectly. And I think the problem with this clause, which hasn't been articulated, is often regulatory bodies look at a course of conduct as a whole to assess for the future, has the conduct that this person's engaged in, whether inside or outside the workplace. For example, a lawyer could be assessed as to whether or not they've committed an offence, driving offence, which tells you something about their fitness to practice and enforce and be part of the justice system. So it's very typical for regulatory bodies to look at conduct as a whole to assess whether someone going into the future is going to be able to perform the role that's been entrusted to them by the community. And these roles have special, privileges that come with them, and they also carry particular trust. The problem I have with this provision is one case that we refer to in our submission looked at 30 statements that were made by a doctor outside of work on social media. So does that mean that the regulatory body has to go in respect of every single individual statement and assess, is this an essential requirement? Is this a malicious statement? Is this a harassing statement? In order to look at the broader course of conduct, which questions whether or not that doctor, if a patient entered into their clinic with those characteristics that they criticised outside the clinic, would they be able to receive a health service that was non-judgmental and appropriate to their needs? So that's my concern technically with that provision. On the corporations point, I think we need to distinguish between the ability of a corporation, a religious corporation, to bring an action on its own behalf, and therefore, and indeed in that provision, it's not a religious corporation, it's any corporation in respect of an association with a religious individual, versus a group of individuals who together, a corporation or an organisation, can bring an action on their behalf. So it's a very different thing to say a company can sue another individual for the loss of its revenue, or because discrimination law looks at compensation and reparation, to sue for its loss of, for example, business income or loss of profit, versus saying that an organisation that represents, for example, people with a disability could sue on behalf of the individual members who have that disability as to the pain and suffering that that individual has experienced. And again, it's about human rights for humans. The international framework protects human rights and calls on states to protect humans from discrimination. There are some international examples, domestic examples, where corporations have been able to, for example, under charters of rights, human rights, acts and constitutional protections bring individual claims, but we have rejected that approach in Australia. So if we want to have a discussion about a Charter of Rights, we should have that discussion, not try and kind of put it in around a discrimination law, which is about protecting humans from discrimination and giving them a remedy when they have suffered that conduct.
That's right. And someone
Senator
within a
Pratt, I'm just wondering if you could wrap up your questioning because we are out of time.
Yes, I just wanted to ask very briefly about employers and the onus of provision of onus of proof, please.
Yes, so I would agree with the view that most discrimination law reverses the burden of proof onto the discriminator to show that a particular policy or standard is not reasonable. And I think that would be a fair improvement of the bill that has been asked for. What I would disagree with, though, is the recommendation that there's some sort of reasonable adjustments defence or provision in the bill, because I would say that's already implied in indirect discrimination provisions. And so providing that defence across the whole lot, including in direct discrimination claims, means that effectively you need to give a free pass or more latitude to a person who engages in misconduct based on a religious belief than you would a person without that religious belief. And again, it goes back to our principle. Our law should protect all of us equally. And where we object to are the provisions of this bill that really depart from that kind of orthodox and standard way of dealing with discrimination.
Thank you. That's very helpful, and feel free to put more things on notice in relation to those issues should you wish. Thank you, Chair.
Thank you very much, Senator Pratt. I appreciate everyone's cooperation to move through this program as quickly as possible. I'd like to thank Just Equal Australia and Equality Australia for their evidence this morning and for their commitment to this inquiry. Thank you so much for your time today. I'd now like to welcome representatives of Unions Tasmania, Women's Health Tasmania, Equality Tasmania, Disability Voices Tasmania and the Multicultural Council of Tasmania. Thank you so much for taking the time to give evidence. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received submissions from Unions Tasmania, Women's Health Tasmania, Equality Tasmania and the Multicultural Council of Tasmania as submissions 40, 169, 197 and 38 respectively. The committee has not received a written submission from Disability Voices Tasmania. Please advise whether you wish to make any corrections to your submission. For the Hansard record, would you please each state your full name and the capacity in which you appear today?
I'm Fiona Strawn. I'm presenting Disability Voices Tasmania.
And Ms.
Jessica
Banks?
Munday, Secretary of Unions Tasmania.
Sorry, is Ms Banks from Disability Voices Tasmania there? No.
Sorry, yes, I am. Yes, I'm an advisor to Disability Voices
All right.
Tasmania.
Thank you. Thank you very much, Ms Banks. Apologies to Unions Tasmania. Could you just announce your name again?
Certainly. Jessica Munday, Secretary of Unions Tasmania, and
Dino Otavi, Organiser for the Independent Education Union Victoria Tasmania branch and affiliate to Women's Health.
Thank you to Women's Health Tasmania.
I'm Jo Flanagan, CEO of Women's Health Tasmania.
Equality Tasmania.
Rodney Croom, President of Equality Tasmania.
And Multicultural Council of Tasmania.
Data Mahambre, Chair, Multicultural Council of Tasmania.
Thank you so much. I invite each of you to make a 1 minute opening statement. If you could please keep your statement to 1 minute strictly, that would be very much appreciated. And we'll start with Unions Tasmania.
Actually, it's Fiona Strawn here. We have only two 1 minute statements. I'm going to go first, speaking on behalf of us all.
Fantastic. Thanks, Ms Strawn.
Thank you for the opportunity to for our team to appear before the committee. We requested a specific hearing for Tasmania because Tasmania's Anti-Discrimination Act is the best in Australia. Existing protections in Australia, in Tasmania, will suffer more under the proposed religious discrimination bill more than any other state. We have the most to lose. We all support protection from discrimination for people of faith. Indeed, Tasmania's faith protections are some of the strongest in the nation. But we draw the line at allowing discrimination in the name of faith. Behind us stand not only the communities we represent, but all three Tasmanian political parties, including the Tasmanian Liberal Government. Organisations as diverse as the Tasmanian Council for Social Services, the Tasmanian Chamber of Commerce and Industry, and a range...
I'm sorry to interrupt you, but we are going to stick strictly to 1 minute. Could I invite the other 1 minute statement to be given now, please?
Senator, thank you. I'll read the second statement. The Tasmanian Anti-Discrimination Act has fostered a more inclusive Tasmania. It was enacted immediately after the divisive campaign to decriminalise homosexuality succeeded in 1997. It is our collective attempt to forge a new Tasmania. The Religious Discrimination Bill will override our Gold Standard Act at several points, including Section 17, which prohibits humiliating and other bullying behaviour. Section 17 has created immense good by resolving many cases involving demeaning conduct, sometimes in the name of religion, against many of the people we represent here today. Section 17 has been found by our Supreme Court not to burden freedom of speech or religion. Unfortunately, many untruths are told about the case involving Archbishop Porteous to discredit Section 17. Our protections, as we've already heard this morning, as I've said already, for teachers in faith-based schools are also under threat. They've been in place for 24 years without any problems. They affect many staff in faith-based schools who have worked well and contributed importantly to their communities. We can't see why the federal...
To interrupt you, but we have to leave the 1 minute statement there, but obviously we've got substantial time for you to add to the comments that you've already made. I now invite questions, and first of all, we will kick off with Senator Louise Pratt.
Thank you very much, Chair. Can I commence by asking, please, what evidence have you heard that you would like to respond to, either in the last day or from the previous hearing in the other committee?
Can I begin from the perspective of people with disability? I heard yesterday a suggestion or a concern that comments about taxi drivers of particular religious faith, that they wouldn't make the kind of comments about guide dogs being dirty and various other things. Having been an anti-discrimination commissioner, I have received multiple complaints of that sort of conduct. And I suspect because of the very short timeframes for these inquiries, Blind Citizens Australia haven't made a submission, but they would be able to give dozens of examples of the religious views that are held around dogs and how those are then expressed to people in their daily lives when they rely on a guide dog. So that was the first thing. The second is that I heard quite strong reliance on some statistical evidence that was attached to the Australian Catholic Bishops Conference. There were two references, footnote 4 and 6, to their submission. I've read both of those materials now, and I don't think that they actually demonstrate what was asserted in evidence. So particularly the key findings on page 2 of the LSAC report and the discussion on page 5, I think really show quite a different picture of who is most likely to be discriminated against in terms of young people in Australia. So those are the two pieces that I noted yesterday that I think need further interrogation.
Others?
I mentioned in my opening statement Archbishop Porteous. There have been regular claims made in this hearing and in the public square that Archbishop Porteous was dragged before a kangaroo court to answer for his Catholic doctrine on marriage. And none of that is true. The complaint against a booklet that the Archbishop distributed called Don't Mess with Marriage from Ms. Martine Delaney was specifically in regards to two statements within that booklet. One that suggested that same-sex partners aren't whole people, and another one which suggested that same-sex marriages mess with kids. And also, I think, about the fact that some of this was presented as fact rather than doctrine. And Ms. Delaney said at the time that her goal was to try and create a more mature debate around marriage equality without these kinds of claims being made, and it was certainly not to stop the Archbishop from stating his view on Catholic doctrine. The two parties attended a 1-hour voluntary mediation. The Archbishop didn't wish to change any of the wording of the document, and so the complaint was withdrawn. It was, as I said, never about Catholic doctrine on marriage. It was about very demeaning statements about same-sex partners. And the booklet continues to be distributed today, so there was effectively no cancelling, censorship or silencing of anyone. That case has been blown out of all proportion as a way to justify undermining Section 17. Very little attention is paid to the very positive outcomes in many cases from Section 17, including one that I'm familiar with, a case taken by Timms, a senior civil public servant in Tasmania, against a very anti-gay pamphlet, which was resolved in the tribunal, and that pamphlet is no longer distributed. If the override that we see in the Religious Discrimination Bill went ahead, then Mr. Williams would not be able to take a case against that pamphlet because it was justified in the mind of the person who distributed it on the grounds of religion. That's a very clear case of where very homophobic material would continue to be distributed if this override went ahead, whereas at the moment, the Tasmanian law makes it clear that that's not the kind of thing that Tasmanians want to see in their letterboxes.
Can I ask, would that pamphlet that was drawn have met vilification?
Sorry,
standards?
Senator Pratt. Senator Pratt,
override,
apologies. I know it's difficult when you're attending remotely. Senator O'Neill just has a sorry.
Thank you.
Senator O'Neill. Senator O'Neill has a quick question of clarification. Senator O'Neill, you have the call.
Mr. Croom, the case to which you referred, was that an anti-discrimination case or an anti-vilification case?
The Porteous case?
No, the second one, the Williams case.
That was under Section 19, which is incitement to hatred, and Section 17, which is the section under discussion.
Okay, so just for me to be understanding clearly, was that a vilification case or an anti-discrimination case?
Well, it was both, because it was under both sections.
Okay, thank you. That's a clear answer. I appreciate that. Thank you, Senator Pratt.
Okay, if you want to give us some further technical advice, this bill overrides Section 17, but not Section 19. I think it's a fairly moot point, but if you take it out of the state tribunal only to give it back to the Commonwealth anyway, it seems fairly pointless when the effective point was to bring people together within that state tribunal. And I wonder if other submitters might comment on that as well as Mr. Croom. Ms. Banks? Sorry.
Certainly happy to comment that, yes, the effect potentially of overriding overriding state law is to push it into the federal jurisdiction, which is a costs jurisdiction, and many people quite deliberately avoid it because they cannot afford the legal expenses of securing their own legal representation, let alone the risks of a costs order against them under the federal court structure. So yes, it has that effect in almost all states and territories. And that is a very serious access to justice issue. As Mr. Croom indicated, a very significant number of people have used state law, and I think in the previous one of the previous hearings, it was state and territory law was described as the engine room of discrimination law, and that's a very accurate representation. The vast majority of claims rely on state and territory laws because they are local. The administration is local. The process has been, apart from under COVID, face-to-face, where people can actually sit down and have civilised and respectful conversation about their different perspectives on a particular issue. And that is a really powerful process, and it's a process that has been picked up by our courts in other areas of law. So it's very rare to get to court in any sort of law now, apart from criminal law, without some sort of mediation process. And that came out of discrimination law. So we're effectively forcing this into a much more litigious process if we override state and territory laws.
Thank you. Can I ask Disability Voices and the Women's Organisation and Unions Tasmania what they have heard that they would like to respond to in the course of the inquiry so far? Disability Voices first, perhaps.
I think what we'd like to respond to firstly is that I'd just like to let the chair know that we have submitted a submission, and could we resubmit, please, if it's been lost. I think the most important thing that we've heard is how our little disability has a voice in this process. That we in the previous committee were the only people with disability who were able to present, and today you have a person from People with Disability Australia. And as 26% of the Tasmanian population and 20% of the national population, it's really devastating that we have not either had the time or the accessibility to submit, but also to have our voices heard. And I think particularly one of the things is to understand, and People with Disabilities Australia put this in their submission, is that the religious model of disability is the oldest model, and of interpreting our differences and our status and our value. And the way that we work now is through the model of disability, which is about, it's actually society's response to our difference that makes our impairment a disability. And I think that that's, most people get that in the community. The risk of this bill is that it takes us back to, and it gives us a particular group the opportunity to give statements of belief that may not be relevant and are also hurtful and discriminatory.
So can you, specifically in that context, what happens when a taxi driver has a licence to say dogs are dirty and disgusting, I don't want it in my car, but still has an obligation under the Disability Discrimination Act to carry a passenger who needs a guide dog? I don't quite, it's almost like, yes, I have to let you into my taxi, but I've got licence to bombard you with my belief the whole time that my passenger.
Presumably that's part of the organisation's responsibilities, in the same way that they would have work health and safety responsibilities, then they have responsibilities under the Disability Discrimination Act. And it's an organisational responsibility. The purpose of, a taxi or an Uber is to transport a person safely from A to B. And if they have a walking stick or a wheelchair or a guide dog, it doesn't matter. The point is that it's about safety. I think people forget that, that the focus is on the service. And I think that's enough.
May I ask Unions WA Unions Tasmania and the Tasmanian Women's Organisation, I think
Senator Pratt, regrettably, we are close to time, so if we could just keep these responses as brief as we possibly can. Thank you.
Certainly. Thank you, Senator. Look, it's I would just reflect on, we came in a little bit there on the previous evidence. I just wanted to reflect on the mental health impacts of discrimination and work. We share concerns about workers who experience discrimination on any level, on a religious basis, of what this could open up, given we consider that our laws, look, no law eliminates discrimination at all. It occurs in Tasmania, but we think our laws contribute to it occurring less. And we'd like to note that, discrimination is deeply traumatic when it occurs anywhere, but we hold specific concerns that overriding our laws and introducing statements of belief that may be made in workplaces could deeply traumatise workers, could lead to additional sick leave, additional workers' compensation claims for mental illness and injury, and that would create discord in workplaces that we desperately don't need. So I think, Dino, you just wanted to reflect on what it is like working and what you heard from religious teachers in our schools.
And basically, really quickly, so given that my work takes me to Catholic and independent schools and other religious schools, so there are actual live cases now that I'm dealing with where, for example, a person unmarried gets a promotion and the religious organisation that is linked to the religious school that the person is in rescinds that promotion that the person has received because the person is unmarried. Now, the person happens to be quite religious, very involved in the religious community, not that it particularly matters, but happens to be heterosexual with a loving partner, etc. But that's a live case. So if changes are made, then this person has no recourse to have the matter heard under Tasmania Anti-Discrimination Act 1998. Thank you.
Senator Pratt, you've completed your questions?
Yes, but I note that the women's organisation, Women's Health Tasmania, hasn't spoken at all yet.
All right, well, hopefully we will be able to ask Women's Health Tasmania some questions from other senators. I'll now give the call to Senator Bragg.
Thanks very much, Chair. There has been a lot of discussion about this statement of belief over the past day and a half. One of the main reasons, or perhaps the only reason it's been put forward, has been this particular Porteous case. So just for the record, I just found it a bit hard to follow before exactly. So what was the outcome of that case? And the second question is, and these are my only two questions, is can you give some practical examples about how the existing protection for religious belief or affiliation has worked in Tasmania under the state law, please?
I'll ask Robin to address the outcome of the case, but just in terms of that last point, Senator, you're talking about faith-based schools and their religious exemption.
No, I think he was asking about the protection that exists for people of religion in Tasmania.
Yes.
Oh, okay, sorry.
Yes.
Robin?
So in terms of the outcome of that case, the complaint was withdrawn. Ms Delaney has written about this, and it's actually an attachment to Equality Tasmania's submission. I think it's attachment D. She sets out her reasons for making the complaint in the first place, but also her reasons to withdraw. And she indicated it was because she felt that there would be no shift in attitude from the Australian Catholic Bishops' Conference or from Archbishop Porteous. So the complaint was withdrawn, no changes were made to the booklet, and the only, Mr Cromer's already addressed the changes that were actually requested. It was very clear, and this has been on the public record for some time, that Ms Delaney stated publicly that she believed in the Catholic Church's right to express doctrinal views of marriage, but what was concerning about the booklet was there were those statements that have been referred to that were asserted to be fact, not doctrine, but fact. And that was her concern, and that it was being sent home to families in children's school bags, children of a diverse range of parents, and it spread a view about same-sex relationships that was demeaning and derogatory, but the complaint was withdrawn. So there was no determination. I was the commissioner at the time. People have criticised my decision to accept the complaint, but that is my role, to determine whether or not a complaint discloses the potential of unlawful conduct. I cannot determine whether a defence is available, And that is very clear that that is a role for a quasi-judicial body in Tasmania. It is the Anti-Discrimination Tribunal's job. And so, yes, sometimes complaints proceed to a hearing where there is a defence that needs to be tested. Just as in criminal law, defences get tested before the courts. And in civil claims, defences get tested before the courts. It is not the role of an administrative decision maker, i.e. the Commissioner, to determine questions of fact and law.
Okay, that's a good answer. And then I just wanted to understand or get the second answer, which was, can you give some examples about how religious activity and belief is protected today in the state of Tasmania under the Anti-Discrimination Act of 1998, please?
Yeah, so the Anti-Discrimination Act has since 1998 protected discrimination on the basis of religious belief, affiliation and activity. People of religion can make discrimination complaints and do if they believe that conduct has been directed to them based on their religious belief, activity or affiliation. And I'm reminded of a case where a young man was extremely upset by a music poster that showed an image of the Virgin Mary and Jesus, but they were replaced by apes. Now, he quite understandably felt that that was an offensive reflection on his his very deeply held religious beliefs. That complaint was referred to the tribunal by me as the Commissioner, because I agreed that, you know, that's an unnecessary way to express your views about religion. And I think that, you know, the band was probably trying to be funny or something, but funny can be offensive and humiliating and ridiculing and discriminatory. And so that complaint went to the tribunal. My recollection is he withdrew his complaint, but I can't swear. I certainly know there wasn't a decision, so it may have been conciliated at the tribunal stage, which can also happen. But yes, so people can complain if somebody treats them less favourably in employment, for example, because of their religion. If there's a hostility to religion in their work environment, they can make a complaint under indirect discrimination. They can also make a complaint under Section 19, which is the vilification provision. If a public statement is made that vilifies people of religion or because of their activities.
Okay. Well, can I just ask that you take on notice, please, any other examples that might come to mind where people have been able to access the tribunal in order to have their religious belief protected under the state laws of Tasmania? That would be very helpful.
Thank you very much, Senator Bragg. I'll now give the call to Senator Scarr.
Thank you, Chair. Ms Banks, I want to deal with this issue of assistance dogs, guide dogs. So I'm the one who made the comment yesterday, and the reason I made the comment, I'm very close to the Muslim community in Queensland. The Muslim community has been the subject of Islamophobia, vile graffiti attacks, and I'm very conscious of the need in this debate that examples, in my view, should not be used which stereotype particular religions. And that is my sincerely heartfelt view. So when that example is given with respect to the unclean dog, right, my sincerely held concern is that people will hear that and then draw general stereotypical views with respect to the wider Muslim community. So that is why I made the comment I made. So I would like to give you an opportunity, given that you've your extensive involvement, perhaps, to give your understanding with respect to the great positive work that our Muslim community has done, both in Australia and in the UK and in other jurisdictions, to reconcile what their holy book and holy teaching says, but also with respect to the great work organisations like Guide Dogs of Australia does, etc., to make sure our disabled have all the assistance they need to have the most enriched and positive life experience they can.
Thank you, Senator Scarr, and you're absolutely right that examples that show a particularly egregious view of guide dogs or anything else can be used to stereotype the whole group. And I agree that, and I've seen some fantastic work in Australia and elsewhere by leaders in the Muslim community to try and reverse the views held by some of the members of the Muslim community, including taxi drivers, that they can't carry guide dogs. And there's been some wonderful programs, and I think that's really important. I guess the problem is that Clause 12 and the definition of a statement of belief in Section 5 allow the individual's view to dominate. And, their imam can, until the end of recorded time, say, well, that's no longer the doctrinal view of Islam, but the person can say, but it is my religious view based in my understanding of the Quran. So I agree with you entirely. But the problem is that, and we don't want any religious groups to be stereotyped, because that's the basis of discrimination. That's where discrimination comes from. It doesn't discount the fact that these things happen, and we have to be able to give you those examples to explain why we're so concerned about Clause 12, because it's not about the doctrine of the church. It's about individual personal views about what is doctrinal.
And Ms Banks, I understand and appreciate that perspective, and I genuinely do, that we can't have this debate without examples being given. But I just wanted to get that on the record.
Thank you.
In relation to the example, the concern you legitimately raise, isn't it possibly an answer to that for me to say to you, in that context of taxis, where the law is quite clear that assistance dogs of all nature must be permitted within taxis, and that codes of conduct apply with respect to treating passengers with respect, that I could put the proposition to you that such a statement made to a passenger would not be a statement that was made in good faith in that context, so would fall at that hurdle of the proposed Clause 12, or secondly, that it was, in that context, would be threatening to a very disadvantaged person in that context, where they're seeking a personal assistance in terms of the taxi, and this statement's made to them, which is grossly inappropriate, and that there are other protections in terms of the proposed clause that would deal with the situation?
I think it would be very difficult to demonstrate that a person of particular faiths who made a statement like that wasn't making it in good faith. Good faith is a very difficult test. But also, I mean, the other things, yes, there are codes of conduct. And in fact, taxi drivers in Tasmania have been prosecuted not under discrimination law, because it's not a prosecutorial process, but by the regulator, the transport regulator, for refusing service. The example we're talking about is not a refusal of service, but it's the expression of views whilst delivering the service. And would it meet the bar that is set out in 12, is it 3, that it was intimidating, harassing? I don't know. And that's the problem here, is we have a whole new test that would have to go to a tribunal. And it is also not clear, and I think we've made this point in our submissions, or some of us have, that it's not clear who has to show that it was malicious, intimidating, harassing or otherwise. The normal course of events would be that it would be for the complainant who'd experienced that statement of belief to demonstrate those things. And malicious doesn't exist in discrimination law, so we'd have to look to criminal law and other areas of law. It's not a helpful test.
And Ms Banks, good faith, and this is an issue that's arisen on some of my scrutiny committees' delegated legislation. Good faith itself is a complicated term in terms of interpreting what it actually means. Is that a fair comment?
Yes, absolutely. Absolutely fair comment.
Mr Krim, I don't have much time, and I think the discussion around the Pullman's case and getting on the record the actual facts.
Only about 30 seconds, Senator Scarr.
Mr Krim, looking at what was said in that document, Don't Mess With Marriage, do you think that Tasmanian law, or any law, should enable a tribunal or the government to make an order that the Catholic Church must change that document, must amend that document, must stop distributing that document?
That's a good question, Senator. Absolutely. Imagine if that document, so let's be clear here, the complaint was not about Catholic doctrine on marriage. And I, like Martine Delaney and others, believe that the Catholic Church should be free to say what its views on marriage are. Absolutely free. That freedom is crucial to a democratic society. However, when that is accompanied by derogatory remarks about same-sex partnerships to the extent that we're not fully human and that we're a threat to children, which is what the suggestions were, then yes, I believe that should be actionable. Imagine if that was said about Asian Australians or any other group in our society. There would be an outcry, and justifiably so.
So just to be clear, Mr. Croom, so you believe that document, that particular document in the Porteous case, because the Porteous case has particular significance, obviously, that the tribunal, or whatever the relevant decision-making authority in Tasmania, should have had the ability, if the case had gone further, which it didn't, to actually order that the Catholic Church stop either A, distributing the document, or B, only distribute the document if it were particularly amended?
I can't prejudge what the tribunal should decide. My comment is in regards to it being something that should be, that a complaint should be able to be taken about, as it is under Tasmanian law at the moment. Because those statements are so derogatory, they are clearly humiliating, insulting, intimidating. They clearly, in my view, meet the bar of Section 17. And it should be possible for mediation to take place and for action to be taken that goes, if there's no agreement, to the tribunal. Whether the tribunal finds that those statements, violate Section 17 is up to the tribunal. If the tribunal does decide that, then in this case, it would have meant very small amendments to the document.
Senator Scarr, we are going to have to finish up here. I'm sorry
Okay.
that I'm cracking the whip.
Can I make a quick comment on behalf of Multicultural Council?
Just a 30-second quick comment, please.
Sure. Thanks, Senator. I share your concern about and your support for the Muslim community of Australia. I would also like to put on record here there's been a submission made by the Shia community group, which MCOT, my organization, represents, against taking away the rights of the Tasmanian Muslim community and make sure that the Section 17 of the Anti-Discrimination Bill of Tasmania remains intact. So once again, just like to echo our concerns from various religious groups that MCOT represents, to make sure that we maintain and protect their rights. And I acknowledge that this bill, in fact, actually protects not just all the other impacted community members, but also religious individuals as well and their beliefs. So that's my only comment. Thank you.
Thank you so much. Thank you, Senator Scarr. And I'll now give the call to Senator Rice.
Okay, and in the interest of time, I will be very quick because I really am keen to hear from Ms Flanagan in terms of the impacts on women, having not heard much in this panel from Ms Flanagan so far. And so in terms of what impacts this bill will have on women, particularly women's access to health services, and noting, can you expand on the fact that you're still concerned about this bill, even though the conscientious objection clause has been removed from previous drafts?
Thank you. I guess I'd like to start with Section 17 because the third largest category complaints under Section 17 are women complaining about discrimination on the basis of gender, and that proportion increases if you include the number of women making complaints on the basis of pregnancy or breastfeeding. And just to remind people that this is not people grumbling about their lives, they're making complaints about things that have happened in the areas of employment or the provision of goods and services or their attempts to get access to accommodation. So Tasmanian women have more to lose than women in other parts of Australia because they lose the protection of Section 17 as well as the protections provided by the Sex Discrimination Act, both of which are overridden by this Act. And the reason women are particularly concerned about this bill is because many religious traditions have really entrenched views about women's roles, about their sexuality, about the important role of marriage and motherhood, and a theological belief that women are under men's authority. So the kinds of things that the statement of belief provisions would give licence to are posters in client service delivery areas that make statements about, people who have sex with people who aren't their first husbands, fornicators or adulterers. A community service provider might tell a woman who's had an abortion that she's a murderer or that she's committed a sin. I mean, these are not only distressing with important impacts on people's mental health, they're also barriers to people getting access to services. So you rightly mentioned sexual and reproductive health services, because this has been such a contested area of service delivery in Australia, and it's still one that we're having to work to ensure equitable and safe access for women across Australia. If this bill were to go through, it will give licence to the kinds of views that shame women who are trying to access these services, and it will also give licence to the view that they're not important and they don't need to be provided.
Thank you. In terms of those discrimination cases brought under Section 17, how many of them do you think could potentially be overridden? Because the override is only going to be, not only, but for overriding statements of belief, and so with those sort of faith elements to it. Would that be, what proportion of those Section 17 cases do you think potentially could be linked to religious views? The
Anti-Discrimination Commission's annual report doesn't give that breakdown, but I think it would be fair to say that traditionally held religious views underpin a lot of the gender-based discrimination that people experience. And I guess I'd like to add too that, the government is doing really important work trying to address the massive problem that we have with family violence in this community, and it's doing a lot to try and tackle the underlying attitudes that support bullying and harassment and gender discrimination. So to introduce a law that enables offensive, humiliating, insulting, ridiculing behaviour, it seems just so counterproductive. I can't understand what the thinking is.
Thank you. And look,
Sorry, Senator Rice, can I just interject quickly on a point of clarification? In relation to the statement that you've just made, you appreciate that any such statement of belief must be made in good faith. So doesn't that give you some comfort in relation to the restrictions as proposed in the bill?
It seems so blurry about what good faith is. Who defines what is good faith?
Well, ultimately it will be a matter for the courts to define that. So as so often happens when legislation is tested before a court. But doesn't that give you a lot of comfort?
No comfort at all, Senator.
Right.
If I'm a Tasmanian woman living in rural Tasmania and I have to take a case to the courts in Canberra, how do I fight this?
Well, I'm not suggesting that you would, but as with so many other pieces of legislation, the interpretation of the legislation is often determined by the courts. That's our system of law in this country. Yeah, absolutely, Senator Rice.
We heard the evidence from PIAC and ADLEG that that's going to have us tied up in the courts with massive cost and have a massive impact on people. Look, I've got a similar question to Ms Strawn in terms of the disability cases, which, as I understand it, are also a very substantial proportion of the cases in Tasmania under Section 17. So I'm interested, I don't think there's a good understanding of sort of what sort of discrimination people with disabilities do face on a day-to-day basis. So just sharing a bit more about that. And again, how many of those do you think could have that sort of faith statement of belief overtone potentially attached to them, so that in fact those statements would then be acceptable because of the Section 17 override?
I mean, some of the examples are predominantly in work and education. And so the one that I shared last Friday was a Tasmanian teacher in a staff room, and a relief teacher approached her and said that the reason she was in the wheelchair was that she had something to learn in this life. And then the other one is a child, a young girl at school being told by her another playmate that she the reason she uses a wheelchair is because her mum and dad don't believe in God. And I think what we don't think about is the ripples and the impact of that. And that I don't believe that a statement like that is in good faith, to say that you are, and I know Robin wants to add to this, that you are in that wheelchair because you've got something to learn, is of good faith. I can't imagine anyone thinking that the person is going to feel good as a result of that. Robin?
Yeah, thank you. And while it's impossible to know how many of the complaints at the moment would fall into the statement of belief issue, one of the problems is because it becomes the defence. The Commissioner gets a complaint, a person has said something to a person that's really demeaning and derogatory. The Commissioner accepts it on the basis it needs to be investigated and potentially conciliated. Sends the complaint to the respondent. The respondent says, "Oh, that's my genuinely held religious belief." You get distracted from trying to resolve an interhuman interaction that was harmful into a debate about a defence and whether that defence is in good faith, available to the person, and all those other things. It completely skews what is supposed to be a process bringing human beings together to try and understand different perspectives and reach a resolution that is acceptable to everyone. It will be used in that way. We see that happening with defences now. And yes, it might be a minority, but that's enough to really skew people's sense that this is law that works.
Thank you. And, look,
and people won't use it if they don't think it's going to protect them.
Thank you. And look, my final question is, I note that I just wanted to know whether Mr Mahabray, did you have anything else that you would like to add in terms of the impact of the legislation on the multicultural community in Tasmania?
Only a very short statement here. Obviously, I'm given to understand that over 25% of the discrimination cases that are made under the Section 17 of the anti-discrimination law in Tasmania are from the migrant or the multicultural communities. Obviously, we don't have a further breakdown of how much that from those cases relate to religious discrimination, but I'm given to understand potentially a fair share. And so basically, it is going to have an impact on our diverse community in Tasmania. And I highly I appeal to the Senate committee or to make sure that the gold standard, as they say, of the Tasmanian bill remains intact. We want an inclusive society, not a society that is based on doctrines which were probably established hundreds and thousands of years ago. It's a lovely society that we want to develop in this country, an inclusive society, and this would be a step backward if we override this bill in Tasmania. And I once again, on behalf of our members, and I know over 6 members have put in with religious backgrounds, religious organizations that belong to Multicultural Council have put their submissions against overriding the bill. And I echo their concerns, and I would like to acknowledge thank you for the opportunity to hear us on behalf of the diverse community of Tasmania.
Thank you. Thanks, Chair.
Thank you very much, Senator Rice, and I want to thank all witnesses for their appearance today, and thank you again for your forbearance in relation to the time restrictions. We will now suspend for morning tea and resume in 15 minutes. Good morning. The committee is now in session, and I welcome representatives of the Youth Pride Network, the Australian GLBTIQ Multicultural Council and the Australian Federation of AIDS Organisations. Thank you so much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 49, 67 and 73 respectively. Please state whether you would like to make any corrections to your submission and concurrently for the Hansard record, would you please each state your full name and the capacity in which you appear today?
Shall I start, Senator?
Yes, please start.
Thank you, Chair. Jean-Carlo Tibera, President of the Australian GLBTI and Multicultural Council.
And then to the Youth Pride Network, who's appearing remotely.
Charlotte, Policy Coordinator of Youth Pride Network.
I'm going to ask you to say that again. We just had some audio issues. Thank you.
Sorry, Charlotte Glance, Project and Policy Coordinator of the Youth Pride Network. Is that any better?
Yes, that's great. Thank you, Ms Glance. And then to the Federation of AIDS Organisations.
Yes, Heath Painter here, Deputy CEO of AFAO.
Thank you very much, Mr Painter. Could I ask each of you to make a 1 minute statement? You'll need to cap it at 1 minute, please, because we do need to stay as close to time as possible. So first to the Youth Pride Network.
Thank you, Chair. Opportunity to speak on this important issue. The Youth Pride Network is an LGBTQI+ youth advocacy group in Western Australia. LGBTQI+ young people are an important and valuable part of our communities, and this includes our faith communities, which over 1 in 4 LGBTQI+ young people identify as being part of. However, LGBTQI+ young people still face very high rates of discrimination in Australia. Because of this, LGBTQI+ young people often struggle to self-advocate in the services they would like to access, such as education, health, mental health, and homelessness services. While we unequivocally support discrimination protections for people of faith, we hold concerns about certain aspects of the bill, including statements of belief, exemptions of conduct for religious bodies, and restrictions on abilities of qualifying bodies. These provisions, we believe, will cause significant anxiety and confusion for young people when trying to navigate discrimination in practice. We also think it will disempower organisations trying to create more inclusive services. For this reason, we urge the inquiry.
Apologies, but we will need to leave it at 1 minute. Thank you so much. Now to the Australian GLBTIQ Multicultural Council.
Thank you, Chair. I just wanted to quickly acknowledge that I've got 2 of my committee members on the line as well. Just for the sake of hands, I've got Michelle McNamara and Carl Gopal-Krishnan online with us today as well.
Oh, I'm sorry. They didn't introduce themselves. Could I just briefly ask them to introduce themselves and their capacity in which they are appearing?
Yes, Carl Gopal-Krishnan, I'm the WA representative for the GLBTI Multicultural Council.
Thank you.
And I'm Michelle McNamara, and I'm also a board member of the Australian GLBTIQ Multicultural Council.
Thanks, Ms McNamara. I'm sorry we missed you before.
It's fine, thank you.
Thank you.
Thank you, Chair. First, I'd like to acknowledge the Ngunnawal people on whose unceded land I'm currently speaking from. The Australian LGBT Multicultural Council, otherwise known as AGMC, is a national peak body that represents LGBTQI people from multicultural, multi-faith backgrounds. We have members in every state and territories, and we have maintained a consistent position that we support a bill that prevents discrimination on the basis of religion, but it must not be at the expense of our right to practice religion ourselves. We want a respectful discourse, but we fear that the proposed changes won't promote a respectful environment. We already know through recent research funded by the Victorian government that we did last year that 1 in 2 LGBTQI people from multicultural, multi-faith backgrounds feel excluded from their own religious communities. So, in trying to achieve the freedom of religion, why are we curtailing the rights of LGBTQI people to practice religion by making it easier to exclude others, making it easier for others to exclude us? The proposed definition of subjective religious belief will bolster and give licence to positions that exclude us, and these subjective religious beliefs are not necessarily required to conform to an established religious doctrine, belief or tenet.
Thank you so much. We'll have to.
Thank you, Senator.
And now to the Federation of AIDS Organisations.
Yeah, thank you. And further to the summary I've already submitted, AFAO believes religious freedoms, like all freedoms, should be capable of being limited to protect the rights and freedoms of others from offensive, demeaning and damaging comments. The bill prioritises the religious beliefs of health workers to the detriment of marginalised communities and people living with or at risk of HIV, such as gay and bisexual men, trans and gender diverse communities, culturally and linguistically diverse communities, including multicultural communities of faith, injecting drug users and sex workers. The ability of healthcare workers to make these comments will reinforce stigma and discrimination, reducing healthcare engagement among our communities and increasing a reluctance in individuals to disclose their HIV status, sexual orientation or gender identity to healthcare professionals. This creates a tension with Australia's pursuit of public health objectives to eliminate HIV transmission. Clauses 12 and 15 will embolden the expression of commentary loosely based on religious belief to the detriment of the health of our communities and Australia's world-leading response.
Thank you so much. I apologise. I'm going to need to ask you to stop there. We will now go to questions, and Senator Rice, if I could hand to you first.
Happy to start. Okay. Thank you. And thank you all for your submissions and appearing before us today. Look, I'll start with AGMC. A lot of the debate in this bill has been sort of characterised as this false dichotomy between religious groups and LGBTI groups. But it's clear in your submission there are many LGBTIQ plus people of faith. And then we've got the other intersectionality of multicultural people and being people of faith, and the intersectionality and difficulties sometimes of being accepted in their multicultural communities. Could you just talk us through, I mean, with those intersections, what an intersectional approach would actually look like if we were doing what everybody wants to do, to be protecting people of faith, to having religion as a protected attribute without all of the problems that this bill's got?
Yes, thank you, Senator Rice. The first thing to note in protecting religious people of faith is that by and large, the culture and the religion and the communities that sometimes coalesce between those two identities are inextricably linked. It's quite difficult to separate them, particularly for LGBTQI communities, especially people who come from communities that are very much migrant communities and refugee communities. And so a lot of the people that we hear from day in, day out are concerned that the ability to choose one is inescapable. And sometimes the concern that we have is how this bill can potentially force us to choose one. We have a member here who knew Christianity for pretty much all their life, but then were forced to feel like they had to leave the church in order to be who they were, and that level of exclusion is something that we don't think this bill currently allows for those people to choose both, or even sometimes their cultural communities as well as their religious communities.
And with regards to this bill, what are the risks going to be for people in that situation? I mean, how is this bill going to increase the risks, say, the LGBTIQA plus?
I spoke about the exclusion. I think it's got to further exacerbate the experience of exclusion between for people who are of faith and LGBTQI. I also fear about how this potentially can undermine the multicultural and social cohesion that we have in this country. We already see quite regularly and hear quite regularly of members having to choose, because of that level of exclusion, to make a difficult choice. And we're concerned to how that could potentially lead and fuel potentially sectarian differences that aren't necessary in a country like Australia.
And so, do you have any views as to how we could do it, how we could be protecting people of faith to have their religion as a protected attribute without undermining LGBTIQA plus?
Yes, I guess I would challenge the need to have the definition of good faith. I recognise that the meaning of good faith is a matter for the courts, but I think the legislation could provide some definition or further clarity around what subjective natures statements of beliefs are and what they can be and what constitutes a reasonable articulation of faith. The concern that we have at the moment is that the ability to decide that is a costly one. A lot of our members of our community can't afford to take this to the courts. And when we're experiencing all this already significant levels of exclusion, then we need that clarity in the legislation before we can see the protection that we want for people of faith as well.
Do either of the other...
Or would an explanatory memorandum example do what Senator Rice was just asking?
I'm not a legal expert, but I would leave that for someone else. But from our perspective, any clarity, whether despite what instrument it comes through, will be needed.
Thank you, Chair, and thank you, Senator Rice.
Thank you. I just wondered whether the other two AGMC reps would like to comment on the intersectionality and how we could be doing this better. Yes, Ms McNamara.
Yes, Senator. I'd like to comment that really this bill provides really what is an unnecessary exclusion of state and other Commonwealth laws, the Sex Discrimination Act. And I think that the provisions making this law override them is just unnecessary and should not be there. It creates a lot of the problems. And so removing the ability of this law to override those would be a much welcomed move.
Thank you.
Yes, thank you. Well, we actually have seen not just exclusion, but in the report that we recently brought out, there are some real instances of outright discrimination, covert discrimination, but also, people have a genuine fear of their safety. So we set up a working group really to look at the interaction between LGBT identities and right-wing movements and looking at some of the trends happening overseas. So we see this bill as, or any sort of tensions, religious tensions, it's causing a lot of complex, not just complex choices, but sometimes complex threats to our members and board.
Would you like to comment on the pervasive nature? I mean, your Navigating Intersectionality report sort of talks about the just having this steady stream of whether it's racist or other discrimination comments, and what the impact of having derogatory comments that perhaps don't reach, they don't reach the threshold that's outlined in the bill of being, vilifying and that really serious comments, but just sort of what allowing and permitting and comments that are offensive have on people.
Could I just briefly answer that, Michelle, and you could lead in? Thanks. I think one of the things that we've discovered, one of the reasons we set up this group, it's related, but it's not strictly in the religious discrimination, but our members don't appear very easily in the research. So we're not very easily identifiable. And if we're not identifiable in the research, then trying to measure the mental health costs, the exclusion in terms of family and domestic and family violence and abuse that occurs in ethnic communities, but also even things like racism in the LGBTI communities. The report that we brought out showed that our members do not complain and do not report, and there's a genuine fear about that. So, it's just a very silent and invisible group of people, but we believe that there's a lot more there than other people might assume is there.
Thank you. Ms McNamara?
Yes. If I could make a quick comment. My personal experience is I'm a member of this council because I'm a practicing Buddhist, and I was practicing my religion when I came out as transgender. When I spoke to my faith leader about it, he told me, among many other derogatory things, that I was possessed by evil spirits and that he would cure me, which gave me the absolute sent a chill down my spine because of the religious practices, conversion practices that exist in our community, in the LGBTI community. And I think furthermore, he told me that I couldn't tell anybody else in the community that I was transgender. And that really had an extremely damaging effect on my mental health for a very long period of time. It took me quite a bit to resolve it. And that personal experience still rankles with me today, even 5 years later, where I have found that there are LGBTIQ plus supportive communities in every religion that I know of, but most aren't. And this bill just adds power to their statements that are anti-LGBTIQ plus people and anti-women and anti-disability and all of those factors. And so I think this bill doesn't add anything to the power that the multicultural, multi-faith society that we have in Australia gives the country.
Thank you. Yes, and in contrast with the presentation from the Buddhist representatives yesterday, who spoke about how supportive they were of the LGBTIQA plus community. So I'm
there are
really
many communities
shocked
in the
and
community.
it's awful to hear that that you had to experience that.
Thank you.
Ms. McNamara.
Sorry, Senator Rice, can I just clarify, was that the formal position of the Buddhist chapter, or was it just an individual who made those comments to you?
So the gentleman was a faith leader in the Buddhist tradition, in a particular Buddhist tradition. He is a lineage holder of a particular set of beliefs in the Buddhist tradition, and so he's a person of quite some authority. But it is very hard in the Buddhist religion to find anything in the canon or even outside the canon that says being trans is not consistent with the Buddhist religion. Because I've conducted quite an extensive search on the topic, Senator, and there is nothing really, but individuals can present what they believe, and this bill allows them to do that without any reference to their canon.
So arguably that statement was not made in good faith, consistent with the tenets and doctrine of Buddhism. What do you think?
I think it was probably made in good faith, consistent with his beliefs, and I think Buddhism rests on the beliefs of an individual teacher. I think it's one of the features of Buddhism.
Sorry. Thank you very much. And back to you, Senator Rice.
Allows, basically, it's in the genuine beliefs held by a person, not necessarily in connection with the tenets of that religion. Look, I'll move on because I know we haven't got much time, and go to the Youth Pride Network. And I really want to thank you for appearing and for your really powerful submission as well. I was really struck by the tragic story that you shared in that about which said a close friend of mine who was openly trans was refused the ability to wear a suit to our school ball and eventually left the school in our final year due to the discrimination he faced, which is a horrific story. And I know there's a lot of concern that this bill is going to make situations like that even worse. So can you talk about what the dangers for young people are from this bill, and particularly those sort of school situations?
Absolutely, thank you, Senator. Yes, I agree. It's a really horrible story, and I think what we see at the Youth Pride Network is that very few young people, particularly high school age young people, are ever going to be in a position to bring kind of challenges to anti-discrimination or equal opportunity commissions or the AHRC. The powerful thing that Australian discrimination law does for young people is it provides them with a backing of what their rights are and how they can self-advocate, particularly in school settings. And we focused on religion schools, but I would contend even public education. We know of lots of young people who experience quite significant discrimination in public education. What we're really concerned about, particularly with statements of belief, is that this will completely confuse the waters in terms of allowing young people to self-advocate and for schools to understand how they can protect young people in an educational setting. And so that's our primary concern. We're also concerned, I think Mr. Greig talked about this in a previous session, about the override to whatever reviews on Western Australia's laws are set to come in after the Law Reform Commission process, and potentially around entrenching the ability of expulsion and discrimination. But I would also add that story of that young person is not uncommon. That's not an uncommon story. We know many young people who have similar experiences.
And how about the experience of young people in terms of accessing services, including homelessness services, medical services, mental health care? What are the concerns from your organisation as to what this bill will mean?
Absolutely. You mentioned in our submission, we've done a review and talked to lots of young people who've accessed specifically accommodation services, but we know from research that discrimination exists both in healthcare, mental health care and accommodation. I would kind of reiterate again that in those situations, young people are inherently vulnerable and they're in a position where it's very difficult already for them to self-advocate. And I think what this will do is, irregardless of the legal technicalities of good faith or whatever, what this will do is create a situation where young people believe that they just have to put up with these sorts of statements and they can't self-advocate, they can't report because of the sort of difficulty of the legal minutiae of it. So we have a fairly solid evidence that queer young people experience discrimination when accessing accommodation services, when accessing support services, when accessing healthcare and mental health care and education. And we think that this is going to create a situation where it's much more difficult for those young people to escape that discrimination.
Thank you. And look, my final question to Afeo, just what the lived impact of this bill you think is going to be for people with HIV in Australia? And you're on mute, Mr. Painter.
So sorry. Central to HIV management is access to healthcare, and whether it's through screening, whether it's preventative, or whether it's for people living with HIV, we need healthcare services that encourage people to feel safe, to disclose their status, to disclose their sexual orientation, to disclose their gender identity. We are very concerned that the bill will create an environment where healthcare workers can make comments that create healthcare hesitation, either by stopping engagement with healthcare or hesitation in disclosing critical personal information, which means that the healthcare worker may not be in a position to provide them with the advice they need because they don't have the ready information before them, or the individual hasn't gone to healthcare or engaged healthcare at all. And this places people at risk of HIV infection or disease progression if they're living with HIV. And I want to just quickly acknowledge Michelle's amazing reference to her own experience, and it was very brave of you to do that. But that is not uncommon. And we know of people who have had similar experiences seeking to obtain post-exposure prophylaxis or pre-exposure prophylaxis. And Australia avoided the worst of what was experienced in America, whereby HIV was seen and framed as God's punishment. What we don't want to see is this situation after 4 decades of hard work emerging in Australia. We are deeply concerned by clauses 12 and 15, and that's why we've advocated very strongly for the removal of those provisions.
Could I just go to that sort of that framing of AIDS being God's punishment? And we had quite a discussion in the Parliamentary Joint Committee last week as to whether, in fact, those sorts of statements would still be prohibited because of codes of conduct of medical associations. If you'd like to comment on your views as to whether that is a real fear or whether, in fact, the codes of conduct would mean it wouldn't happen.
Well, it would be dealt with under...
I can't talk about the code, so I can't respond to the codes of conduct, but what's critical here is it's actually if that comment is made. So it's not that the comment might be made and some code of conduct might be used to manage or respond to the practitioner who made the comment. It's the fact that a comment could be made and has been made in other environments, and the moment the comment is made, time starts to tick on the harm it has on the individual and on the communities or the community that individual belongs to, because those people will perceive a risk of judgment or of stigma from healthcare. And it's at that point that people hesitate in engaging healthcare or hesitate in disclosing critical information. And it's at that point that our successful HIV response is compromised.
So it's just the sheer fact of emboldening people to make those comments when otherwise they may not have made them. They might have stayed silent.
Absolutely. And the reality is these comments have been made privately in Australia and publicly in other similar countries like America. And it's that absolute point that it could embolden those comments being made here.
Thank you. Thanks, Chair.
Before I go to Senator Pratt, I just want to pick up on that point because obviously the comments that were made about people with AIDS being God's punishment is absolutely abhorrent. But can I put it to you that that sort of statement would not be protected in the proposed religious discrimination bill because it only covers statements of belief which a person genuinely considers to be in accordance with the doctrines, tenets, beliefs or teachings of that religion.
So if I can refer back, sorry, you're asking me that question?
Yes, I am, Mr. Paynter, yes.
Yeah. If I can refer to Michelle's case study, if I can call it that, where you have a particular person of faith making a comment to someone. Now that person makes that comment based on their interpretation of their faith. Once the comment is made, the harm is done. So I'm not convinced that this legislation would prevent that comment from being made. And even if, and at the point it's made, the damage is done. And and then you have this whole situation of an individual having to launch some kind of case to seek redress for the comment's impact.
Well, no, what I'm putting to you is that, harmful comments are not necessarily covered by, or hurtful comments are not necessarily covered by any legislation, but what I'm putting to you is that would not be a comment that would be protected under the proposed bill, because it would be very hard to argue that anyone would genuinely hold that view in accordance with the doctrines, tenets of their religion. So I'm just saying to you that I think the bill does not give anyone who makes such horrible comments any sort of protection.
Be that as it may, we're still concerned that it could embolden comments of this nature.
Thank you very much, Mr. Paynter. I'll now go to Senator Pratt.
Thank you. I'll start with you, Mr. Paynter, on a similar theme. In the context of Australia's successful HIV prevention, can you contextualise what HIV prevention has been like in countries where religious doctrine has very directly impacted on our capacity to respond to the spread of HIV?
Yeah, it's really interesting. Thanks, Senator Pratt. Look, the reality is it creates a situation where people fear healthcare services. They fear healthcare services because the healthcare workers that they're engaging could disclose their HIV status or their sexual orientation, and we've seen this particularly in countries to our far north. And that could lead to people being persecuted or criminalised because homosexuality, for example, is criminalised in these or in many of these countries. And so the impact on addressing HIV or even seeking to expand prevention services to people at risk of HIV, often communities that are very hard to reach, is catastrophic. And what you have is magnified poorer health outcomes among these marginalised communities.
It's also true that I've seen examples of doctrine that has explicitly targeted people with HIV in terms of safe sex messages around, well, if you're married, for example, you can't catch HIV because there's a presumption that sex outside marriage is not happening by one or other of the partners, and not being able to have a real discussion about who's doing what with who and why and how, because it's limited by doctrine and presumptions about moral codes, also has a damaging effect.
Absolutely. So you have this situation where people who might be in...
Sorry to interrupt. Senator Pratt, just by way of clarification, can you please just clarify which religion has that doctrine? Because I'm not aware that that's a doctrine of any particular religion.
To not have sex outside marriage?
No, the extension of your argument being that that you made in relation to AIDS not being possible.
Well, I think it's the presumption because people want to conform to that doctrine, that there's not always an open and honest disclosure of the fact that a couple is not conforming to that doctrine, and that has ramifications for open discussion about how HIV is actually applied. But Heath Paynter's the expert on this, not me.
Yeah, thanks, Senator Pratt.
Let's go. Sorry, are you happy for me to comment?
Yes, continue, please, Mr. Painter.
So let's go to that comment that Senator Pratt was making about sex outside of marriage and the presumption that someone who may be engaging in a health service who's married may actually need to engage services around HIV management. So they might be someone who is having sex outside of their marriage. They might be someone who is having sex with the same sex as them or the same gender as themselves. So they are engaging in sexual conduct that is outside of marriage. What we need are healthcare services that are open and encouraging of those people to disclose that information so that the healthcare professional can provide them with the advice they need to manage the risk of HIV, or indeed to manage treatment of HIV if that is the case. The opposite of that is that people simply disengage and hesitate in disclosing, and that is where our HIV response will fail.
But you don't have to be a person of faith to have that hesitation. Those two things are not necessarily aligned. People, for all sorts of reasons, might seek not to disclose active sexuality outside of marriage and have absolutely no religious basis on which to, undertake that particular health journey for themselves.
That is Senator O'Neill asking that clarifying question, Mr. Painter, if you can't see.
Yeah.
So I'm all for people accessing health services, but I don't know that people don't access services because of their religious beliefs as the main reason.
So some people may, but what we're concerned is that this will embolden comments either from a healthcare professional in a service setting or outside a service setting that will lead to healthcare hesitation.
Okay, I understand your point now. Thank you.
Thank you very much, Senator O'Neill.
I didn't get where the motivation was embedded in your point. Thank you.
I will now move to Senator Pratt.
Thank you. Can I ask the Youth Pride Network, and thanks for your great work in Western Australia, Charlotte. You've done a recent report on accommodation. What are the experiences of young people who faced, while in a vulnerable situation, perhaps having escaped family violence at home, where they have been subject to religious or other views in accommodation that has affected their ability to access that service?
Absolutely. You're correct. We've recently completed a report around the experiences of LGBTQI+ young people in Western Australia in accommodation services. Of the young people who we surveyed who had access to accommodation, around 92% had had a negative experience, one or more negative experiences, including homophobia, transphobia, or queerphobia. So that was about 50%. Feeling unsafe, about 40%. Staff ignoring young people discriminating against them was 32%, staff discriminating against them was 24%, being refused housing because of their LGBTQI+ identity was around 20%, and experiencing violence because of their LGBTQI+ identity was around 20%. So those were some of the experiences. I think that something I'd also like to talk about from that report is that one of the key things we found was the key to preventing that and preventing that discrimination, which I think is what all of our organisations aim to do, was about being able to create very kind of strong cultures within organisations and policies around prevention of discrimination. And so that's something we're really concerned about with this legislation, is that it will kind of disempower or make organisations hesitant or unsure as how they can go about changing the culture within their service to sort of remove those kinds of remarks. And so that's something we're very concerned about, because we do understand that LGBTQI+ young people experience very high rates of discrimination in our accommodation system.
Thank you. That's a terrific answer, Charlotte. I wanted to ask Heath Painter again and ask you to respond, Charlotte, when, how it is for young people when they hear views like this. So I'm reading from a Religious Institute website that says, since the majority of HIV/AIDS in the US is contracted through immoral sexual activity or drug abuse, we must realise that these diseases are consequences of the choices individuals make. And then it quotes the Bible. God made man with a freedom of choice, but with this freedom comes awesome responsibilities and consequences that can affect the good or bad of one's life. What are the ramifications? Those kinds of statements are nevertheless still made in Australia, and they're not automatically, you don't need a religious freedom clause to be able to make them, but you might need a religious freedom clause to be able to make them to someone's face, for example. What are the ramifications of how we manage HIV prevention and getting people to disclose to a health worker in the face of doctrinal statements like that are clearly made in good faith?
That's to me, Senator Pratt.
Yes, thank you.
Look, it's horrific reading that or hearing you read that. It deeply concerns me that this kind of narrative could gain traction and enter into the public domain as a kind of point that's discussed. And what it really does is it creates a sense of fear among young people, particularly young people who we know haven't had a lot of engagement with health services. We're trying to desperately build their knowledge around HIV risk. To hear these comments being made by leaders, by people more senior than them, simply turns them away from healthcare. It turns them away from engaging with healthcare to build their awareness and knowledge of risk, to build their awareness and knowledge of the need to screen regularly, to build their awareness and knowledge of the huge benefits of treatment if they happen to acquire HIV. And so the real risk is that this could have a real lifelong effect on the confidence people have in the safety, the inclusivity, and also the cultural appropriateness of our healthcare settings. And we know now that people, particularly in the LGBTI community, really favour seeing community-controlled healthcare physicians or physicians inside community-controlled healthcare settings, because they have a lot more faith in these, or a lot more confidence in these providers, that they won't be making those comments. The inverse is that there is a fear or a hesitation, perhaps hesitation is the better word, around accessing mainstream services where there is a risk or a perception of being judged or of stigmatising comments being made to them.
Mm. Thank you. I don't know if you had an observation on that, Charlotte, but I also wanted to ask, would it surprise you to know that the COVID cluster in Western Australia has been that's just arrived here, has been more difficult to track because the cluster is associated with a massage parlour? What does it mean when we're trying to get good public health responses and a religious view about a debate like that is privileged over other voices in certain contexts?
Sorry, was that?
To both of you. I know I wanted to give you, Charlotte, a chance to respond to, how young people navigate these kinds of issues.
Thank you. And I completely second everything that Mr. Painter said. And I think we spoke about minority stress in our submission and the impact that hearing those statements indirectly or directly has. And I think maybe also creating how those create a perception or a perceived hesitation when accessing services. And I think it's important to know that young people, LGBTQI+ young people, will assume that they will be discriminated against until proven otherwise. So the rest of society, or in a lot of ways, assume that they won't experience discrimination But for queer young people, they will assume that someone will discriminate against them until they're shown clear signs otherwise. And so when that's reinforced by statements or stories that they hear from their friends or experiences that they have, it makes them incredibly hesitant to access healthcare, mental health care, and other sorts of services. So I think that's really important, and that leads to kind of impacts down the line.
Painter, in that context, to ask you about the situation in WA with that massage parlour, but also to say it's clear in Australia we don't have laws as a whole that actually in large prevent those kinds of statements being made, with the exception of perhaps Tasmania as a whole. So what do you make of this, therefore, extra licensing that seems to have been inserted in this bill? Is there a problem with freedom of speech in terms of how we currently manage these issues from a health point of view on either side of the debate? Answer as you see fit.
I think it goes back to the core principle that freedom of speech is always something that should be capable of being limited to protect marginalised communities from inflammatory comments, from comments that are not evidence-based. Really what we need is to avoid laws that interrupt that, or that actually create a situation where the voice of one group can privilege that of another group, or can be prioritised over that of another group. And that is our concern with sections of this bill.
Senator Pratt, I'm keen for you to wrap up if you can, please, very shortly.
I have, Chair. Thank you.
Oh, thank you very much, Senator Pratt. Senator O'Neill has one question, I understand.
Yeah, thank you very much. I'm just referring to, and you might need to take this on notice, I'm just referring to a piece of research that I cited yesterday and has been mentioned this morning in evidence. It's the longitudinal study of Australian children. And the Australian Catholic bishops put the point that roughly 1 in 20 Australian children has experienced discrimination based on their religion, which was higher than the rates of discrimination based on disability, mental health or sexuality. And I've gone to the source to check it, and I'm reading from table S2, and the committee will provide you with for this to comment on. But this is a percentage of teenagers reporting discrimination according to demographic and physical characteristics. So racial, 19.4%, the highest. Then disability, 7.6. Religious beliefs, 11.7. Body, well, this is actually the highest, I'm sorry, 31.8. Mental health, 7.6. Sexual identity, 5.4. And sex, 8.6. A huge range of ways in which people are being spoken to by others in diminishing ways, in hateful ways that break people's sense of themselves and their right to be who they truly are. So that's why we have all this discrimination law. Can I be clear? You do support legislation to prevent discrimination on the bounds of religion. That's for all of the groups, because you represent, if you're nodding, just, you're all nodding, everybody's in agreement, so the record can show, yes, everyone is in agreement with that. Can I take you then to, so I invite you to respond to that, because I think it's very concerning, and you represent such a large group here collected, you know, as you're gathered before us. Can I take you to section 12, because we've discussed this in detail, and I want you to have a look at the Human Rights Commission, because they actually state in their submission, and they're the ones who are doing this day in, day out, despite the awareness of all the issues that you've been raising and we're all concerned about, they state that it is not aware of any cases where genuine statements of belief have been held to be contrary to the Australian anti-discrimination law. So I invite you to have a look and see if you can find any examples to provide the committee with, not vilification, discrimination, anti-discrimination law. And you might be able to give me an answer on this today. While the Human Rights Commission recommends the removal of Section 12, it also argues that Section 12 would not confer much, if any, additional protection to statements of genuine religious belief, which is quite different from some of the views that have been put to us by other participants in these inquiries. Now, what is your view? Do you agree that Section 12 wouldn't confer much, if any, additional protection to statements of genuine belief, particularly in light of the Human Rights Commission's statements? So perhaps Mr. Giancarlo De Vera, if you could, what a beautiful name, if you could actually answer that here, because you are live in the room, that would be very helpful.
Thank you, Senator. I'm happy to take some elements of the question on notice, but I think the first thing I want to say is it was a point that my colleague, Mr. Gopal-Krishnan, mentioned earlier, and that's the cone of silence that sometimes a lot of people in our community experience, and that's a fact that we don't want to report some of these experiences of discrimination. So the point you made about the Human Rights Commission not recognising, I guess, the number of potential complaints of discrimination, I think is one side of the coin. We see the other side of the coin where people don't report them because they don't think redress is possible. And so the ability, so the question there is how, and we hear the evidence from the people we've heard today here, how the level of stigma, the level of perception, and how that is going to concern people wanting to come forward and not wanting to come forward, I should say, rather, and what that means to people who don't feel like they've got the power to make change. And so going back to an earlier question you made, Senator, you asked about the clarity around whether it should come through the explanatory memorandum or the legislation itself. I actually think, upon further reflection, that it should actually be further clarified in the legislation, because explanatory memorandum will help the court to decide what the meaning of those statements should be. Will help the court to decide what the meaning is, the definition of statements of belief. I think we can prevent a lot of this by ensuring that we have clarity in the legislation, so we're able to feel more confident and be able to come forward. And I think to some degree will overcome some of the barriers we have in our current experience of being silent and not wanting to come forward.
Could I on notice ask you to have a look at the Law Council's evidence from the previous committee's hearing, which asserted very significant structural challenges to people accessing actual redress if the bill as it's shaped with regard to state, federal jurisdiction is to go ahead. So they very clearly outline, Chapter 3 courts, state tribunals, federal courts, the whole complex mess, which is also so unknown to so many Australians in terms of civic literacy. If you haven't had the experience, usually it's something that you heard one day at the back of the classroom when you were in Year 8 in one lesson, and it's got nothing to do with the rest of your life until you confront it. So if you could take on notice the Law Council's concerns about the way in which this would be structured, I'd be interested in your response to that too. Thank you very much, Chair.
Thank you very much, Senator O'Neill. And I've... I'm sorry, did someone speak? No?
Sorry, I was wondering if I could also respond to O'Neill's question.
Could I just ask you to do so in a very quick 30-second effort, please?
Absolutely. To take your point about the complexity, but what I would put to you is that as an organisation, something we do is we've worked with legal organisations to try produce resources to help young people understand their rights. And at the current stage, it's already incredibly complicated and difficult for us to communicate what young people's rights are in a school or an educational or a hospital or wherever. Regardless of whether this is what statements this does or does not, what we're concerned about is the additional complexity that we think this is going to add, and the incredible difficult position that puts young people who are trying to self-advocate in when they are trying to understand what their rights and obligations are in many settings.
If I can, Chair, just respond. The Catholic Education Commission indicated that they would support a relatively small amendment to 38.3 of the Sex Discrimination Act to be embedded as part of this legislation to actually provide clarity to young people in schools that they would not be dismissed. It's been articulated that that would not be happening anyway, but would you support that legislative change to make it clear while the Australian Law Reform Commission continues its work more broadly into 38.3? Mr De Vera?
Sorry, do you mind repeating the question, Senator? Sorry, my apologies.
You were nodding, so I thought you were saying yes.
Sorry, Senator O'Neill, we are really right.
It's on the record now. Perhaps you can take it on notice.
Sure, maybe we can take that on notice.
A small amendment to 38.3 for students in schools.
Thank you very much, Senator O'Neill. Look, I would like to thank representatives from the Youth Pride Network, the Australian GLBTIQ Multicultural Council and the Australian Federation of AIDS organisations for your submissions and for your time and generosity in giving evidence this morning. For those who are listening, just to update you on our program, we are running a little behind. We are intending to take a half an hour lunch break only and hopefully catch up so that we are on track with our AIG and Chamber of Commerce and Industry session at 1:30. We're all working very hard, I know, to stay to time. It's a very tight schedule. I'd now like to welcome representatives of the Diversity Council Australia, the Australian Youth Affairs Coalition, Equality Rights Alliance, the Harmony Alliance, People with Disability Australia and the Federation of Ethnic Communities Councils of Australia. Thank you so much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 7, 36, 48, 84, 66 and 82 respectively. For the Hansard record, would you each please state your full name and the capacity in which you appear today and also indicate if you have any correction to your submission. I will start with the Diversity Council Australia.
Thank you, Chair. Catherine Brown. I am the Director of Communications and Advocacy at Diversity Council Australia. We have no corrections to our submission.
I thank you. Now to the Australian Youth Affairs Coalition.
Yes, Luke Ryken, Executive Officer of the Australian Youth Affairs Coalition, joining from the land of the Bunurong people of the Kulin Nation.
Thank you. Equality Rights Alliance.
Ms Helen Daly-Fisher, Convener of the Equality Rights Alliance, here on Ngunnawal lands.
Harmony Alliance. No one from the Harmony Alliance is attending. People with Disability Australia.
Jean-Carlo De Vera, Senior Manager of Policy.
And the Federation of Ethnic Communities Councils of Australia.
Alexandra Raphael, I'm the Director of Policy and Advocacy, and we have no additions to our statement.
Thank you very much to you all. I'd now like to invite you to make an opening statement to a maximum of 1 minute, commencing with Diversity Council Australia.
Chair, sorry, I was just unmuting. So look, thank you for having Diversity Council here today. We are the independent not-for-profit peak body who lead diversity and inclusion in the workplace, and we have a group of over 1,000 organisations who are members of ours, and our membership reaches about 20% of the Australian labour market. Look, we have really strong support for people being protected from discrimination and harassment because of their religious belief, and we proactively support organisations across Australia with workplace resources to create inclusive multi-faith workplaces. However, we have concerns that this proposed legislation goes beyond protecting people from discrimination and could extend to eroding other important anti-discrimination protections. In particular for workplaces, it could give licence to potentially harmful statements to be made that could contribute to hostile, unsafe or non-inclusive workplaces, as well as for employers creating complex legal situations which would have an impact on the ability of workplaces to foster inclusive cultures.
Ms.
And
Brown,
our research
I'm sorry, I will need to hold you there because I'm strictly speaking, keeping
to time, absolutely.
The 1 minute. So if everyone could observe that, please. Now to the Australian Youth Affairs Coalition.
Yeah, the Australian Youth Affairs Coalition is the national voice and advocate for more than 4.5 million young people in Australia. In the debate on this bill, the discussion has often been focused on the areas of life which will most affect young people. And we conducted research to hear directly from them. 79% agree there should be laws which protect religious people from discrimination. However, 92% responded the bill should not remove protections under existing laws. We do believe that people of faith should be protected from discrimination, but I have to ask, what is the acceptable number of LGBTIQA+ young people to experience discrimination on the basis of religious belief each year? What is the acceptable number of young people with disability to be called a burden on the basis of religious belief? Because that is what this bill will allow. And while you or I or the other people who appear before this committee may not intend to engage in that behaviour, it will give organisations, individuals and those with bad intent the power to discriminate, and this should not be allowed to occur.
Well done, Mr Ryken. Thank you. Now to Equality Rights Alliance.
Thank you. ERA is one of the 6 national women's alliances funded by the Commonwealth Office for Women. We're strongly in favour of the implementation of the international right to freedom of thought, conscience and religion, as set out in the ICCPR. Unfortunately, this bill doesn't enact that right. Internationally, the right to freedom of religion gives people an absolute right to believe what they want to, but the right to express that belief in the world can be limited if your religious speech or practices would impact on the rights of others. Section 12 turns that right on its head by protecting religious speech, even if it results in unlawful discrimination under other acts. One of the greatest barriers to gender equality is tackling unconscious bias and discriminatory norms and cultures. In its current form, the bill will provide protection to people who contribute to sexist work cultures, reinforcing the cultural barriers that the Sex Discrimination Commissioners Respect at Work and Set the Standard reports seek to overcome. This bill should not be passed in its current form. Thank you.
Thank you very much, Ms Daly Fisher. Harmony Alliance has indicated they are now on the line. Could I ask for the representative to introduce themselves and then make a 1-minute opening statement? Right. I'm just been told she may not be there yet. People with Disability Australia.
Thank you, Chair.
It's a difficult juggling act managing so many remote attendances.
Thank you, Chair. People with Disability Australia would like to see this bill not passed in its current form. We have concerns around the ability to further discriminate all people with disability. The proposed changes also potential robust of hard-fought legal protections that we access on a daily basis in the state and territories. We have overarching concerns around how this legislation will promote and bolster community attitudes which are degenerative and potentially dangerous to people with disability. The concern that we have is that these attitudes are by far the biggest barrier that we experience as people with disability and stops us from being free and equal. So how are we going to ensure that this bill overcomes the concern and the barriers that we have around being equal and free in a society where community attitudes don't devalue us as human beings? We're concerned how this will lead to worryingly standards and practices being set at an organisational individual level and how these standards and practices will seek to exclude us. And for these reasons, we do not want this bill to proceed as it currently stands.
Thank you very much. I'll now go to the Federation of Ethnic Communities Councils of Australia.
Thank you. The Federation of Ethnic Councils of Australia is the national peak body for multiculturalism, representing the millions of people across Australia from culturally, ethnically and linguistically diverse backgrounds. We reject all form of discrimination, support protection from discrimination on grounds of religion. However, we believe that people can be protected without removing protections from others, which we believe this bill does. Our communities across Australia may include many people who could be affected by this bill in numerous and complex ways, and unfortunately the timeframe for this inquiry has not adequately allowed for their voices to be heard, which is essential to properly understanding the possible impacts. However, the key concerns that we have heard are around the ways that the statement of faith provisions could be used to discriminate against people, including on the basis of religion, and especially those whose religious beliefs are visible, such as through their name or their appearance. We are concerned that this bill allows statements of faith to be used by those with more power to discriminate against those with less. And we note that an individual's relationship to faith and religion is often personal, and people of the same faith may not agree on their interpretations. As such, as well as being concerned that this bill may be used unjustly by people and institutions from majority religions against people from minority religions, we also see the possibility of this being used between people of the same faith. This bill is likely to negatively impact Australia's multiculturalism.
Sorry, I know.
Well done.
Thank you so much for your statement. I'll now go to questions and give the call to Senator Pratt.
Thank you very much. Because we're short on time, I'll put 3 questions, and please, if I can ask each witness to just pick one of them to answer. In what form, amended form, might you support this bill passing? Have you read any submission or heard any evidence to the committee or the previous committee last week that's caused you to rethink or change your mind about any aspect of these bills? Or is there any particular submission or evidence that you've read or heard in these processes that you'd really like an opportunity to respond to? Perhaps, and I'll go to the Diversity Council first.
Senator Pratt, before we go to the Diversity Council for an answer, I just want to confirm that Harmony Alliance is on the line. I did hear a beep.
Yes, I am here.
Oh, wonderful. Ms. Nguyen, could you just announce yourself and your position? And I'm sorry we're jumping around, but obviously Harmony Alliance have joined us late. If you could just introduce yourself, please.
My name is Nyadu Nguyen, and I am the chair of Harmony Alliance.
Do you have a 1-minute statement that you wish to make?
No, I think we'll be submitting a submission. We'll be making a formal submission.
All right, thank you very much. I'm sorry, Senator Pratt, if I can give the call back to you. Apologies for interrupting your question.
Well, I will just go straight to Ms. Brown.
Thank you, Senator Pratt. Look, my very quick answer would be that we would reiterate the concerns that we expressed at the other committee hearings last week. In particular, our concerns, like many organisations here, are around the Statement of Belief clause. We are not legislative drafters, but believe that a bill that is put in the form of other anti-discrimination legislation where there's no hierarchy of rights or there's no overriding of other aspects of anti-discrimination law would address the issue, which, as we said, we're very strongly in favour of protecting people from discrimination on the basis of religion.
Thank you, that's terrific. Youth Affairs Coalition.
Thank you, Senator. We would agree with the DCA. In our particular submission, we recommended removing Part 2 of the bill and all other provisions which would allow freedom to discriminate, essentially consistent with other pieces of discrimination law. We did that by specifically working with a group of young people, 50% which were young people of faith, and asked them what they thought and gave them a range of options. And so that was what they came to.
Terrific. Equality Rights Alliance.
We similarly have concerns about Section 12 in its current form, and we would want to see, in particular, the provisions that allow for the overriding of existing discrimination laws to be removed, and instead for a balancing provision to be included which allows for an assessment of the relative damage to the parties involved, which would then allow for an assessment of the competing rights in that situation, which would be consistent with the approach taken in the ICCPR. In addition, there is some concern about the definition of religion in the bill, or the lack thereof. The idea of religion, I should fess up before we go any further that my previous career was as a discrimination lawyer for 12 years, both in the private and community sectors. And one of the things that as a former practitioner in this area I see as being a critical problem is that the idea of religion itself is something that we have difficulty defining. It's been done by the High Court, and we do have a definition from the High Court that we could use. That definition does take into account our concerns about Section 12, in that it says that the canon of conduct part of any definition of religion, if the canon of conduct offends against ordinary laws, canons of conduct which offend against ordinary laws are outside the areas of any immunity, privilege or right conferred on the grounds of religion. And that's a paraphrasing of the decisions in Church of New Faith from the Commissioner of Payroll Tax Victoria in 1983. So we have a structure in place for actually looking at a definition of religion. It's the basis for the ABS's understanding of religion. And it's not going to solve all of our problems because religion is by its nature amorphous, and we don't want to narrow it down too unnecessarily. But there does need to be work in this bill on that definition, because at the moment, in my past life as a community legal centre lawyer, I have had clients come to me, in one case with a foot of paper and CD-ROMs, by which he wished to explain to me his religious beliefs. Which were the reason he wanted to get a male lawyer rather than a female one. But when you look at the definition as it stands currently in the Act, what you need is that he needs to believe in good faith, that his beliefs are his beliefs. He needs to genuinely believe that his beliefs conform with the tenets of his faith. Of his religion. We don't have a definition of religion, so it's very difficult to start unpicking that. It's going to end up being a long, complicated process in the courts, which doesn't benefit anyone. And the flip side to that is that there will be people whose beliefs are extreme, problematic from a safety or a health or a discrimination rights perspective for other people, which will nevertheless be happily covered. And so we need a balancing mechanism in the Act, which allows us to say if a person's rights, if we have two people's rights on the line, the right to non-discrimination on the basis of religion and somebody else's right, there needs to be a provision for balancing that, preferably on the basis of comparative damage.
Can I ask if what you described was commonly known as the sincerity test, as opposed to a reasonableness test?
Yes, so most of the anti-discrimination legislation at federal level uses reasonableness as its method for balancing the needs of many people. What we're looking at here, though, I think if we're talking about the definition of religion, we're looking at a limiting, if you like, of the extent of the right. All human rights need to be limited to the extent that they impinge on other rights.
Yes.
And so if we're looking at, and I apologise, I wasn't familiar with the term you used and it's gone out of my head.
What did you say?
I wasn't familiar with the term you used and it's gone out of my head.
The sincerity test.
The sincerity test. Yeah, so at the moment the Act, or the bill, relies very heavily on a sincerity concept based on the idea of good faith. I think we probably need something a little bit more objective than that, but it's very difficult, particularly given that ERA is advocating the implementation of the right to thought, conscience and religion. Then there is always going to be a sincerity element in it. So we can't alleviate that, and that's why the balance becomes important, balancing interacting rights, and we need a mechanism for that in the Act.
That goes to questions that were asked earlier about the capacity of courts to actually deal with doctrinal matters. And we've had a massive range of views across all of the faith traditions, and within the faith traditions, a massive range of views. Yet, all around the world, there are countries that are dealing with this. Most of the witnesses here have articulated, as you've indicated to us today, that everyone supports something that will provide protection against religious discrimination. And you probably heard me reading the statistics just recently about the impact on young people. So what amendments need to be made, given, your knowledge as citizens, right? Legislation, yes, it's complex, but as citizens, what amendments need to be made to enable that provision of protection without doing harm? What do they look like?
The first one, from my perspective, is that human rights are for humans, not for corporations. If we want to deal with the ability of institutions that administer a faith, that needs to be dealt with separately, and that needs to be dealt with a good, long conversation beforehand, because human rights can't be held by a company.
So we had evidence about that yesterday from the Jewish community about how important it was for them to service their community. I agree with you with the timing, but we are where we are, and this is a protected attribute really that has not had legislation. People don't want to wait and wait and wait because the government's been promising it forever. So can I ask you to sort of take on notice? I hear the point you're making, but I think that the point that the Jewish community made, not just for themselves but on behalf of others, actually talked to the need for more than just an individual having a right. Because the freedom to associate is embedded in religious practice and manifestation of your faith. It's not just an individual who gathers together, it's a group of people. So I'll leave my questions there if I could. Just if you could respond to that on notice, that would be very helpful. Thanks, Ms Fisher.
Sure, I'll just
Daly
make
Fisher, sorry.
one very quick response to that, which is that feminist organisations would love to be protected under the Sex Discrimination Act. Feminism is something that has been developed and is maintained through group interaction. It is a constant ongoing dialogue. It's not appropriate for feminist organisations to be given human rights. And so I think it may be appropriate for other protections to be put in place for religious organisations, but a Discrimination Act that deals with the human rights of individuals is probably not the place for it.
If you have any suggestions, I'd be interested to see what it might look like. Thank you.
Thank you. The Harmony Alliance and
can I, first of all, I'd like to apologise for coming in late, but if I could take the minute that I was offered before and just make some general comments on Harmony Alliance position. Harmony Alliance is one of the national bodies that present migrants and refugee women. And the proposed religious discrimination bill does concern us. We think that migrants and refugee women in Australia comes from a range of different religious backgrounds and non-religious backgrounds, and our concerns regarding the bill lie at the intersections of religious freedom, human rights, and the agency of women. And while the bill we think that the bill will potentially negatively impact migrant women on a number of levels, including young girls. On the issue of the protecting statements of belief, we think this would give space for discrimination. This is something that has been raised by others on this platform. We think that in protecting such beliefs that might have an intersection with practices that discriminate or harm women, that this can provide some sort of an excuse or indeed undermine the protections of Sex Discrimination Act or even the Racial Discrimination Act. We also think that that migrant women are already facing a range of barriers to employment, and that this legislation, in the way that it's currently drafted, it has the potential to even create more barriers for migrant and refugee women. An assumption about this legislation is the interventions of court. Again, we are mindful that not all people have equal access to the court, and there is a significant disadvantage for migrant and refugee women, especially those with low literacy skills. So really, our recommendation is that Harmony Alliance does not support the bill in the current form to protect migrant and refugee women's physical and mental well-being, right to education and employment, and the right to be free from discrimination. We recommend as a minimum the following: that the exemption to the statement of belief listed in section 12.2 of the Religious Discrimination Bill that do constitute discrimination should also be extended to include hateful, manipulative, and commanding statement concerning other individuals or group of people. Where the exception to unlawful discrimination is outlined in section 39 of the Religious Discrimination Bill concerning employment should be accompanied by a more explicit definition of inherent requirement and an adequate safeguard to prevent racist or sexist attitude, prejudices, and bias from passing as inherent requirement of a job. Our final recommendations are Section 7 to 9 in the Religious Discrimination Bill should be amended so that there is no longer allowed publicly funded body to discriminate against people on various grounds. I'm sorry, I didn't want to miss out on getting those points at least noted by the committee.
Thank you very much. Senator Pratt, we have almost reached your time limit. Could you just wrap up, please?
Do we have people with disability?
Yes, you do, Senator.
Yeah.
I'll make it quick.
Yeah.
Sorry. In response to your first question, Senator, we would simply like to see the removal of the overriding of existing legislation, the Commonwealth and territorial level. The complaint mechanisms already are quite inaccessible, and we fear that having to pursue redress through the courts would be even more inaccessible.
Thank you, that's helpful. And Becca, please.
I'm happy to just support everything that everyone has already said and just say that there are specific ways in that multicultural people in Australia are affected on all of those levels, including, for example, by complaints processes which are already incredibly inaccessible for people from different cultural backgrounds or who don't have English as a first language.
That's very helpful also and very succinct. Thank you, Chair.
Thank you very much, Senator Pratt. I'm now just going to give the call to Senator Bragg, who just needs a couple of minutes, and then to Senator Rice. Senator Bragg.
Thank you, Chair. Ms Dally Fisher, I think you've highlighted quite an important issue in your testimony today. So the question of how the more orthodox parts of the bill work alongside the existing federal anti-discrimination laws. So am I understanding your view accurately that there needs to be more thought given to how those potentially competing provisions would apply?
That's correct. So in our submission, we've actually suggested that the way forward is to review and consolidate all of the existing federal discrimination laws. It's a task that's been attempted before, but it is something that needs to... Yeah, we survived.
And it's a Labor platform too.
Yeah, but the problem that we have at the moment is that it's actually very difficult to balance competing rights between separate pieces of legislation. So there is a potential under the bill, as it currently stands, that an employer may find themselves in a situation where one employee considers that they have a valid complaint under the Sex Discrimination Act, and another employee considers that they have a valid complaint under this present bill. And it's going to be the employer's job to work out what their action is. While we can accept that the courts need to sort it out, running two cases simultaneously is a real burden. So from our position, consolidation of the standard parts of this present bill into that would help us to deal with those conflicting areas.
Okay. Could you maybe take on notice any examples you can think of where there could be a competing right between, say, the age discrimination law and this? The more orthodox provisions of the bill. I'm not talking about the statement of belief. And then my last question to you was more perhaps in reference to your legal practitioner days. So are most of the cases that arise under the existing 3 acts, do they generally go to the Human Rights Commission and are they generally resolved there, or do you have any sense of this?
We would always try to resolve complaints at the Human Rights Commission prior to, and there is a previous process prior to the Commission which isn't talked about much, but that's the lawyers getting together and trying to put the matter aside. That often happens after the parties have tried to do that. And so it's actually quite a long process.
Thanks.
And then on top of that, my advice would always have been go to your state or territory jurisdiction in preference.
Because it's free?
Yeah, because it's free, because the process is just a little bit less, when you get to the tribunal, the process is less complex.
It's free to make a claim, but if you defend a claim, do people seek to have counsel with them, and is that where cost comes in?
It does.
Yeah, okay, thank you.
Sorry, I'm just
Thank you.
Really trying to keep on track. We do need to finish right at 1 o'clock. So, Senator Rice, you have the call.
Let's see how much we can get out in the next 10 minutes. I want to start with FECA, and thank you for your submission and your concerns with the bill. You're obviously well placed to reflect on the sort of the intersectional complexities of the bill of people of faith, many of our multicultural communities having strong faith communities. And in particular, I note that we've had submissions and evidence from some of the Muslim community leaders that they support the bill because they want to see people to be protected on the basis of their faith and to have religion as a protected attribute. So could you just sort of talk us through, obviously in forming FECA's position, you must have thought a lot about this. So talk us through what your processes were to come to the position that you have come to.
Sure. So thank you for the question. Yeah, I mean, FECA consults widely on all of these issues and has now for a number of years as these issues have been debated in the Parliament and the public. And so while we didn't really have enough time to do as much consultation as we would like on this one, we're really, I think, well placed to be across all of those different competing views across Multicultural Australia as much as anyone can with such a diverse cohort. And I think, look, there are lots of different opinions on this, and I think it comes down to what Helen was saying, was that discrimination legislation needs to be created for people, not for institutions. And so, yes, we absolutely, and I think the vast majority of people in Australia support the right to be, the religious discrimination, but where we err when we look at the view just from institutions and organised kind of bodies is looking at entering into the territory of the right to discriminate on the basis of religion, and then again, because of the short time frame of this inquiry, we're concerned that the voices of those organised bodies are much louder than the voices of everyday people who have lots of competing parts of their identity that leads to this discrimination. So we have a lot of people in Multicultural Australia who are, maybe discriminated against due to as a result of this bill because of their sexuality, because of their age, because of their gender, because of many, many other types of parts of their identity. And so Multicultural Australia is not a monolith. It is incredibly, incredibly diverse. And the reason why FECA has taken the position that it has is because we see the danger in this bill is for the people in our community with less power, basically, and which is literally the opposite of what discrimination legislation should be aiming to do. It is turning it on its head, the purpose of this type of legislation. So that's our rationale there.
Mm. And can I ask
you? This is Nyadol from Harmony Alliance. I wanted to add on to the comment that FECA made. I think another really important consideration, especially hearing from institutions, is generally the difficulty that I think as Australia, as a country, we're struggling with, which is the representation of women equally and equitably in those institutions, and therefore women being able to communicate in those institutions the intersections of religion and their gender. And I think that this bill, particularly when it comes to migrant and refugee women, misses that. The second thing is that we do understand that migrant communities can be, or some migrant communities are predominantly religious-based, but I think that needs to also be balanced with the changes that occur when a person arrives in this country, the benefits of laws and regulations. For example, the federal legislative regime of anti-discrimination legislation, and I think that what occurs in this instance is that when we just look at the religious aspects of communities, which might be something that is more visible as something they brought with them here, we miss the other nuances of the nuance of what happens to women when they come here, how the expectations change, and how that might conflict with particularly religious beliefs that are now going to have the power of being protected by law.
Thank you very much, Ms. Nguyen. That was really useful. Noting the time, I'll move on. I think we could continue talking about that for about the next half an hour if we had the time, which sadly we haven't because of the contract constricted period that we are considering this bill. I want to move to People with Disability Australia. So, Mr. De firstly, just briefly, what's PWDA's view on the consultation process associated with this bill, and has it been accessible for your members?
Simply put, no.
Right.
We have had the opportunity to engage in wide-level consultation.
Thank you. And you say in your submission that Section 9 is going to enable service providers to refuse to accommodate people with certain disabilities within the provider settings based entirely upon a subjective notion of good faith. And so can you expand on that? And I just also want to say, I'm really sorry that this is, what your members and yourself are having to put up with.
Look, it manifests in different ways, but most concerning is how it manifests on the individual level. A lot of people access supports through independent support providers, and so particularly those who are managing their own supports, especially through the NDIS, who are self-managed. And so the concern that we have is that at the provider level, who are individual contractors individual contractors being employed by the person with disability, that they may make decisions without even making any concession around what is needed for the person's disability and the support that person needs to be able to provide that support. Sometimes without even the conversation, it could just be an articulated belief that they think is in good faith, and what happens when they feel like they can be emboldened to make decisions around what they can deliver, even though it will probably be in contradiction of their own code of conduct.
Again, so as per the discussion we were having in the previous session, it's emboldening that conduct, and then the person who is being impacted, it's up to them to sort of take action.
That's right.
and in general, so people with disabilities, I mean, what's their ability to be taking action through the courts?
It's actually quite significant. I think there's one level then the people need to have the ability to be able to self-advocate. We can't assume self-advocacy is something that people with disability can do. The second thing that we need to consider is that even if they can self-advocate, they'll need the support of individual advocates to navigate complex systems.
Yeah.
And so we are constantly seeing, particularly as individual advocacy organisations throughout this country, and we are one of them, a huge, I guess, backlog of supports that we can't provide individually to provide advocacy services because of the lack of resources, simply put. And so we're concerned that even if people can advocate, they will need the support of advocates, and if they get to the point of having the ability to navigate the systems, particularly complex legal systems, the cost is a concern. 1 in 2 people with disability are impoverished. So the levels of poverty is significant. 1 in 2 people have a job. So the ability to go through the courts is absolutely something that we can see being a huge problem.
Yeah, thank you very much. Okay, we've got 2 minutes. Ms. Daly-Fisher, I wanted to draw upon your previous life as a discrimination lawyer and the discussion you had previously about religion. And I asked questions of other people who have had experience, expertise in what is a religion, with relation to I don't know if you know about the example that was in the media last month about the Church of Ubuntu in Newcastle, which sacked somebody because they were vaccinated, and it was their position that that was in contradiction with our constitution, contrary to our position on what's required of us by our Lord God and Creator. We've had a bit of discussion as to whether such a claim would hold up in the court, whether the Church of Ubuntu would be recognised as a religion, and so they would be able to do that. Do you have any views on that?
Yes, and I'm not intimately acquainted with the case, but in my view, the current definition of religious and religious beliefs is very broad. And so I think if you are somebody who is associated with an institutional religion, it may not be immediately apparent, but when you've dealt with significant numbers of people who have very idiosyncratic beliefs, I feel that those beliefs would in fact be covered, at least partly because the requirement that the beliefs be in conformity with the tenets of a faith is only that the individual genuinely believes that those beliefs are in conformity. And so it's an extremely subjective definition. I think it is one that will cover an extremely broad range of areas. The other point that I would make about that, no, in the interest of time, let's leave it.
Okay.
Yes,
and look, I'm just on notice, because I'm not sure how much Diversity Council, I did want to ask you about what the impact of this bill would have on workplace harmony and inclusion and what impact that will have, which you gave some good evidence in the Parliamentary Joint Committee hearing last week, which I did want you to share with this committee, but we've run out of time. So perhaps, I don't know, take on notice anything more on that you would like to add to the evidence you've already given.
So, Senator O'Neill, I'm sorry, we do need to finish here. It is after 1 o'clock. Could I ask Senator O'Neill if you could put your question on notice?
Yeah, my question on notice
is,
do you have any insight into the deal that was announced as existing between Ms Martin, Mr Sharma, Ms Bell and Ms Katie Allen they declared, and it was publicised on the 1st of December, that they had a deal with the Attorney-General, acting, one would presume on behalf of the Prime Minister, to make an amendment to Section 38(3) to provide protection for students in schools.
Senator
we don't know the status of that. Do you have any insights? Were you
just
advised
quickly
of
ask
that
a
deal?
question. Could you take that on notice, as Senator O'Neill has indicated? Thank you very much, Senator
And
O'Neill.
Chair, just for
and
I have the Church of Ubuntu,
Senator
an
O'Neill,
image
I
of
just
the
wanted
door.
to acknowledge. Thank you very much, Senator Rice.
I have an image of the Ubuntu Wellness Clinic to which Senator Rice has been referring, and it's a medical cannabis clinic in Newcastle. I'll provide
Thank
a
you,
photo
Senator
for anybody
O'Neill.
who's interested.
Could I thank very much the Diversity Council Australia, Australian Youth Affairs Coalition, Equality Rights Alliance, Harmony Alliance, People with Disability Australia, and the Federation of Ethnic Communities Councils of Australia for your commitment to this inquiry, for your attendance here today, and for your very valuable evidence. It's most appreciated. We will now suspend for lunch and resume at 1:30. Thank you.
We're back on track.
We are back. Good afternoon and welcome back. The committee is now in session, and I'd like to welcome representatives of the Australian Industry Group and the Australian Chamber of Commerce and Industry. Thank you so much for taking time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submission 69 and 133 respectively. For the Hansard record, would you each please state your full name and the capacity in which you appear today, including whether you wish to make any corrections to your submission? So firstly to AIG.
Yes, good afternoon. Stephen Smith, Head of National Workplace Relations Policy of AI Group, and we don't need to make any corrections. Thank you.
Thank you very much, Mr Smith, and to the ACCI.
Thank you, Chair. Scott Barklam. I'm Director Workplace Relations with ACCI. We have one minor correction. In recommendation 10 on page 17 of our submission, there is a reference to proposed section 38. In reality, that should be proposed section 39 when we went and re-looked at it today. Thank you.
Thank you very much. And Mr
Simon
Farrow?
Thank you very much, Chair. Simon Farrow, Advisor of Workplace Relations at the Australian Chamber of Commerce and Industry.
Thank you very much, Mr Farrow. Would either of you either group like to make an opening statement of no more than 1 minute?
Yes, thank you, Chair. AI Group supports freedom of religion. For employers and employees, the bill is an improvement on the 2 exposure drafts, and we acknowledge that the government has sought to address the concerns that we've raised and others raised about aspects of those exposure drafts. Our primary concern was in relation to the combined operation of the statement of belief provisions and restrictions on employer conduct rules. The conduct provisions have been removed, but the statement of belief provisions have been retained. Our preferred position is that section 12 of the bill would be removed completely, excising the statement of belief provisions. But if that's not achievable, it's very important that an additional defence is included in section 39 of the bill to enable employers to take reasonable management action to deal with unreasonable religious activity in the workplace. And we proposed an appropriate amendment in our submission. The words that we've proposed come from the anti-bullying provisions in the Fair Work Act, and they would allow employers to take reasonable management action in a reasonable manner. And under those provisions, that type of reasonable action is not bullying. Similarly, action that an employer might need to take to deal with any unreasonable activity relating to religion in the workplace should not be seen as anti-discrimination, or should not be seen as discrimination.
Mr Smith, thank you. We are over time, so thank you so much. To the ACCI for your opening statement.
Thank you, Chair. We might send the opening statement we were preparing, if that's acceptable,
Of course.
in the interest of time. Very briefly, 10 recommendations from us. We don't carry instructions on the educational hiring or employment by religious institutions matters, which a number of other witnesses have gone to. We don't oppose passage of the bill subject to the recommendations, and we share the concerns of our colleagues from AI Group. And finally, just an observation, we've been listening all day. There's very little interaction or very little input you've got from duty holders, from those who comply with this legislation. So we commend our submissions and input today to senators on that basis. And thank you, and we look forward to questions.
Thank you very much, Mr Barclam. I will firstly go to Senator Bragg.
Okay, thanks very much, Chair. Good afternoon. Mr Smith, you said that you thought that the statement of belief should be deleted from the legislation. Can you explain why, please?
There are a number of problems, Senator, with those provisions. As you know, statement of belief in the bill is a very broad concept, and the two aspects to the particular provision in section 12. One is that it expressly overrides a long list of other anti-discrimination legislation. So in effect, it is putting religious beliefs ahead of a lot of other rights that people have under other anti-discrimination legislation. So that's one issue of concern. The second issue is the exclusions in that provision, which talk about behaviour that is malicious or it threatens, intimidates or vilifies. Now, all four of those concepts set a very high bar. There's all sorts of other behaviour that may be unreasonable, harassing in various ways that would not meet the definitions of those four provisions. So we think the bill would be much better if section 12 was removed completely.
Okay, thank you, Mr Smith. Can I ask you, Mr Barclam or Mr Farrow, whether or not you shared the AI Group's position on the statement of belief, and if so, why?
Thank you, Senator. I'll give that to Mr Farrow.
Thank you very much, Senator. Our position at ACCI is not to remove Clause 12, but rather supporting Australian Industry Group's recommendation to add an additional exemption to Clause 39, which would, as Mr Smith outlined in his opening statement, allow employers to take reasonable management action in a reasonable manner without that conduct constituting religious discrimination. The interaction between Clause 12 and Clause 19, which is the discrimination at work provision, is somewhat opaque, and we do have some concern about it, particularly whether, although Clause 12 protects statements of beliefs from not in and of themselves constituting discrimination, there remains a question as to whether stating those beliefs therefore constitutes holding a religious belief or engaging in a religious activity, which is obviously the operative provision, the operative sort of phrase in a lot of clauses in the rest of the bill, including the discrimination in work clauses. So we do have some concerns around circumstances where there might be, although the statement of belief by the religious observer is protected and is not religious discrimination, whether actually action taken in response to that statement can constitute discrimination. The hypothetical that you might think about is if an employee regularly attends weekly office meetings and makes a statement which they base on religious beliefs that perhaps all women should be obedient to men, and he continuously makes this sort of statement, justifying this on religious grounds. While he might not be therefore held liable for discrimination, we have concern as to whether if the employer were then to discipline or ultimately lead to the dismissal of that employee, whether that would constitute religious discrimination in the under the bill. So we support AI Group's recommendation, adding an exemption as reflects the anti-bullying provisions of the Fair Work Act.
Okay, last question from me. Are there any other examples that you can provide the committee to flesh out your concern about how this could work or frankly be unworkable in the workplace?
Well, thank you, Senator. I might sort of refer to some of the scenarios that were outlined. I know before the joint committee that was looking into the bill as well, where, and I'm sure your committee has discussed this extensively as well throughout your hearings, where there's the common scenario which is laid out about employees trying to proselytise or evangelise other employees by distributing religious material or that sort of thing. And that's why we feel like this sort of exemption, not only in response to Clause 12, but also more generally would provide sufficient protection for employers by enabling them to actually take reasonable management action in a reasonable manner using that sort of double objective test.
Sorry, just to understand. So is this example where someone comes to work and regularly provides pamphlets?
Yes.
Right.
Yes,
and,
exactly. Puts them on the desk of another employee. Perhaps.
Right. And are you concerned that could be permissible under this bill?
We're more concerned about whether action taken by employers in response to that, by, for example, telling them, don't do that.
Right.
We don't accept that in our workplace. We're more concerned about that action than constituting religious discrimination.
Okay. Very, very helpful. Thank you. Thank you, Chair.
Thank you very much, Senator Bragg. Now over to Senator Scarr.
Thank you very much, Chair. And just in relation to Mr Barclay's point about considering the obligations on the holders of duties, if I can give you some comfort, I was in the in-house legal department of Mount Isa Mines when the Queensland Anti-Discrimination Act was introduced in 1994. Having been a general counsel of a company with nearly 4,000 employees in 5 different jurisdictions, I understand exactly the point you make, and it's a very important one. Mr Farrow, I'd just like to tease out this issue in terms of reasonable management, because I think it's very important. I'm very attracted to the proposition, because when I looked at a lot of these scenarios that have been put up in terms of statements of belief, I thought, well, an employee should not be proselytising at work, and I think it is quite reasonable for an employer to say, I have hired you to be a barista or to serve coffee, I've hired you to be a diesel fitter, I've hired you to be X, Y, Z. I haven't hired you to proselytise during my work time. And in fact, that can cause me issues in terms of the employee environment and social cohesion of my workforce. And I've worked with workforces which have come of all religions. And it really is important that that social cohesion is important. So is that generally the thrust of the point, that employers need a reasonable opportunity to make sure that religion doesn't become a point of some sort of animosity or concern amongst employees, and you keep a united workforce working towards a common goal?
Thank you, Senator. I think that's exactly right. It's about cultivating a sort of cohesive workplace environment, and this sort of exemption would go a long way to enable employers to ensure that. It really is about balancing a lot of different, sort of important considerations here, both, of course, the religious beliefs and activities of the religious person, but also the sensitivities of everybody else in the workplace.
Exactly. Sorry to interrupt. We've only got a short amount of time, and I've got 2 other quick areas I want to cover.
Of course.
So there is a difference, though, isn't there, between sort of the example that's given of an employee putting religious material on everyone's desk, and they keep doing that, notwithstanding what I would consider a reasonable management direction. No, that is not something that's permitted in our workforce. There's a difference between that and when you have the incidental conversations around subjects, say in the lunchroom, and the example given in the explanatory memorandum is someone talks about what are you doing at Christmas, and someone says maybe, well, I don't believe in Christmas, so it's every other day of the year for me. It just seems to me that's a lower level sort of incidental comment that wouldn't be of great concern for most employers. And if it did arise and someone objected, you'd simply quietly sit down with the relevant people and say, look, this person has this view. We just need to make sure that we can accommodate everyone in the workforce and maintain that social cohesion in the workforce. Is that
Senator, I might answer you there if I might, and Mr. Smith may also have something to add if Simon doesn't mind. Absolutely. It's exactly that. Look at the reasonableness and the intent and practicality and common sense was what we were on about all the way through in our submission. And I think that's exactly the point. People are interested in discussing these issues. One point which has struck us is that in an increasingly diverse community, and I did look at some ABS statistics about growing diversity of religiosity across the country, including a couple interesting I hadn't heard of, which are becoming important. There's more grounds for a reasonable person to fall into potential offence here, and for an employer not to be able to have any idea that that could occur, and not really shouldn't be assuming responsibilities or liabilities, but dealing practically with workplace disputes reasonably. That's why we're indebted to our AI group colleagues for the suggestion at paragraph 39.
Okay. Can I move on to another subject quickly, and that is reasonable adjustments. So let me provide you a scenario.
Just 3 minutes to go. Thank you, Senator Scott.
I know, I'm watching, Chair.
Thank you.
So assume you're a large employer. You've got thousands of employees, and I work for a mining company. We had 3,500 people at 2 mine sites. Some of our staff were from Indonesia, of the Muslim faith, and therefore, obviously, there's an issue with respect to prayers, say, at a Friday. From my perspective, I think it is reasonable, provided it can be done without compromising legitimate operational issues, etc., for a business to do their best to try and accommodate those religious moral obligations that your staff have, whilst also ensuring that the work is done at the workplace. Could we entertain a reasonable adjustments clause in the context of this legislation? What do you think?
Senator, I'm happy to tackle that one from our group's perspective. We don't believe that it is necessary to put a specific provision in this legislation, like, for example, is in the discrimination legislation relating to disability. But those provisions are very complex, and yes, they're long-standing, but in this case, in terms of religious belief and religious activity, the legislation outlaws direct and indirect discrimination. We don't think that it needs another very significant concept in there around reasonable adjustments.
So Mr. Smith, I think the observation you're making that covers direct and indirect discrimination means that there comes with that an understanding that you're going to discriminate maybe against people of the Muslim faith if you require them to be at an office meeting on Friday afternoon, and that's the only opportunity. So my concern can be met through the indirect discrimination aspect of the bill and what an employer is obliged to do.
Standard provision.
Is that correct?
Yes, exactly, Senator. The indirect discrimination provisions deal with that issue squarely, and we don't need that other whole regime around reasonable adjustments specifically, like is in a minority of other legislation.
Okay, that's the end of my time. So 12
well done, Senator Scarr. A gold star for you. Thank you. I'll now give the call to Senator O'Neill.
Oh, thank you very much. The time is limited, as we've said. Are there any additional key concerns, further to what has been noted this afternoon already, for Australian businesses that you want to put on the record with regard to these bills? Because you had very truncated opening statements. Mr. Smith?
Senator, there's nothing that's not in our submission. So, identified the key concerns. But, there's another issue that we haven't talked about in any detail about the overriding of other anti-discrimination legislation. But if Section 12 was to be removed, then the provisions in Section 12 that do that would also be removed. If it's just a matter of getting the additional defence for reasonable management action, then we still do have a concern about the fact that this bill does expressly override other anti-discrimination legislation.
Senator, I might jump in there too, just for
Thank you.
completeness, and say we have 10 recommendations,
Yes.
9 of which address the detail of the bill. One particular one, recommendation 9, is about the absence of a definition of religion.
That's
know
the part
this is
I've
an
marked up in my
exceptionally
document to ask you questions about, because I think we've had evidence this morning that the definition of religion is somewhat ambiguous, and I think your submission fills that out quite carefully. I note in particular paragraph 99, where you talk about what you seek to minimise in terms of workplace conflict. So very keen to hear your views on that.
Well, I think in essence, Senator, it is that religion's changing markedly. I made the point. We've identified 2 particular issues where Australia's changing significantly. One is that we've got obviously more diverse community coming from different places in the world that bring religions that a lot of Australians wouldn't have encountered before, the precepts of which might not be known to people. The other one is,
Are you
of course,
referring to particular religions there that you can name?
Oh, well, I'll give you an example, and I want to get these words carefully. There is the Ubuntu, the one that was mentioned earlier, the wellness clinic. But
yes, I've just sent Senator Rice a picture of their wellness clinic.
Well, but and I want to get this right, and I'll check with the Hansard people. There's also Ubuntu, which is the Zulu religion that a number of people from Southern Africa are bringing to Australia, which is a religion of many thousands of years standing, as I understand it.
Okay.
So both of which, they capture the 2 areas of change here. New spiritual practices and wellness and things that are very difficult for any employer or any peers to understand in religious observance, but also, new cultural practices that are not things that people may have grown up with around them. Both of which raise the sort of practical concerns about time at work, about directions, about duties, and the like. So we think it would be useful. We think some of the High Court cases point to complexity in these areas, but it would be useful to add a definition. But we don't, on balance, say that this legislation shouldn't pass without one. But we think it may what will prove to be an area of potentially unfinished business and guidance. The one final thing I'll say, because I am aware of the time, is that the new infrastructure around this isn't just about litigation. There's also promotion and supporting materials. So those who are charged after the passage of the legislation may be able to provide practical guidance on how to assess and deal with and listen to people about their religious observance and the things that they bring to work that may be legitimate.
Thank you very much, and I note that you make very clearly the point that small business owners who will be subject to these laws cannot be expected to rely on authority from case law that is largely unfamiliar. So that, small businesses in a world of pain, they are going to need support if this bill passes in its current or amended form to manage their responsibilities in a way that meets the test of the law and enhances cohesion in the community. With regard to the final report of this committee, are there any particular recommendations that you think we need to make in addition to those that have been considered in your submissions? Is there anything further you think we need to put in?
Well, I'll only pass this back. I'll make a brief comment, then pass it back to Mr. Smith. But the only thing that we didn't address that we think has some appeal is AI Group's point about the statements of belief. And in particular, as Mr. Farrow said, the alternative with an amendment to 39. But with that, Senator, I'll pass it back to Mr. Smith and see if he has anything he wants to add.
Nothing further from me, Senator, but ACCI's submission does deal with a range of discrete technical issues that we concur with. So between the 2 submissions, there's a comprehensive set of recommendations there for how this bill could be made more workable.
Can I ask if you heard any of the submissions of the Human Rights Commission, the Australian Human Rights Commission, last week?
I didn't, Senator. I did listen to some of the hearings last week, but I didn't listen to that one.
And likewise, Senator.
Okay, so you may need to take this one on notice. The Human Rights Commission evidence I think was quite interesting. Could you just have a look at some of their comments really around Section 12, which you've indicated you want removed, and give us your view on that? And in light of that also, could I ask you to have a look at the concerns that are raised in Submission 47 to the Parliamentary Joint Committee on Human Rights by Professor Toomey, which go to the constitutionality of the bill, and also the corrective to that was advanced yesterday by Professor Aroni in his submission. And at Appendix B, he suggests redrafting of clauses 11 and 12 to overcome the uncertainty of this bill potentially being unconstitutional. And the reason I ask you, even though you're not lawyers, is that any uncertainty in the context of business practice always means cost and delay. And we can ill afford that given the pressures in the economy at the moment and the pressures on businesses. And I particularly think of small businesses in regional parts of the country that I know that you represent with vigour. So if you could take those on notice, that would be important. I note that you also, in the Chamber of Commerce and Industry submission, call for this committee to tackle the ambitious reform needed. And that is a suggestion made by a number of entities, indeed today, that a single national framework of anti-discrimination law is required in Australia. You know, Labor have that position. I know that Nicola Roxon, as the Attorney General, attempted to do this. Why do you, as leaders of business in Australia and representatives of businesses, think that it's achievable, desirable, and are you proposing a law reform process as an alternative to this bill or supplementary to this bill?
Thank you, Senator. I'll take the last of those questions first. Our recommendation 1 is a reference to the MAG, the Meetings of Attorney General, as to mechanisms to address this, which can occur after or simultaneous with the passage of this bill. So we're certainly not advancing this as an alternative to the need to, or the professed reasons for addressing this legislative challenge. So no, we think it's a longer term process, and we wouldn't want to delay the basis on which this has been brought forward. Why do we say it? Primarily motivated by our experience in the workplace relations field and seeing the benefits, even though we're key critics of the workplace relations system, the one thing that was done well, and it was done well under both Labor and the Coalition, is to move to a genuinely national system, to enable employers to provide and manage nationally consistent standards across borders, and to support HR policies, the things that aren't written into law, by a consistency of the law in workplaces. So we also, and I'll be very frank, we don't like being forum shopped. We'd prefer to have a single national system which was consistently applied. One of the things we think has been revealed by the bill are minor inconsistencies between the various ground-specific pieces of legislation. We have a historic understanding of why they're there, but we don't think that's necessarily a good legal construction, which is why your party has it in its national platform to move differently. But I think I'm
very impressed that you've read it that closely, and I appreciate the interest in it.
But can I just make one point though? We're not just talking about a single act to cover all the grounds federally. We would be talking about removing the state legislation and tribunals and moving to a single national system. Now, what was done, and this is a very ancient history, but years and years ago we had separate state-based statistical bodies that became the ABS. We're not talking about, mass redundancies of state tribunals. We're talking about a system of harmonisation or nationalisation that would see those state infrastructures and anti-discrimination communities become state branches of an expanded federal institution and federal legislation.
Thank you very much. Could I ask if the Australian Industry Group supports the position that's just been put there?
Senator, if I could just clarify one thing that you said earlier. I am a practicing lawyer with AR Group Workplace Lawyers, just for the record. But on the issue of that exercise when Labor was in power last
Sorry, Mr. Smith, could you say that again? I couldn't quite hear your question.
Yes, I just clarified that I am a practicing lawyer, just in response to your other issue. But when with that reform exercise that you mentioned with then Attorney General Roxon, we were heavily involved in that, and it became very complex because there are the 4 federal pieces of anti-discrimination legislation, and it looked to us like if there was to be an outcome, it would have been a big levelling up exercise on all of the discrete issues. So that was one issue of concern. There's also the fact that the state legislation covers a lot of protected attributes that aren't in the 4 pieces of federal legislation. And there are also some very complicated constitutional issues about enforcement at the federal level. So after that exercise that I was heavily involved in, we came to the view that it's unworkable, but a very worthwhile and noble objective, but unachievable. So we're certainly not pushing for it to be
All right.
to be
Senator
clear,
O'Neill, we will need to move to Senator Pratt because
yes,
we are.
I'm for clarity, are they separate views so that you are not in agreement on this matter?
We agree with the objective, but we don't think it's achievable at any time in the foreseeable.
Thanks, Senator O'Neill. Senator Pratt.
Thank you. Just quickly, I wanted to jump to the extent to which the standard discrimination law that deals with direct discrimination and indirect, and therefore the inherent requirements of a job and how you meet those tests, the extent to which an existing discrimination law that enables someone to be protected in their visibility and their free speech at work. Gay people can talk about what they did on the weekend. Unmarried people can talk about the fact that they're nevertheless having a baby. But if, for example, someone wants to put a pamphlet on everyone's desk telling them to go to Mardi Gras, and that the current protections for sexuality don't enable someone, don't exclude someone from being subject to reasonable management action, do they?
No.
So in that context, is there any need for a proposed amendment to Section 39? What would it change in the workplace as far as you could either amend Section 39, give it an exception in relation to a workplace exception in relation to statements of belief, or you could just not have that section of statements of belief that so many others have suggested. Can you respond to that, please?
Yes, Senator, I'm happy to make some comments. The difference between this piece of legislation and others is that the concept of religious activity and the making of a statement of belief is quite different to a law that protects against direct and indirect discrimination on the basis of age or disability or race, etc. It goes to conduct, and therefore
others said that it's not, because there's conduct inherent to the other attribute. But anyway, I'll hear you out because I'm the one asking the question.
Yes, so we think if Section 12 was removed completely, then there's less need for the added defence. But if Section 12 stays, then this concept of reasonable management action has worked very well in the anti-bullying jurisdiction, and we think it can be readily adopted here, and it'll work very well here as well.
Why in that context should community why should just business get it? Why should not all the other organisations that have asked for this because of similar concerns in their organisations not get it too?
Senator, our analysis of the bill is related to employees and workplaces. So we're not suggesting that wouldn't be useful elsewhere, but we haven't turned our mind to those issues.
No, that's helpful. You're not suggesting it wouldn't be helpful elsewhere. Is indeed a helpful statement. So to what extent does it make it easier in terms of, I realise there are some inherent differences in terms of the types of adjustments needed for different attributes that might be reasonable, but does it make it more efficient and easier for employers if we have fairly standardised anti-discrimination law?
Senator Pratt, can we make that your last question, please?
Yes, Chair.
Thanks.
Yes, very briefly from me, Senator. Yes, consistency is very useful, but we do have the 4 pieces of legislation at the moment that aren't consistent at the federal level, and now this is a 5th one, and certainly the state legislation is not consistent either, but consistency is useful. It's a complete web of tangled state and federal laws at the moment in this area.
If I might, Senator, just briefly to jump in there, we very much share that view, and just to clarify before, I'd like to associate us with the clarifying statements of Mr Smith about consistency not necessarily being the highest common denominator or extending scope. That certainly wasn't our intention of talking about the benefits there.
All right, Senator
Chair.
Pratt, we will leave it at that. Thank you so much. I'll now give the call to Senator Rice.
Thank you. Thanks, Chair. Look, I'll start with the AI group. In your concluding paragraph in your submission, you say that the bill requires further amendments to achieve the apparent policy intent that employers can take reasonable management action in a reasonable manner to address inappropriate conduct in the workplace. So can I just confirm then that that means that you would not support the passage of this bill in its current form?
We don't support the bill in its current form, but we recognise this has been a long-standing policy position of the government, so we're not opposing a bill in this space, but we do think the bill needs to be amended to make it workable for workplaces.
And you know, consistent with the discussion we've just been having about the sort of complexity and overlapping legislation, do you think having a piece of legislation that was, as has been described, sort of more orthodox legislation, sort of along the lines of our other anti-discrimination legislation at a federal level, would you would be more likely to support?
Yes, this legislation can be fairly readily modified to make it a more traditional form of anti-discrimination legislation. There's only a gap, as we know, in South Australia and in New South Wales at the moment in this area of religious discrimination. So the gap could be filled at the state level, but if it's going to be level, it should be more traditional in its terms.
We had some discussion at the hearing last week in the Parliamentary Joint Committee hearing when you appeared with the Diversity Council on the impact of the statements of belief of Clause 12 on workplace inclusion and sort of workplace harmony, and the Diversity Council were able to give quite a bit of evidence then about sort of what the impacts on not having that an inclusive workplace meant. Unfortunately, we ran out of time to hear from the Diversity Council on that issue this morning, but I just wondered whether you would be able to comment on what the impacts of that lack of, you know, having the problems if you don't have inclusive workplaces.
Yes, certainly, and in the Diversity Council submissions, they refer to a lot of evidence of the benefits for businesses and employees of having diverse and inclusive workplaces, and we very much agree with that. We have a very significant focus within AI Group with our members on helping them to achieve diverse and inclusive workplaces. So I don't think anyone could argue that that isn't beneficial all around, and we're keen to make sure this bill doesn't disturb that.
And certainly you feel that at the moment, as drafted, that Clause 12 in the Statements of Belief would disturb that?
That's our concern, yes.
Yes. To the Chamber of Commerce and Industry, similarly, you've got, you know, outline a range of recommendations, a range of amendments and things that you think need to be changed in the bill. So can I just confirm that you also don't support the passage of the bill in its current form?
We call for amendments to the bill, Senator. They are commended to the government and to this committee more immediately as practical improvements to it. We don't necessarily have a headline for or against, but we think there are, as we put in the front of our submission, practical, common sense, usable, applicable. We think that improvements can be made.
Thank you. And in your opening statement, you didn't go through all of your 10 recommendations. Are there some of those other recommendations that you haven't had a chance to talk to yet that you'd like to expand on? Yeah.
Look, thank you for that, Senator. And what I might do is ask my colleague, Mr. Farrow, to just also have a think about this again as well. Our first recommendation is this big picture question about more fundamental reform. Putting that to one side, we deal with the expression of the inherent requirements, and we've gone back to look at the International Labour Organisation Convention 111, where that concept comes from, and there's the omission of the word particular from the requirements of the particular job or particular position. The word that's been used here is particular employment, which we're a bit concerned about the difference of compared to other pieces of legislation, and there's, I think, a High Court reference there from Justice McHugh to go to that's not a meaningless distinction. We also have some discussions about vicarious liability. Generally, a lot of our messages there are about what we can know and what we can control, and what's practical and reasonable for us to receive responsibility for those exercising agency on our behalf. We have some suggested measures when it comes to subclause 14.2 on the reasonable conditions, requirements and practices. And if I can make an observation there, they're all very applicant contingent, where what our members experience is the need to try and manage for diverse workplaces, to try and comply with legislation and the requirements upon us. And we'd like those to be expressly reflected in the assessment of what reasonable conditions are for us to do. A couple of the others are fairly small or applied. We did talk about that definition of religion. We do think it's useful, but we would appreciate, or we would recognise that it may not be something that can be done prior to the passage of this legislation, but we do think it would be improved by that. And finally, this is a fairly small sort of piece, but it's important. There's a recognition in here that some acts are undertaken in direct compliance with awards or agreements, and there's a reflection of federal awards and agreements. There is still a residual WA state system for the private sector. So it's a fairly small thing and consistent with the principles of how this has been drawn up to complete and square that off for state instruments as well. Simon, have I missed anything you'd like to add for the Senator there?
No, I think you've covered everything there, Scott, and thank you for the question, Senator. I'm guessing we're running out of time, but I'd definitely emphasise the inherent requirements, recommendations we made, particularly, as Scott mentioned, around the differences between employment and particular position. We'd like to see the same language used, which is in the Fair Work Act, which obviously employers are most familiar with, and noting the High Court's sort of views about the potential divergence of meaning between those two phrases.
Great. Thank you very much. Thanks,
Thank
Chair.
you so much, Senator Rice, and I would like to thank the Australian Industry Group and the Australian Chamber of Commerce and Industry for your participation in this inquiry and for your time and commitment in giving evidence today.
Thank you.
Thank you.
Thanks.
I'm very pleased now to call representatives of the Australian Education Union, the Australian Council of Trade Unions and the Independent Education Union. Thank you so much for giving time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 12, 26 and 98 respectfully. For the Hansard record, could you please state your full name and the capacity in which you appear today, including whether you wish to make any corrections to your submissions? The AEU.
Yes, thanks for the welcome, Senator. Susan Hopgood, Federal Secretary of the Australian Education Union, and we don't wish to make any additions or deletions to our submission.
Thank you. The ACTU.
Thank you, Senator. Liam O'Brien, Assistant Secretary of the ACTU. I'm also joined by Sophie Ismail.
I'm wondering whether each person could introduce themselves with the capacity in which they appear, please.
Good afternoon, Senator. Laurie Sharp, Acting Federal Secretary of the Australian Nursing and Midwifery Federation.
Yes, my name is Anthony Odgers, the Assistant Federal.
And Ms. Ismail?
Thank you, Chair. Sorry, Anthony.
We're not hearing from Ms. Ismail. We've got a few connection issues. Mr. Odgers? Is it Mr. Odgers, could I ask you to turn off your video because you've got a poor connection and just use your audio. Dr. Peters?
Yeah, that better?
Thank you. Micah Peters, National Policy Research Advisor of the Australian Nursing and Midwifery Federation.
Thank you. And do we have Ms. Ismail on the line?
Yes, Chair, I'm hoping you can hear me now.
Yes, I can indeed.
Apologies for that. My name's Sophie Ismail for the ACTU. Thank you.
And your capacity, your role?
Legal and Industrial Officer, Gender Equity.
Thank you so much. I would now invite you to each make a 1-minute opening statement, and I do need to ask you to limit it to 1 minute, please. Firstly, to the AU.
Look, thanks, but I think if you don't mind, Senator, I think we would like the ACTU to begin.
Of course. I'll now ask the ACTU to make an opening statement.
Thank you, Senator, and thank you, Susan. I might make a few brief remarks and then obviously hand to my colleagues to also make a few brief remarks. If I can just start by thanking the committee and the chair for the opportunity to make the submissions. We believe every worker in this country has an equal right to safe, healthy and respectful work. This means work that is free from discrimination on the grounds of race, sexual orientation, sex, gender identity, disability, or any other personal attribute, including on the grounds of somebody's religion. Australian unions have got a strong interest in an effective anti-discrimination human rights framework. Majority of complaints made under this framework relate to employment, and work is fundamental to who we are, and it must be recognised that due to the power imbalance in workplaces, that workers are particularly vulnerable to exploitation and discrimination. To the extent that this bill facilitates the protection of someone's religion, it is supported by the Australian Union Movement. These provisions are not controversial, and whilst in many states in Australia we have protections on the grounds of religion, the addition at a federal level is also supported.
Mr. O'Brien, thank you. Sorry, Mr. O'Brien, we will need to leave it there at strictly 1 minute. Can I invite the Independent Education Union of Australia to make an opening statement?
Yes, thank you, Chair. Can you hear me?
Yes, I can indeed.
Thank you. It would have been a simple matter legislatively for the Parliament to have added religion as an attribute to federal anti-discrimination law. Instead, this bill has conflated that object with others. This bill isn't supported by school principals in independent schools per their representatives from AHESA, or by the considerable majority of faith-based school communities. That opposition isn't because the bill's poorly drafted and key provisions depend on regulations yet to be drafted. It isn't because the bill actually proposes to extinguish religious freedoms for some, and it's not just because it proposes to override modern state legislation that enjoys overwhelming support in the general community. The primary reason this bill won't have support from faith-based school communities, where our members and their families are at the core, is that those communities don't believe that basic individual freedoms guaranteed by law, for example, the right to marry or not and to have children, should be subordinated to an institution's rights in employment.
Thank you very much, Mr. Odgers. I will now go to senators for questions, and we'll start with Senator.
I'm sorry, Senator.
Yes.
Sorry, it's Lorianne. While I deferred to the ACTU, I would still.
I apologise.
And so, and I understand that Lorianne would also like to.
No, we're only taking an opening statement from each organisation. So I would invite you to make your opening statement now, Ms Hopgood.
Okay, thanks very much. So look, obviously I wish to supplement the submission that we have already made and which you have made. And I wish to make 2 points. Firstly, Bill's legislation of discriminatory statements of belief complicates protections against discrimination in public sector education settings. And just to ensure everybody understands, the AEU represents those in public schools, TAFE and early childhood. The anti-discrimination provisions in public sector education settings, enterprise agreements and education policies variously refer to Commonwealth, state and territory anti-discrimination laws as their foundational legal framework. And the fact that the bill overrides such anti-discrimination laws confuses and complicates a large number of these matters. Secondly, the proper regulation of the teaching profession will be undermined by the bill, we believe, and will expose students and colleagues to significant harm. Currently, a teacher's discriminatory statements, both inside and outside of the course of their practicing teaching, is a relevant factor for a regulator to determine whether the person should be regarded, should be given ongoing permission to be a teacher.
Thank you. Look, I'm going to have to
50.
leave. You have gone over time, I'm sorry, so I'm going to have to leave it there. I'm now going to hand over to senators to ask questions, and I give the call to Senator Pratt.
Thank you very much, Chair. Because we've got little time, I want to ask quickly, how would you like to see this bill amended in order to address the concerns of unions so that we can provide the protection for religion, which is currently an unprotected attribute?
Anyone in particular, or just?
I'll start with the ACTU.
Great. Thank you, Senator. So as I was saying before, all the sections of these bills that are inconsistent with existing anti-discrimination laws should be removed. That is because, as I was saying before, protecting religion as an attribute is a relatively simple task, and to the extent that this bill does that, it's supported. However, this bill goes significantly further than that, and it will actually increase discrimination in workplaces and in many respects create the preconditions for harassment. So we say that really starting, first and foremost, we should remove all of those provisions that are inconsistent with existing anti-discrimination laws. I might defer to some of my colleagues to also add some remarks on this. Laurie Ann, would you like to?
Yeah. Thank you, Chair, and thank you, Senator Pratt. We have 3 main concerns with this bill, and they include the intersection with our regulatory bodies, which is the Nursing and Midwifery Board of Australia. We also have concerns that it will allow religious hospitals and aged care facilities the right to discriminate again based on employment, and we also have major concerns with the adverse specific health impacts on gender and sexually diverse people that this will have. I just want to make a point because I didn't get to make it in the opening statement, but just from the onset, the ANMF wish to be clear that they're not anti-religion and that we believe in freedom of faith. We just don't believe that faith is a justification to discriminate. And I also would like to make the point that that I think it's extraordinary that and I'm quite frustrated that we're having this conversation at this time, considering the amount of pressure that our workforce are under on the front line. We see that some of the amendments to this bill that's been made in the third iteration are only going to make that worse for our members, trying to deliver healthcare to all. So that's quite frustrating. I'm happy to talk in more detail about the interaction with professional standards, and my colleague Dr. Peters can talk about some of the health impacts as well. So one of the core concerns around this bill is that it will hinder the work of our regulatory bodies. And as you all know, our regulatory bodies exist there so that the public have confidence in the professions. And the effect of the Section 15 place both registered practitioners and bodies in undesirable and awkward position.
I'm sorry, Chair. I'm sorry, Chair. Your typing is knocking out the speakers.
Oh, apologies. Thank you, Senator Pratt.
My apologies for needing to fix that.
Thank you.
So we give the example of
some
the
timing instructions, but that's okay. Thank you.
Okay. So in Australia, nurses and midwives adhere to a wide range of professional standards and codes of conduct. We operate by ethical frameworks, and that's regardless of whether we are in a paid position or an unpaid position. So we might be volunteering, we might be out in a social setting, or we might be working. We are concerned that this bill will allow health professionals to say things based on religious beliefs that could be discriminatory and harmful to those of potentially different sexual orientations. Now, this would be very difficult for our regulatory body to be able to discipline the health professional on these grounds when we have a religious discrimination bill of this nature. We do give the example in our submission of the vaccines and the very harm and detrimental public health consequences that could have if there was anti-vaccine sentiment within the community based on someone's religious beliefs, particularly when we are experiencing a global pandemic. My other concern with this bill is that we're worried that aged care facilities that are faith-based and hospitals that are faith-based could potentially discriminate against future employees based on their belief or their lack of belief. Now, just to give you an example of aged care, when just this week we've been calling on the federal government to call in the Army to assist because they are so incredibly short-staffed with only in some instances, 2 nurses to 120 residents, we see that this could further discriminate, this could further inhibit the ability to be able to employ workers in this sector. We've had chronic understaffing, and we can't be having anything that would be an inhibitor further to employment in this sector. So I think the third consideration for this bill that talks to our concern is around the health impacts, and I'm just going to hand over to Dr. Peters to give some brief examples of that, if you don't mind.
I was going to come to those questions. I asked a different question, and I wanted to get to the bottom of how the bill needed to be amended. I do want to hear from Mr. Peters. Can I ask unions? You've said you would support a more orthodox version of anti-discrimination. Australian Industry Group said that if Section 39 were to go ahead in terms of statements of belief, that they would ask for an exception for reasonable management action so that they could discipline an employee if the inherent requirements of the job weren't available to them in order to constrain someone's action in a workplace from, putting pamphlets on someone else's desk consistently. What I wanted to ask the ACTU would be the limits of that in terms of protecting workers from potential statements of belief that might be inappropriate for other workers. For example, if that statement of belief was made by a patron, and how that intersection, how the protection that the Australian Industry Group has suggested won't necessarily work for all circumstances in workplaces. Thank you.
Thanks, Senator. I might start and then invite Sophie Ismail to add to this. We wouldn't see that as sufficient. The first thing to understand about the statement of beliefs is it prevents workers from bringing complaints to tribunals. So merely dealing with, any constraint that an employer might have is only one part of the problem in terms of creating a safe workplace free from discrimination. So we would say that we would not go far enough, and that we need to ensure that statements of belief are not precluding workers from bringing complaints about others in the workplace who are discriminating against them. I might further defer to Sophie, though, to add.
Thanks, Liam. Thanks for your question, Senator. I mean, part of the problem with this rushed process is that we haven't had chance to properly consider the amendments that the employer parties have put forward. But as Liam has mentioned, amendments to Section 39 don't deal with the problem sufficiently. The employer parties have said there's a range of amendments that they want to the bill, and we're saying there's a range of further amendments that are needed to properly protect employees in workplaces. So we think the statement of belief provision should go entirely.
On that note, could I ask you to take that consideration in relation to the employer's response on notice, and there is an opportunity to further consider their position and provide us as a committee with any further feedback or response. Thank you. Senator Pratt, back to you.
Thank you. Can I ask also in that context, to what extent orthodox anti-discrimination law provides for resolutions of those issues and for visibility in the workplace for religious belief, sexual orientation, marital status? You know, there's an inherent visibility that comes from a protected attribute that pretty much stops as soon as you start to interfere with productivity in the workplace or you become harassing or menacing to someone else. Is that not correct in how I've presented that?
Well, Senator, we think there are a range of problems with existing anti-discrimination or the exemptions that currently exist that need reviewing. And so part of the
I understand, putting the exemptions aside, when the exemptions aren't in place, as a whole, employers that have to deal with the whole range of protected attributes in their workplace, how does that provide that protection for visibility in the workplace?
Well, a usual anti-discrimination statute protects the attribute, and you're protected to the extent that you don't trample over other people's rights. And what we're saying is that bill protects religion over and above that. It gives the attribute of religious belief special treatment to the point where you're allowed under this bill to trample over other people's rights. And we're saying that needs to be wound back, and religion needs to be treated like every other attribute, age, sex, the other attributes. And you're permitted to practice and manifest your religious beliefs to the extent that that doesn't hurt and harm other people.
Thank you. But with it comes some visibility. For example, you're able to talk about what you did on the weekend and what you actually believe, provided it doesn't harass or menace someone else.
Yes, that's correct.
Thank you. To return to the health issues, I wanted to ask Ms. Sharp if you might be able to review the evidence in one of the last sessions from the Australian Federation of AIDS organisations in terms of some real examples of how statements of belief could make life more complicated for health workers and in particular for vulnerable clients. Mr. Peters, did you want to make further comment on that?
Thanks, Senator Pratt, and thank you to the Chair and Committee for having us appear today. As my colleagues have stated, certainly important to protect people from discrimination on the basis of religion and faith. However, our position is that the bill contains details that go beyond simply protecting people of faith from discrimination on the basis of their beliefs, to affording greater protections for people to be discriminatory towards others in the name of their beliefs. And this, as Lori-Anne said, this coming at a time when the pandemic is already stretching the health and aged care workforces to breaking point. It really couldn't come at a worse time. But in terms of health impact, really it has the effect of setting preconditions for making Australian healthcare and aged care, and indeed the community more broadly, less of a safe space for people, including people who are LGBTIQ and other groups such as women, single mothers, and people of minority faith groups, and it leaves them exposed to the potential for experiencing harmful, hurtful, demeaning and discriminatory statements of belief that aren't covered by the bill as clearly. And so we've got a primary focus on providing safe, best practice care, and elements of the bill are likely to lead to worse health and social outcomes for already vulnerable members of the community who already experience poorer access to healthcare and worse physical and mental health outcomes due to fear of being discriminated against in the context of receiving that care. So substantial research from Australia and around the world have shown that many members of these groups already experience poorer outcomes, including suicide and mental health outcomes, due to historical and ongoing experiences of discrimination that also occurs in the health and aged care context. So this already results in poorer morbidity and mortality outcomes because people feel unsafe and scared of the potential for discrimination and being treated poorly and worse due to gender, sexual orientation, marital status, or not sharing the same faith and belief as their treated staff.
Thank you. So in terms of...
Last question, Senator Pratt.
Thank you. In terms of going to HIV as an example, again, if someone's allowed a license through statements of belief to say things like, it's true that most people have contracted HIV through immoral sexual activity or drug abuse, certainly any form of sexual relations outside marriage causes damage. AIDS, while deadly, is only one expression of that damage. What do you think of, a right to make statements like that as a matter of right without having a broader ability through regulation or through more debate or through, all the processes we may or may not use currently? How does this law privilege a statement like that counter to health and workplace outcomes?
I think statements such as that mean that people might feel fearful to engage with healthcare or aged care because of things like gender and sexual diversity would make a barrier for their engagement with healthcare services and might mean that they don't access screening or treatment when it's required. So
that's right. And what if your employer is of those
Senator
beliefs?
Pratt, I'm going to have to wind you up. I'm sorry.
No, I know, but
just very quickly,
what
please.
if your employer is of that, and this is to the ACTU, what if your employer is of those beliefs and has the right to, therefore has the right to say those things in the workplace? What does that mean for our anti-discrimination laws as they stand now? You won't be able to discriminate against someone in terms of adverse treatment of them in terms of their employment, but you could still make statements like that to your own staff, could you not?
Absolutely. And we agree that that is a real limitation of this bill. And also another reason why the employer amendment probably does not deal with this issue. So actually, we do think there's...
Mr. Ismail, I'm sorry, we're
The
losing...
statement of belief in itself does not...
Dr. Peters, sorry, we're losing your connection. Maybe you could turn your video off.
It's Mr. O'Brien's connection. Chair?
I'm sorry.
Yes,
sorry,
sorry.
Mr. O'Brien,
Mr.
apologies. Sorry, Mr. O'Brien.
I might defer to... That's okay. I might defer to Sophie to finish.
Could you just repeat what you said because we didn't really hear it?
Apologies. Is that a better connection?
Yeah, that's very good. We can hear you loud and clear.
What I was saying before to Senator Pratt was that we agree, and this is, again, what we think might be one of the limitations of what was being put forward by the employer proposed amendments, that if an employer is making these statements, workers have very little recourse. As to the assertion around adverse action, we think there is some genuine grey area here because such statements will not be considered discriminatory and therefore may not be considered adverse action in the workplace. But I might defer to Sophie Ismail to add to that.
Thanks, Liam. And I just wanted to make the point, Senator, I thought you said that perhaps a religious employer couldn't discriminate or treat a staff member adversely, and there are existing exemptions that allow a religious employer to adversely treat a staff member, and we're extremely concerned about those existing exemptions. What this bill will do is entrench and add a further layer on top of those existing exemptions and create a further level of regulatory complexity and unfairness in our laws that we just don't need.
I'm well aware of the exemptions. If that were to happen in a small business, for example, the existing protections where you couldn't sack someone or discriminate against them, nevertheless, you could still be subject to statements like that all day, every day. In them, not, as Mr. O'Brien said, the statement in and of itself doesn't constitute adverse action. Is that correct?
Yes, this will extend out to all workplaces, religious and non-religious, and the statements of belief can be made in all workplaces. That's right.
Senator Pratt, we'll have to leave it there. Thank you so much. I've just got a couple of brief questions and I'll hand over to Senator Rice and Senator O'Neill, but we do need to finish right on 3 o'clock. I want to direct this to the ACTU. In your submission, you claim provisions of the Religious Discrimination Bill will override all existing federal and state anti-discrimination laws to protect people who make discriminatory religious statements of belief, including at work, even if those statements are hostile, offensive, damaging, inappropriate and harmful. The bill explicitly outlines that a statement of belief is not protected if it is malicious or would threaten, intimidate, harass or vilify a person or group. Can I ask why you believe that these safeguards are inadequate? Perhaps to you, Mr. O'Brien.
I might take that. Sorry. I was going to take the response to the question.
Yes, thanks, Ms. Ismail.
Look, our concern with the test, firstly, we don't think that statements of belief should override discrimination law, full stop. We think that that's an unacceptable provision, allowing statements of belief to override other rights. But the test, the way the test is framed, is a very, very high bar. It's very unclear what a statement, what kind of statement will be deemed to be malicious or threatening or vilifying, for example. That's a very high bar. And it leaves a lot of room for a statement, for example, that is hostile or degrading or harmful or humiliating. It leaves a lot of room for a range of very inappropriate and damaging statements to be made that might not meet the threshold of malicious, that might not actually vilify or, meet the high bar in that test. So we're worried that there's a wide range of really damaging and harmful statements that might be permitted by this. But aren't you setting the bar in trying to suggest that we should have laws which prevent inappropriate statements? Aren't you setting the bar too low? I mean, there's no law which prohibits an inappropriate statement. So this is about finding the right balance, isn't it? Well, employers have obligations under workplace health and safety laws to create safe workplaces, and that includes preventing inappropriate and harmful behaviour in workplaces, and that includes inappropriate, harmful and hostile statements. A great example is the Respect at Work report, which found that those kinds of comments at work, hostile, sexist comments at work, create the preconditions for sexual harassment, and that is now an absolute scourge in our workplaces that the government has committed to addressing. What this bill does is opens up the floodgates for these kinds of comments to be made in workplaces that will then lead to, we think, very damaging outcomes for workers and employers and the community at large. If I can just, though, correct you, the Respect at Work recommendations relate to a particular type of conduct. So you're suggesting that there should be a bar which is set so low that any inappropriate statement is deemed to be unlawful, and what I'm putting to you is that the bar is too low, and the ACTU, isn't cognizant of the need to strike the right balance in also ensuring that there is proper religious freedom in the workplace. Well, we support, we don't think any worker should be discriminated against because of their religion. Workers should not be discriminated against on the grounds of their religion unless it's an essential part of their job. What Respect at Work found, though, was that sexual harassment is often accompanied by what is called a hostile work environment. Yeah, look, I won't get bogged down on that. That actually wasn't the point that I was making. But in any event, I just wanted to move on and...
if I can just add...
If I could just move on, because we've got fairly limited time. Consistent with existing Commonwealth anti-discrimination laws and subject to a number of exceptions, the Religious Discrimination Bill does not override or interfere with state or territory legislation. Clause 68 explicitly provides that this bill is not intended to exclude or limit the operation of a state or territory law to the extent that the law is capable of operating concurrently with the bill. So can you explain why you hold such concerns? And that's again to the ACTU.
Well, there are two provisions in the bill that explicitly allow for an override of state and territory law by regulation. One is in relation to the statements of belief and one is in relation to the exemptions. And then there is, you're correct, a further provision that says any laws that are in, that must operate concurrently. But it's very unclear how laws will operate concurrently with this Act, where there are, for example, now 3 different layers of religious exemptions in the Fair Work Act, in the Sex Discrimination Act, and now in this Act that are slightly different in scope, slightly different in their impact. It's very unclear how those are going to operate concurrently and how employers are going to navigate this.
Yeah, but that will ultimately be a matter for the courts, as it is obviously with so many.
Well, that's right. All of this will be dragged into the federal court at great cost and expense for employers.
Well, I mean, not necessarily. There could be test cases which have nothing to do with employers or in fact workers, but in any event, we'll wait and see what obviously eventuates. Can I just now go to the Australian Education Union? Regarding teachers, should a teacher no longer adhere to the faith or teachings of the school, and that the school would only be allowed to terminate their employment if that teacher was employed after a publicly available policy was provided to the teacher prior to their employment? Many parents prefer this position when sending their children to a religious school of their choice. So do you believe it is fair and reasonable for a school to maintain staff who share the same ethos as the school?
Well, if the question that concerns faith-based schools, perhaps I should answer it on behalf of the IEU. As I understand it, the question's in 2 parts. Firstly, relating to a policy and the need for or support for having policies that outline the basis of employment. And secondly, as to whether we support the capacity for employers to have people working for them who are of the same faith. In relation to the question in respect of faith, well, yes, we do. We have no difficulty whatsoever with an employer employing as many people as they can of their faith. As you would be, all members of the committee would be aware, there's no merit system for employment in the private sector in Australia. There's nothing to prevent cronyism or employing members of one's family, and there's also nothing to prevent an employer from employing as many people of the same religion as they can. The issue, and it's an issue that's dealt with squarely in our submission, is that for the vast majority of schools, for more than 95% of faith-based schools, it's simply not possible to recruit people of the same faith to fill those positions because there aren't enough qualified teachers to do that.
I don't think that's the proposal of in that what I'm addressing is obviously employing those who share the same ethos or values of the school. So the union doesn't have an issue with that.
No, even if you don't come from that religious background, your contract of employment will enjoin you to particular standards of behaviour that are not inconsistent with the and often they'll be very general, and we complain about this in relation to policies in terms of their scope.
Right. Thank you. I'm sorry to be so quick, but I'm very conscious of time. Could I just also ask a question of the Australian Education Union, and that is, do you believe educational institutions should be able to preference staff that adhere to the same doctrines and beliefs of the school?
Look, I'm sorry, Senator. I was on mute before when I was trying to refer the question to my colleague.
That's okay. Ms. Hopgood.
Look, can I just say that I would refer we support, what I'd say is we support the IEU's position on this. It directly relates to the IEU and its coverage, not the AEU.
No, but
so I would go back to Anthony.
I'm sort of interested in you answering that question.
Yeah,
Do
okay.
you,
So
yes,
my-
if you could
my
answer it, because you're separate to the IEU, do you believe educational institutions should be able to preference staff that adhere to the same doctrines and beliefs of the school?
Well, the schools and the teacher employees that we cover are in public schools, and that is not a relevant question. In relation to your question about
Could you give your response?
religious-based
Could you?
schools,
No, I understand that,
support
but
the view,
sorry.
we support the view that the IEU has just put.
Yeah, but Ms.
actually,
Hopgood, are you able to give your view in relation to the question that I've raised?
Yeah, yes, my response is that we support the view that the IEU has on this matter.
All right, thank you very much. I'll now hand over to Senator Rice.
Thank you. And look, I'll start with education also. And so the question to the IEU, certainly it was really, your evidence to the Parliamentary Joint Committee last week was really stark in terms of the experiences of your members and the discrimination that they, LGBTIQA+ teachers experience in particular. What I wanted to know is we've heard how the situation is different in Tasmania compared with the rest of the country, because the Tasmanian anti-discrimination legislation doesn't allow religious schools to discriminate for either teachers or students on the basis of their sexuality. Do you notice, is there a difference in Tasmania compared with the rest of the country?
I begin by saying that we appended to our submission examples of prejudicial and discriminatory conduct. Only one of those examples comes from Tasmania. So yes, there is a lesser incidence. What I also add, and in part want to add to the answer that I gave before, and that is that we don't have a difficulty with preference at the point of engagement, but as a general principle, we support the idea that it should any concept of preference should be solely limited to the inherent requirements of the position, and that is a factor both in Victorian and Tasmanian legislation.
And we've heard quite a lot of evidence from various religious groups that they feel they should be able to preference members of their faith for all jobs because they're a religious organisation, basically, and they multiple submissions and witnesses said, oh well, political parties can choose who they employ, so why can't we, as religious schools, choose who we employ? What's your response to that?
Well, I don't believe there's any bar to them employing whomever they want, provided that they don't discriminate. What this legislation and the Fair Work Act and other legislation does is to give them the ability to discriminate. They already have an ability to discriminate at the point of engagement. All this legislation does, instead of having a single exemption, is to have three forms of exemption plus the preference sections in Section 11.
Right. So do you have any? So in general, then, I mean, their desire to employ just people of their faith. Do you have a problem with that?
Well, it's almost impossible in 95% of cases. In an ideal world, would we like to see appointment made on merit? We're just talking about what happens at the point of engagement. Well, yes, we would. Would we like to see? Would we like to see employment? All employment decisions have merit as their basis. Yes, we would. The major problem with the discrimination exemptions is not that they provide that employers will be able to find positions for qualified teachers of religion who can't find them at the moment because there's some legislative obstacle. The real difficulty that we have with the legislation is that it takes no notice of settings wherein religion plays no part in the work that the employee has to perform.
Okay, I mean, and do you discriminate or do you differentiate between the overall ethos of the school and religion in that instance?
Well, the substance of our submission is that it's wrong to generalise about the way in which individual schools will both interpret the teachings of the particular religion and treat staff. There's no, you can't, it's wrong to, it's conceptually wrong to make blanket statements, and I don't want to be drawn into it, about how a particular employer will behave, irrespective of the faith-based nature of the relevant school.
Thank you. Ms Hopgood, I'm really interested in the potential for people to be making what could be seen as quite discriminatory statements and potentially behaviour against LGBTIQA plus students in public schools and defending that on the basis of it's a statement of belief. And I had a bit of discussion yesterday about somebody who it seemed like within a public school was a teacher that was misgendering a child and basically took action and in fact won their action. But anyway, so just can you talk us through what the implications are of sort of making, on the basis of statements of belief, teachers in public schools being able to be making statements against LGBTIQA plus students that would be harmful to those students?
Yes, look, certainly, Senator. I suppose this goes, to our concern about the impact of the proposed legislation on the regulatory authorities' ability to determine whether a person is, if you like, fit to teach. You may be aware that, I started, I think, to say this at the beginning, that currently a teacher's discriminatory statements both inside and outside the work environment are taken into account and can be taken into account when determining whether a person has that authority to teach or their ongoing, certificate to teach. But unfortunately, what this legislation does is cut across that by removing the regulatory authorities, which are the registration authorities in each of our states and territories, from being able to take reference to anything made outside of their work. And so we could well have a situation where a teacher is making very discriminatory remarks or remarks which are very hurtful to LGBTIQ plus students, or to, for example, girls in schools about their rights. There's another example. Actually making those on their own, in their own social media, etc., which would not at the moment be acceptable, actually, would not be acceptable. And in fact, the regulatory authorities could take action against that and deem that that person simply is not is not fit to teach. But this would cut across that and they would be unable to take that into account. So look, we think actually, the example you've given is a very good example, because we think it actually can be very harmful for our students, also harmful, of course, for other teachers and education workers in settings if the comments are aimed at them as well, and actually takes away from, what good work we've done over a very long period of time to ensure that our students are protected from such such remarks and comments and campaigns, however they're described, actually, because it excludes it. So we are very concerned about this matter.
Senator O'Neill, Senator Rice has indicated she's got a couple more questions, but we'll put them on notice. We're right on the precipice of time. Can I go to you for 1.5 minutes?
Thank you. Senator Rice just referred to a piece of evidence which described Max in material that we received yesterday. I think it's very, very important that we actually get a good response to this from the AEU, because it is about the collision point of somebody's beliefs and that being accommodated in a workplace or not, and the outcome is clear in this one. I'd be interested, genuinely interested, particularly in the AEU's response to that case, because people of faith exist in non-religious schools as well. As teachers and as students, and parents send their children there expecting them to get, the full gamut of the pluralist society. So I think it's important to refer to that. Could I just go to section 12? The Australian Human Rights Commission has submitted that it's not aware of any cases where genuine statements of belief have actually been held to be contrary to Australian anti-discrimination law. And I'm not talking about vilification, I'm specifically anti-discrimination law. Are you aware of any such examples, particular cases involving disputes between employers and employees? Perhaps on notice for that one. But for today, in your view, is there a better, more procedurally workable way of reassuring people of faith in Australia that the expression of what the bill describes as moderately expressed religious views will be or are already protected under Australian law? Mr. O'Brien?
I might defer to Ms Ismail on this one.
Thank you.
Thanks for your question. Well, as the Religious Freedom Inquiry found, Australian law already protects religious freedom in this country. We don't have a problem in this country with religious freedom. People are free to express their views. There are limits around that to the point where it impinges on other people's rights. But people are free to express their views already. We don't need this provision. What this provision is expressly designed to do is allow statements of belief that are discriminatory, that would currently be unlawful.
Ms Ismail, can I point you to the evidence from Dr Renee Barker, who quoted St Thomas Aquinas and said, to one who has faith, no explanation is necessary. To one without faith, no explanation is possible. And the concerns that have been raised about the Victorian situation in particular, where a very narrow definitional lens has been applied to what constitutes an inherent requirement. And I know that this will vary from school to school, but she writes that a maths teacher at a religious school is often used as an example of a secular role where the person fulfilling that role does not necessarily need to comply with the religious ethos of the school in order to fill the requirement of their job, which has been very commonly cited in community. However, with the administrative assistant, or Gardner discussed above, the role of maths teacher may be seen by religious people very differently from those of a secular background. As with other teachers, a maths teacher is likely to be approached by students for guidance on a range of issues, not just trigonometry or algebra. They may be required to participate in religious activities. A teacher whose belief and values conflict with the religious ethos of the school is unlikely to be able to do either of those things, both in line with the school's religious ethos, nor authentically. And I just cite that because I think it starts to get to the complexity of the huge variation in understanding of what support for the ethos of a religious-based school, which we all applaud and believe should be a right in a free and pluralist society, and the attempt to provide protections that might be heavy-handed in a way that doesn't understand differentiation for religious communities. Because we've heard from Christian groups here a wide range of views about, whether the maths teacher has to be
I'm going to have to ask you to put
this
question on notice because we are out of time, I'm sorry.
Well, I think it's an important question.
Yeah, no,
if I could get a little response and then responses
that.
on notice from anybody who wishes. I think we're at the nub of some of the debate here.
Could I ask you to put that question on notice? Just get to the heart of the question and then put it on notice because we are going to have to finish up.
Well, I have put it. I'm just seeking a response.
All right.
I can answer quite quickly.
All right. If you can do that very quickly, that would be terrific.
We think that these are things that need to be dealt with on a case-by-case basis by courts, if it comes to that, but that we need to get the test right. We think that where it's an inherent requirement of the job and it's reasonable and proportionate, an employer should be able to make a decision about someone's employment based on their religion, but only in those circumstances. And when that comes into dispute, which it will, as you pointed out, in a range of circumstances, yes, courts can decide on each case, in each case, whether it's appropriate or not.
Thank you very much. And
Thank you. Thanks very much,
Thank
Mrs.
you,
Mail.
Senator O'Neill. And I would like to thank the Australian Education Union. Sorry, you've got your questions on notice?
No, I wanted to ask my question for it to be put on notice.
All right, Senator Rice.
Okay, and I was wanting to get a response from the evidence that the Buddhists and Hindus gave to us yesterday about discrimination in employment in it was service provision, essentially, and who are very concerned, and I know the complexity of Section 7, 8 and 9 does sort of do my head in terms of what would be permitted and what wouldn't be in terms of discriminating against people on the basis of faith. But they were very concerned that they would be discriminated against on the basis of, being Buddhist and Hindu by service providers who are of different faiths. So if you could sort of give us a response to that. And my other question was the same one that I ended up putting on notice last week as well, as sort of expanding on your concerns how these provisions might be used as a cloak to mean that sort of taking action against workers that were otherwise sort of raising issues in the workplace, and so basically on the grounds of religion that they then could have employment action taken against them.
Thanks, Senator Rice. And I again just thank the Australian Education Union, the Australian Council of Trade Unions and the Independent Education Union for their participation and their commitment to our inquiry and for their evidence today. We are now going to suspend for afternoon tea for 10 minutes. We will return at 3:15. Thank you. Good afternoon. The committee is now in session and I welcome representatives of the Australian Human Rights Commission and the Australian Council of Human Rights Authorities. Thank you so much for taking time to give evidence today. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state or territory shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 32 and 165 respectively. For the Hansard record, would you please state your full name and the capacity in which you appear today, including whether you have any correction to your submission?
Thank you, Chair. Perhaps I will go first. Emeritus Professor Rosalind Croucher, President of the Australian Human Rights Commission. I'm appearing today with Ms Lorraine Finlay, Human Rights Commissioner, and also Mr Graham Edgerton, Deputy General Counsel of the Australian Human Rights Commission. In the session as well, Chair, is Ro Allen, Commissioner Ro Allen, who will be representing the Australian Council of Human Rights Authorities. I would like to make a brief opening statement, if I may, on behalf of the Australian Human Rights Commission, and then pass the baton to Commissioner Allen to make an opening statement on behalf of ACRA, and we will welcome questions.
Thank you very much, Professor. Look, I would just ask for Ms Finlay, Mr Edgerton and Commissioner Allen, if they could each introduce themselves and explain the capacity in which they appear today.
Thank you, Chair. Commissioner Finlay.
Thank you, Chair. My name is Lorraine Finlay and I appear today as the Human Rights Commissioner with the Australian Human Rights Commission.
Thank you.
Chair, my name is Graham Edgerton. I'm the Deputy General Counsel of the Australian Human Rights Commission.
Thank you, Mr Edgerton.
I'm Ro Allen. I'm appearing today as the Chair of the Australian Council of Human Rights Authorities and I'm the Victorian Human Rights Commissioner.
Thank you very much, Commissioner Allen. Now to the Australian Human Rights Commission opening statement of 1 minute. Thank you.
Thank you, Chair. I'll begin by acknowledging the custodians of all of the lands on which we're appearing today and pay respects to Elders. The Commission strongly supports the introduction of enforceable protections against religious discrimination for all people in Australia. While the bill does this, it also goes significantly beyond the existing model of such laws. We're most concerned about Clause 12, which would permit discriminatory statements of belief to be made. We consider this clause as not legally necessary. Other provisions of the bill will provide confidence to people that they can speak freely about their faith without infringing the rights of others. We have concerns about 3 other provisions, which we will address in questions. The Commission has long played a significant role in promoting an understanding of religious freedom in Australia, and we look forward to continuing this important work into the future. Thank you, Chair. We welcome your questions.
Thank you very much, Professor. I now firstly give the call to Senator Scarr. Oh, apologies. Sorry. The Australian Council of Human Rights Authorities, do you have an opening statement?
Yes, I do.
I apologise.
Today I make my... That's okay. Today I make my remarks on the land of the Audi order, and I'll pay my respects. As the chair of ACRA, I'll take our submission as read, but every state and territory commissioner personally signed the letter because they wanted to raise 4 matters with the panel today. The first is that every commissioner believes that religious freedom should be respected and upheld in Australia, but the balance of this bill has not got it right. And in fact, that this bill would allow religious organisations to discriminate against people with other attributes. The second is the overreach into the anti-discrimination powers in state and territory jurisdictions. And the third, of course, the confusion that it may or will have on our tribunal system in relation to hearing the matters. As I said, I'm representing ACRA, but today I'm also the Victorian Human Rights Commissioner, and before that I was Australia's first LGBTIQ+ Commissioner, so I'm well placed to answer any questions around discrimination in our community this bill has and may have in the future, and my own lived experience. Thank you.
Thank you very much, Commissioner Allen. I will now move to questions and give the call to Senator Scarr.
Thank you, Chair. I'm going to read a quote from St Thomas Aquinas, which Senator Deb O'Neill and I have been referring to on quite a regular basis over the last 2 days. To one who has faith, no explanation is necessary. To one without faith, no explanation is possible. And I provide that quote in the context of this issue around inherent requirements of a position, because there's one perspective, and the example that we've been considering over the last few days is our maths teacher in a religious education context. On one level, you say, well, the maths teacher only needs to teach maths and meet the relevant pedagogic requirements to do that effectively. On another level, you say that a teacher in the context of a religious education institution needs to understand and comply with the religious ethos of the institution. I'm wondering, where is the balance we should be seeking in terms of making sure that there is no discrimination, but at the same time recognising the legitimate right of a group of Australians with a common religious ethos to form a religious institution and make sure those who are participating in it share their religious ethos.
Senator, perhaps I could go first in venturing a brief answer. The question goes to the preferencing in terms of selection of teachers, I gather is the gist of your question. And
sorry, not just teachers, but the example we've heard from the submission from Dr. Barker on the first day goes to everyone who's working. It could be someone working in admin, the gardener, but the institution itself has been established on the basis that there's a sharing of the common ethos. We heard from the Jewish community that from their perspective, having governing bodies of hospitals or schools, their preference is to have the right to say that everyone serving on that governing body should share the same religious faith, even though to be a director of a governing body doesn't inherently require you to be of a particular faith. So it's even broader than just teachers.
Thank you, Senator, but the question I think concerns essentially selection in employment.
Correct.
Yeah, and in that respect, we're talking about exemptions from current law, and there is a review that the Australian Law Reform Commission has been asked to undertake after the commencement of this bill, if it is passed into law. And that is the appropriate opportunity to consider these questions more fully. But pending that review, the position of the Australian Human Rights Commission is that schools should be allowed to preference in employment at least teachers based on their religious belief or activity in order to maintain the ethos of the school. But the distinction, our primary emphasis is not on selection, where arguments can be made about the ethos and so on, but more in terms, our view is that schools should not have the ability to discriminate against existing teachers, to terminate employment on the basis of their religious activity or belief. So there's an opportunity coming up with the Law Reform Commission, but insofar as there is needed to be anything now, we'd support a preferencing at the point of employment, but not in terms of against people in employment as a basis of termination.
Ms. Allen?
Look, I think for me, Senator, it's a choice between religion and spirituality. In my introduction, I didn't introduce myself as a person of faith, and also a queer person. And so for many queer people of faith, you are drawn to work in a Catholic or Christian or Jewish school because it aligns with your ethos, your values. And so there are many LGBTI people of faith that work in, and not just schools, but if you think about all community services, 80 to 90% of all Victorian funding goes to welfare services, which cover, hospitals, everything. And we're drawn from our social justice, ethoses to those communities. So, I think that's where Victoria, of course, biased, but that's where Victoria's got the balance right, in that it is an inherent requirement for some positions. As you've noted, not the gardener, you're not the receptionist, but potentially for religious instruction teacher, for example. So it still strikes that balance, I think, between an organisation being able to say, for this particular, employment, it's a requirement. But I think, it's fair to say that people are drawn into that space. And I would argue that I have the religious or Christian ethos that would fit with the school's, if I was a teacher, the school's ethos. So I just think that this bill even actually kind of pits us against each other, that there's religion over here and there's LGBTIQ people over here, and that's not always the case.
Yeah, Ms. Allen, I think there's been strong testimony that we've heard over the last few days that there are a lot of people from the LGBTIQ community working in religious institutions and sharing the ethos of their workplace. I think that evidence has come through very strongly. And but one of the conundrums, I guess, I'm trying to sort out in my own mind, to be open with you, is it's one thing for me to observe that you share the ethos of a group. It's another thing for that group who've established their institution in accordance with their ethos to make a determination as to whether or not you or I share that ethos. And the question in my mind is, to what extent should the group in community, and in terms of religious freedom, there's a recognition that this is exercised quite often in community as a group. To what extent should they have the right to determine what their ethos is, rather than you or I determining whether or not we fit their ethos? Do you understand the conundrum?
Last question to Senator Scarr, please.
Oh, sorry, that was a question. Sorry, I guess I was.
I understand the conundrum, Senator, and I think is the short answer.
Okay.
And it has to be tested in Victoria, and it will also depend on the orthodoxy of the school, just going back to the school example, and that school would have to put a very strong case.
Okay.
Nothing is clear.
Nothing is clear. Okay, I accept that. Absolutely.
It's a broad church, Senator.
And that's a very apt metaphor. Very apt metaphor. Well done. That's the best metaphor we've heard in 2 days. Professor, if I can ask you, this issue of corporations, which is quite a technical issue, and the point I'm struggling with in terms of a corporation is, if a member of my community, a Muslim member of my community, is a sole trader and dealing with service providers, and a service provider says, I'm not going to provide a service to you because of X, Y, Z, and that constitutes discrimination, the Muslim sole trader has a right to make a claim. If the Muslim sole trader decides they want to incorporate and be a company, someone comes to offer them a service and sees that the owner of the company is a Muslim, why shouldn't they have the right even though they've chosen to be incorporated to take the benefit of limited liability, why shouldn't they still have the right to bring a discrimination claim? And this applies in my mind, whether or not it's religion or sex discrimination or race discrimination. It could be a lesbian has a business. Why should they be deprived of the right to bring a discrimination claim simply because instead of being a sole trader, they've just decided to incorporate and get the benefit of limited liability?
Thank you, Senator. I think there are a number of different threads being intermingled here, shall we say.
Sorry.
The ability for more than one person to bring a complaint is already provided for in the architecture of the existing discrimination laws as a group. So the idea of a collective, as in a congregation or a number of individuals, there is a possibility for a number of individuals to group together and bring a complaint. That's quite a different concept from imbuing in a corporation the right to be a complainant under anti-discrimination law, which is completely at odds with the ethos of human rights law, which is about the human rights of individuals.
Okay.
So it's the corporate element that is unnecessary, and I think just throws a confusing element and an unnecessary element in the mix.
So my Muslim business person, in your view, would be able to bring a claim irrespective of whether or not they were a sole trader or working or the owner of the company. They would still, as an individual, be able to bring a claim?
Yeah, the corporate status is irrelevant.
Okay, thank you. Thank you, Chair.
Yeah, thank you very much, Senator Scarr. Senator O'Neill.
Thank you very much. In relation to Section 12, which has occupied so much of our time, the Australian Human Rights Commission has submitted that it's not aware of any cases where genuine statements of belief have been held to be contrary to Australian anti-discrimination law. That is in paragraph 55 of your submission. I have been asking participants in this series of days of hearing about their view with regard to that. So can I ask you, over the course of this Joint Standing Committee inquiry, have you been made aware, the Senate inquiry or the previous inquiry, have you been made aware of any such examples?
Thank you, Senator. The point that we sought to make in that paragraph that you've quoted is that because of the absence, so far as we are aware, of genuine statements of belief being found to be contrary to anti-discrimination law through case law, our view is that it's unnecessary. It doesn't mean it's that Clause 12 is without impact, but it is unnecessary to achieve the protection that is required, because the only legal effect of Clause 12 is to reduce protections against discrimination. And at the margins, it will have the effect of allowing derogatory and demeaning comments to be made. So the fact that that moderate statements of belief have not been found to be held to be contrary to anti-discrimination law doesn't mean that there's not a necessity for the protection. But what it suggests is that Clause 12 in and of itself is unnecessary.
Thank you. And is the Australian Council of Human Rights Authorities aware of any example, or do you wish to expand on the response from, the Commissioner? Thank you. Professor Crouch has answered the question. Is there any response from the Commissioner? Ms Allen.
Commissioner Allen, you're on mute.
Sorry, I wasn't looking at you. I was just listening.
No, sorry. I've said I agree.
Senator, could I perhaps add to that briefly?
Yes, please. Mr Edgerton.
Senator, I think the point that we were making in our submission was that the policy objective behind Clause 12 is to protect moderately expressed statements of religious belief. That's the policy objective. There's now been 3 days of evidence in front of the Parliamentary Joint Committee on Human Rights. There's been a day and a half of evidence in front of this committee. Hundreds of submissions have been made to both committees. And those who are proponents of Clause 12 have not identified any Australian case where a moderately expressed statement of belief has been found to be contrary to Australian discrimination law, either in a tribunal or in a court. And so we say the conclusion from that is that Clause 12 doesn't address a pressing legal issue. it's not necessary to protect moderate statements of religious belief. But that's not the legal effect of Clause 12. The legal effect of Clause 12 is broader than that, and that's why we have concerns about it.
Okay.
Protect not just moderate statements, but it will also, at the margins, because it overrides existing anti-discrimination law protections, it will have real impacts on people who rely on those protections, particularly in relation to demeaning or degrading statements.
Could I just, on notice, sorry, I'm going to run out of time, but on notice, could I indicate that we received a submission from the Human Rights Law Alliance, and they refer to some cases in here. It would be very interesting to get your response to the scenarios that they describe there for our consideration.
I'm happy to do that. I heard some of the evidence when that
came through.
Bundle was handed up. I haven't looked at the bundle, but I understand a lot of that related to complaints under the Fair Work system and not under discrimination law. So I was looking at an employment context rather than a discrimination context.
Thank you very
much.
much.
I'm happy to look at that on notice.
Yeah, there's a range of them there. Commissioner Allen, I've got a few more lines of question, but you indicated there's uncertainty about the Victorian legislation, but you were pretty clear that you said it would not no to the gardener and no to the receptionist. I think I heard you say that. Is that determined already? Because that is an area that's been, traversed somewhat in the course of these hearings.
No, it hasn't, Senator. I think they're just examples that I'm using about where a school would argue that something is an inherent requirement. And I think it would just, pass the reasonable and proportionate test quite easily, that a gardener is an example. I know the maths teachers come up a lot, but I think a gardener would be an easier test, that it doesn't meet the inherent requirement test under the Victorian legislation, but it hasn't been tested, and every school could still go through the opportunity of testing that.
And you did say that depending on the orthodoxy of the school, a case might be made out that could be an inherent requirement.
Again, brand new updates of the Equal Opportunity Act.
I'm sure as the Victorian Commission you're well aware of these really heightened concerns and also the escalating attacks on people in terms of religious discrimination, particularly Muslim women, 72% of the cases. So could I just ask...
Can I add, Senator?
Yes, please, Commissioner.
It really, whether it is or it isn't, it's the perception of whether the discrimination for Muslim women. So, whether the bill's passed, whether Muslim people feel protected based on their religion or not, if that makes sense.
Okay. I might need to ask a further question, but in your submission in paragraph 56, the Human Rights Commission, you say the establishment of a new defence cannot prevent unmeritorious complaints from being made. Now, this is a critical point because one of the key rationales for the provision that's been considered in this legislation is to prevent complaints from being made under Section 17 of the Tasmanian Anti-Discrimination Act. Some submitters have pointed to the complaint against Archbishop Porteous, which was ultimately withdrawn as an example of a complaint that would not have been made under this law if the law had been in place at the time. And I note comments from you, Professor Croucher, last week that alluded to these issues. Will Section 12 prevent, and indeed can the Commonwealth Parliament prevent, complaints being made to state anti-discrimination tribunals? And I believe, Professor Croucher, you spoke about legislative change for the human rights for your agency that had helped to deal with that issue. So could I ask you to put that on the record?
Certainly, Senator. The point that I was making was that in 2017 there were some amendments introduced to the Federal Act under which our complaints handling is conducted, which enabled a consideration at an early stage to winnow out complaints that might be considered vexatious, unmeritorious, or not likely to go very far. So it was an administrative process of filtering at an early stage. And that enabled an ability to review things early on. And situations, in some of their state and territory laws, there may not be administratively that ability to winnow things out a bit further, which is why we recommended in one of our recommendations that consideration be given at the state and territory level. Because the mere fact that a complaint can be made, that can be a distracting issue, because the process that may lead to can be a very constructive and educative one. We get a very high satisfaction rates through our conciliation processes, I should say. And so people shouldn't be afraid of a complaint being made. I think sometimes the reference is being made as being hauled before an anti-discrimination body, which I would resist mightily, because I've seen how constructive the process can be. And they are administrative processes, they're not judicial processes. So, but we consider that having an improved administrative process of managing complaints early on might be an advantage to state and territory bodies. Commissioner Allen may wish to comment from a state and territory perspective, but that is a view that has had some discussion with my state and territory counterparts as well.
Thank you. Commissioner Allen?
I'm sorry, I'm having some trouble with my audio. But I think Ros has answered the question.
Okay.
Mr. Edgerton may make some observations about the Tasmanian law. Senator?
Yes.
Just very quickly. So, Senator, I think the answer to your prior question is that if this new federal defence was raised, it wouldn't prevent a complaint from being made. That defence would need to be as part of a new complaint. I think there's 2 points to understand about the Tasmanian law. One is I think there's a misapprehension about the threshold. It's been portrayed as a very low threshold for a complaint to be successfully made. Case law in Tasmania about Section 17 says that it should be interpreted in the same way as Section 18C of the Racial Discrimination Act. And in that sense, it should apply only to conduct that has profound and serious effects, not to be likened to mere slights. So the threshold for Section 17 is higher than I think people expect. The second thing to note in Tasmania is that there's already a free speech defence available in Section 55 of the Tasmanian Act. And that defence allows people to engage in public acts that are done in good faith for any purpose in the public interest. That defence was not tested in the Porteous case. It's a defence that's currently on the Tasmanian books. And it's another good reason why Clause 12 is not necessary, because the good faith requirement is already in Tasmanian law.
Okay.
Just last question, Senator.
Could I put on notice one question and then ask for a response from Commissioner Allen on another matter? Professor Toomey raises concerns about constitutionality with regard to Section 109 of the Constitution, and the concerns that she raises are essentially that unless there's an inconsistency, there's going to be pretty bad law made. A recommendation to amend that problem and provide some certainty has been offered by Professor Aroney. I know that you don't believe there's need for a Clause 12. He makes amendments for 11 and 12. I'd just be interested in your considered view of that, if you could take that on notice. And finally, if I can go to Commissioner Allen, we've talked about how truncated this process has been. The EEO legislation in Victoria and the Section 17 in Tasmania have been much discussed. Has the federal government been in touch with you and the Victorian government to discuss this legislation and its intersection with the Victorian legislation to inform this process of lawmaking at a federal level?
Senator O'Neill, could I ask that the witnesses take that question on notice? Because
I'm sure you would, but I'd like an answer.
I know
it's a
you
yes
would,
or no. It's not that hard.
Well, no.
Commissioner Allen, we don't want to do this dance again today, Chair. It'd be really good to get an answer.
It's not a dance,
deserves
Senator
an
O'Neill.
answer.
I need to make sure that everyone has a fair opportunity
I'm
to
sure
ask
Senator
questions.
Rice would be interested in the answer
and
too.
so
She
you're
might even
well over
ask
your
it.
time, so I am going to ask if the witnesses could take that on notice, and I'll now give
Commissioner
the call.
Allen, did you actually get any?
And I'll now
from
give the
federal
call to
government?
Senator Rice.
Chair, and look, I'll start with Commissioner Allen then first with a response to Senator O'Neill's question.
The Commonwealth Government hasn't been in touch with me personally. I have to take on notice touch with anybody else in the Attorney's Office or broader in Victorian Government.
Can I say I'm disappointed but not surprised?
Okay, and I did want to say how crazy it is that we've only got half an hour to consider all of the learned knowledge and wisdom that is before us in this panel. So briefly, also to Commissioner Allen, we've heard evidence that the main reason that the government has included Section 12 is because it wants to override the Tasmanian legislation and the Victorian legislation. They're pretty narky about both of those. So, Commissioner Allen, could you just give us a quick summary of what the benefits of the Victorian legislation are and what the risks are going to be that if it is actually overridden by this federal legislation?
Okay, thanks, Senator Rice. I think the benefits of Victorian legislation strikes a good balance, and it certainly protects LGBTI people in employment situations. A statement of, again, we're not sure exactly what that could mean in an employment situation, but you could be sitting next to a colleague that says, "Good morning, Ro. Just want to tell you that God loves you and I'm praying for you every day." And that's a statement of belief, and that may not be seen as workplace harassment. In Victoria at the moment it would. So that's just an example. It's hypothetical. I think we're living in a world of hypothetical what could happen. But it's the perception, again, it's the perception of Clause 12, that authorising environment that Clause 12 would potentially give for people to feel like they could discriminate, which in Victoria at the moment, people sleep easier because it's illegal to discriminate against them in the workplace. So I think that's one benefit, and there's many more, obviously, around our brand new conversion practice, change and suppression practice 2021, which is about to come in place on February 17, and that the benefits of that, of course, is to stop conversion practice or exorcisms of young people in Victoria, and that could be perceived as a statement of belief. It would need to be tested. It's a very concerning clause for me and the Victorian legislation.
Thank you. And I mean, I note that you're here actually representing the Australian Council of Human Rights Authorities, and as you said in your opening statement, your submission is signed off by your equivalents in every state and territory, even those that don't have the strong anti-discrimination laws that are in some of the states and territories. Could you just talk us through sort of why all of the states and territories felt that it was important to sign on to your letter expressing concern about the state and territory overrides?
Well, thanks, Senator. I can say this. I'm new to I went to one meeting and I've chaired one meeting, and I've been told that it's not usual for every state and territory commissioner to agree and sign on anything. But certainly they believe that the balance of this bill is not right, as I said in my opening, that we do need to come up with and have a mature conversation federally and across states and territories about how do we protect religious freedom and balance that with other attributes. And I think some of the states, as you noted, they have very strong laws, Victoria and Tasmania. Other states are looking to implement those laws. So we all are aware of the impact that this bill would have for the mental health, I suspect, of all LGBTIQ people in Victoria, but across Australia, and they share that experience. So yes, even though they may not have strong laws, they do understand the potential harm of this bill.
Thank you. And look, I know that we're running out of time, so my final question is just my one and only, sadly, question to the Human Rights Commission. Professor Croucher, given the concerns about this bill, in particular the constitutionality concerns, do you think that if this was implemented, can you talk to us about the legal challenges you see being unleashed and what the scenario would look like, and potential legal challenges in the High Court as well? What does the Human Rights Commission see that scenario as looking like over the coming years?
That sounds like scripting a major movie for the next generation. Senator, the bill at its core is a solid anti-discrimination bill protecting the attribute of belief. That's an important addition to the suite of laws. There are some other bits that are positive, which go to inclusion of volunteers and interns, and that's a recommendation, for instance, across all of the discrimination laws. Those bits are good, welcome, and should be implemented. There are elements that we've addressed in this hearing and others, and all the other the witnesses have addressed, where it is unnecessary and and not only unnecessary to address the real concern that people should have confidence in being able to express their beliefs. We feel that the bill is calibrated well without clause 12 and the other clauses that we've identified as problematic. And the ones that have been identified as problematic are the very ones that may play out in the scenario that you were suggesting of future litigations. Insofar as the bill sticks to the well-trodden path of discrimination laws, then I don't foresee enormous litigation in the future, but rather a solid expansion of a very healthy complaints handling jurisdiction of the Australian Human Rights Commission at the federal level. So keep it to that and it will work. Add the other bits in, it's wide open for challenge and question.
So in terms of the bill before us, it would have to be significantly amended to be that standard piece of legislation.
Remove the bits that we've identified as problematic and leave the rest to run as an orthodox, which is a funny word in this context, but an orthodox addition to the anti-discrimination suite.
Thank you. Thanks, Chair.
Yeah, thank you very much, Senator Rice. Senator Pratt, just for a couple of minutes, please.
Thank you. I just wanted to return to the statement of belief provisions. You said in paragraph 55, and we've resolved the context in which you were talking about genuine statements. What kinds of statements of belief have been found to be contrary to anti-discrimination law in that they've had a discriminatory effect? And how might Section 12 undermine those findings for both Roe Allen in a Victorian context and for you, Professor Coucher?
Perhaps if I may go first, Commissioner Allen. In our submission, Senator, we give some specific illustrations drawn from 2 3-month periods. It's from paragraph 98 and following in our submission. In the interest of time, may I just refer you to that section and we can expand upon it on notice if necessary.
98, did you say?
Yes, 98 and following. It's at section 5.3 and particularly in paragraph 101 and paragraph 102, we refer to periods of 3 months in which we made an analysis of our complaints. I know we were questioned about this in the PJCHR hearing and can provide further information on notice in view of the time, if that's amenable to you and the Chair.
So will you still be able to use a statement that might be licensed under Section 12 to be able to say it as a way of creating proof that other accompanying disadvantageous conduct occurred? So, for example, some people will bring a case that says, well, I didn't get this promotion because I'm gay. And you might say, well, the Commission will say, okay, well, what proof have you got? And sometimes it might be just a feeling, but that might be disadvantage to the case. But in other cases, you might put a statement forward. How can you have a right to stay a belief, but then not have a right to discriminate on that basis? Does it have any implications for how you collect evidence in relation to these kinds of complaints?
Mr. Edgerton, can I ask you if you'd like to answer that question, please?
Senator Pratt, that was a real concern for us in relation to the exposure drafts of the bill. Yeah. The explanatory memorandum has tried to address that by saying that a statement could still be used as evidence of discriminatory conduct. But our real concern is that the statement by itself can amount to discrimination, and that's really what Clause 12 allows. Commissioner Finlay, did you have anything else you wanted to add on that?
I think you summarised it very effectively.
All right, Senator Pratt, we might need to...
and Roe Allen, please.
Oh, sorry, Commissioner Allen.
Thanks, Senator. I think your example, Senator, is an excellent one, and we used it in our submission. That you hear a manager say, I believe that homosexual people go to hell and I don't want to work with homosexual people. And then you apply for a job and you don't get that job. You know, the statement, it could be seen as a statement of belief, but then how could it be used as evidence in state anti-discrimination law? It's very hard to prove. I know I've been overlooked for jobs too. It was the first time being an LGBTI commissioner that my gender or sexuality was an advantage in the job I was going for. It's very hard to prove, and I think the statement of belief, Section 12, just makes it impossible.
Thank you. Thank you, Chair.
Thank you very much, Senator Pratt. Yes, Senator O'Neill.
In your opening statement, you indicated that people who are seeking the comfort of Clause 12 should not seek it there, that in fact they should have confidence in other parts of the bill. Could you just nominate them now and provide a full answer on notice? Thank you.
Was that a question to the Human Rights Commission, Senator?
Yes, to you, Professor Croucher.
Yes, indeed, we can provide that on notice.
Thank you very much.
Thanks, Senator O'Neill, and I'd like to thank the Australian Human Rights Commission and the Australian Council of Human Rights Authorities for your commitment to our inquiry and for your time and evidence today. Thank you.
Thank you, Chair.
I'd now like to welcome representatives of the Northern Territory Government. Minister, thank you very much for taking time to give evidence today. I remind senators and witnesses that the Senate has resolved that an officer of a Department of the Commonwealth or of a state or... we're just going to pause for one moment. We're just checking... apologies. I just was asked to hold for one moment, just checking that the Minister is online.
Yes, good afternoon. Selena here from the Northern
lovely.
Territory.
Thank you. Minister, welcome. And again, thank you so much for taking the time to give evidence today. Just to reiterate that senators and witnesses, to remind senators and witnesses that the Senate has resolved that an officer of a Department of the Commonwealth or of a state or territory shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submission, submission 87. For the Hansard record, could you please state your full name and the capacity in which you appear today, including whether you wish to make any correction to your submission?
Thank you very much for the opportunity to the committee and for your time and your work, and of course all the officials bringing the committee hearings to fruition today. My name is Selena Yubo. I'm the Member for Arnhem and the Northern Territory Attorney General and Minister for Justice. I'm appearing on behalf of the Northern Territory Government.
Chair, can I just make the observation that one thing about being Australian that I love is when you were checking if the Minister was there, she simply said, yes, it's Selena from the Northern Territory.
Thank you, Minister. Now, can I invite you to make a 1-minute opening statement, please?
Thank you very much, Chair. I have several areas that I want to touch on during today's hearing, but I will start with an opening statement. Thank you for the opportunity. Today, I wish to draw the attention of the committee's focus on what we feel is the consequences of this bill, whether it's intended or otherwise by the Commonwealth Government, and what we feel will be very damaging impacts when considering the Territory's unique and diverse context, particularly when we're talking about remote Territory communities. If our organisations were to exercise the full and all of the protections that are being offered in this bill, I have very real concerns that the consequences of the bill have the potential to unreasonably interfere with the ability of Territorians to have access to essential services and institutions, and also the ability to retain and build our workforce in our regional remote locations. Some of the examples that we'll highlight and have been highlighted in the past, I know, are remote school examples and service providers such as health services and social services who have a religious denomination base. I'm also the Northern Territory Minister for Aboriginal Affairs, and something that I'm very passionate about is ensuring that we have access to justice for Aboriginal Territorians, and we have a big suite of measures and reforms that we're going through this term of our government. Our Territory Labor government does take this very seriously, and evidenced by the release of our first ever Aboriginal Justice Agreement, which was released in August last year, 2021. We have a 10-year commitment of our Aboriginal Affairs strategy, which we have also aligned to the National Close the Gap Refresh strategy. Something that we feel very strongly on behalf of the Territory Government is that although we feel that the Federal Government may satisfy themselves that there are adequate checks and balances in this bill, it is, of course, of our belief that we do not think that the best protections for Territorians can lie with what the current state of the bill. And my concern particularly is that the bill, in fact, further hinders access to justice and also makes an already confusing justice system and a stretched justice system even more confusing for Territorians, and particularly those who do not have English as their first language or who reside in our remote parts of Australia. The fragmented nature of the discrimination law across the country is something that we feel needs to be more harmonised, and when we're talking about the differences between Commonwealth law, state and territory laws, makes it all the more complex for people to access understanding, support, advice and their protections and the complaint mechanisms in order to protect them as Australians. And this presents a huge barrier when we're talking about the conversation of justice. And I believe that this bill will indeed raise the barrier to access to that justice even more higher and out of reach of the everyday Territorian. Chair, can I just ask, I am conscious there is a short amount of time. I have 3 areas that I'd like to touch on, but I can leave my opening comments there if we are stretched for time.
Minister, thank you so much. I'm going to kick off as chair with a couple of questions and then I'll hand over to other senators. Minister, do you believe it is important for schools to be able to hire staff consistent with the ethos of the school?
Thank you, Chair, for the question. I'm actually a teacher by background and I was the former Northern Territory Education Minister. One of the areas that I have been concerned with this bill as a past educator and a former education minister in the Territory is the impact on our schools that we could see should some of our changes to the current Northern Territory Anti-Discrimination Act 1992 remove the protections around discrimination when we're talking about particular, and I'm trying to word this very diplomatically, particular guidelines that are individual and based around those conversations, which I know that the committee's heard very much so over the last couple of days of hearing religious sensitivities in regards to employment. So that would be my concern here in the Territory, that with a small jurisdiction and some very regional and remote parts of the country, not having an option of other places to either have employment or to attend education institutions based on any inhibitors or barriers because of statements of belief, that would be a huge concern in the Territory and the impact to our communities right across from our urban to our remote.
Minister, my final question relates to Clause 68, which explicitly provides that the bill is not intended to exclude or limit the operation of a state or territory law to the extent that the law is capable of operating concurrently with the bill. Could you just expand on the concerns that you have in relation to this particular matter and the extent to which you're concerned about the bill overriding territory provisions in your laws?
Thank you, Chair, for the question. Something we've been working on for the past 5 years here in the Northern Territory are the amendments to the Northern Territory Anti-Discrimination Act 1992. We have put off some of those amendments frustratingly for several years because of the process that we're currently going through in terms of the federal government and the bill that's proposed and that we're scrutinising now. The concern that we have in the Territory is that regardless of not having the intention to override Northern Territory legislation and law, we already have a prime example in the Territory where we're unable to legislate for Territorians because the Commonwealth has exercised their power to not allow us to legislate both ourselves and the ACT with voluntary assisted dying, and that's something that's a legacy issue, unfortunately. So we do have concerns that while the intention is not to override NT legislation, we already have a current example, very much so a live current example of legislation that we are not able to exercise rights for Territorians because it's hindered by the Commonwealth Government legislation.
Thank you. I'll now hand over to other senators. Senator Pratt, you have the call.
Thank you very much, Chair. You said, Minister, there were a couple of other areas you wanted to touch on. I thought I'd be as flexible as possible and give you the opportunity to do that.
Thank you, Senator Pratt. I appreciate the opportunity. I know that we're very limited in time. Two of the areas out of the three that I thought may be more pertinent to discussion and possibly lead to more questions this afternoon in the hearing. One in particular was access to discrimination complaint bodies, territory and access to justice. So I touched on it very briefly in my opening statement, but what we found through some of the very deep dive consultations with our Aboriginal Justice Agreement around the territory is that everyday Territorians don't necessarily access at an equitable rate the complaint systems that are available to them here in the Territory. We've found it very high in Aboriginal Territorian population and in our immigrant population and those who speak English as a additional language. So we've also seen the low rates of accessing discrimination complaint process in our vulnerable and disadvantaged Territorians, including Territorians who have disabilities. So that's one of our key concerns, is that any changes to that fragmented discrimination law that we have across the country will further inhibit and disadvantage Territorians to be able to know and understand their rights, but access to complaint systems that would support them, protect and defend their rights.
Dig into that in a bit more context. If this law proceeds, your future iteration of your Northern Territorian laws, as you envisage them, which have been delayed, if they would be overridden by this law and therefore have to rely on national courts to make determinations, in effect, you'd have, you could potentially have quite isolated communities that had either made a complaint or had a complaint made about them, really disadvantaged and dislocated from being able to proceed or access justice.
Thank you, Senator. Yes, that would be our big concern in the Territory context, where not every town, community, homeland, or area, station area, for example, for some of our pastoralists, have a service body or a service provider that they can access in their community, in their language, within, a couple of 100-kilometre radius. So further complicating the system and creating complexities in terms of accessing that if we have federal mechanisms that then need to get into place, as opposed to trying to have the NT solutions-based resolve that occurs currently through the Northern Territory Anti-Discrimination Commission, would be a huge concern in being able to provide that clarity and then those pathways to, if someone was to appeal a decision or a process.
So where and how do your mediations or determinations or investigations take place? Does the Discrimination Commission travel out to places to investigate a complaint? And where do parties who are being mediated come together?
Thank you, Senator. There's a range of different ways that can be accessed for on-the-ground support mechanisms. It's not perfect. The Anti-Discrimination Commission operates very is a very well-oiled machine that operates on the smell of an oily rag, as they say. They make every attempt to travel hundreds of kilometres across the territory to be able to provide their services, but we still come up with barriers and challenges of being able to, one, get to remote access to Territorians, having access to first language Territorians, whether that's Aboriginal Territorians or our large migration population, particularly from Southeast Asia, and providing interpreter services, and then also just the weather in the wet season as inhibited being able to do face-to-face. We do have, sorry, I'll just finish before the next question, Senator. We do have mediation services that have been quite successful in particular parts of our regional centres that have worked, or a lot of work, but have worked quite successfully in having some of those local-based solutions, but they're community-led, and we do see some really great examples in the territory of some Aboriginal organisations who lead the space of alternative dispute resolution in communities and in language and in an appropriate way that's either culturally appropriate or appropriate to family groups.
And are you aware of whether the Federal Human Rights Commission actively comes and hears cases very often in the Northern Territory? You know, what happens if by matter of override your laws become more inaccessible?
Thank you, Senator. I don't have any information at this point in time that I could point to an obvious example of seeing that, I guess, federal support for dispute resolution or access to Territorians in some very remote circumstances. I'd love to be corrected. I'd love to have some examples, but there's nothing that springs to mind at this point. And I just fear that if there was something that further created a divide, then that would we wouldn't see any of the support that would then need to come with that divide.
Senator Pratt, we
You've been
might...
very eloquent. Thank you, Minister. Thank you, Chair.
Yeah, thank you, Senator Pratt. And I'll now give the call to Senator Rice.
Thank you, and thanks, Minister, for appearing, and in fact being the only one of the state and territories to appear. So I'm really grateful that you have appeared before us today. I just wanted to start with asking what consultation was there with the Northern Territory over this legislation, particularly regarding the state and territory overrides?
Thank you, Senator. I have touched base with the Northern Territory Anti-Discrimination Commissioner prior to this hearing. I know that they obviously have been working with the Australian Human Rights Commission as well, and being part of that that body that has provided submissions through this forum in that way. One of the areas the Commissioner did point out was, whilst we have the understanding of currently the Commonwealth law which could override NT law, it hasn't been accessed so far, is my understanding. I don't obviously then have a guarantee that it would not be accessed in the future in terms of overriding.
Right, but I'm interested in the consultation in terms of the development of this bill, about what consultation there was with the Northern Territory Government about it.
Oh, yes, sorry, thank you, Senator. We provided our submission. I think the consultation process has occurred the way it has. We have, through our own reforms and our own agenda as a Labor government in the Territory, been looking to progress our Anti-Discrimination Act, as I've mentioned already, and improve discrimination protection in NT legislation. We have done our own consultation based on the NT legislation, but I don't think the federal process has necessarily been community-driven, community-led or community-minded.
Did you put in a submission on the second exposure draft, which also included the sort of state and territory override, and expressed concerns about it in that? Do you know?
I would have to check that with my agency. I apologise, I don't have
That's okay. If you could take that on notice, because I'm interested in terms of all of the states and territories about who expressed concerns in the second exposure draft, which basically it seems like the government just ignored and continued on with the same direction in the bill that's before us today. Look, in just a couple of minutes we've got left, I'm interested in the issue that you outline in your last paragraph about how health and wellbeing services are often delivered by religious organisations, and that in the Northern Territory such a service provider may be operating in a near monopoly context where there's no accessible alternative. Could you talk through just how significant a problem that is and how many of those services are in fact provided by religious organisations, and the consequent, and what your concerns about that with this legislation are going to be?
Thank you, Senator, for the question. I do have some, just to answer in terms of number of services, I'd have to take that on notice because I don't have the number of NGOs that operate in the Territory, and take that on notice if that's the request of the committee. In terms of our non-government organisation service providers, we do have many religious-based organisations, often the only service provider providing either program services in some of our regional and remote parts of the Territory. Most of them are key service providers for Territorians who are vulnerable, disadvantaged, and in our remote areas, a high proportion of Aboriginal Territorians. Some of the organisations that many of you would know and be familiar with: Anglicare, Catholic Care, and some of the volunteer and groups like the Salvation Army, the Australian Red Cross, etc. So they are key partners for delivering services programs in the Northern Territory. So impact of some of the proposals or restrictions to the bill would definitely ripple through the community. We are a very small jurisdiction, as everyone knows, 245,000 people. It's not a 6 degrees of separation of the Territory, it's a 2 degrees of separation of the Territory, and even less than the further out you go from a major centre or a town hub in the Territory, and who is the service provider, the opportunities for employment are with that service provider, and who is accessing services or programs.
And how about with regards to schools? How many communities only have access to a religious school?
There's a couple. I'm a little bit dusty with my numbers because I'm not the Education Minister anymore, but we have 152 government schools in the Northern Territory, and from memory we have just under 50 non-government schools. That includes our independent schools as well as our Catholic and Christian schools. Some of them provide boarding house accommodation for their schools, but I'm from the top of my head, there are two communities. One which is a community of 3,000 plus people, and that is Port Eyre or Port Keith in the West Daly region of the Northern Territory, and they only have a non-government as their school provider for both primary school, preschool, primary school and high school, and that is run by Catholic Education NT as an example, and then there's the smaller ones that I can think of: Daly region, Xavier's College, which is on Kiwi Island, and then also, that's the top end, and then in the Daly region there is, in Nauru, there's a Catholic run school, and there's no government run school in that community of Daly River. So there are, and those communities are all hundreds of kilometres away from next township or the next community in many cases. So they're just a couple I can think of off the top of my head.
And so, I mean, as you say in your the second last paragraph, are you concerned about potential discrimination against LGBTIQA plus teachers and students potentially in those schools? Absolutely, and it's been my concerns for several years prior to this portfolio, and it still remains my concern. Great, thank you. Thanks, Chair.
Thank you very much, Senator Rice. And Minister, we'd like to thank you very much for your time today in giving evidence. Very impressed that you have appeared in person, the only state or territory representative to do so, and we also thank you very much for your commitment to our inquiry.
Thank you very much, Chair. Thank you to the committee. The Northern Territory sees this as a great opportunity to put our voice on the table and officially on the record. Being a small jurisdiction, we're still quite mighty, and we do hope that we have some weighting in making sure that the Territorians and the Territory perspective is taken into account in your considerations. Thank you very much.
Thank you so much. Your voice has been heard loud and clear today. Thank you, Minister.
Thank you. Good afternoon.
I now would like to welcome representatives of the Attorney-General's Department. Thank you so much for taking the time to give evidence today. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state or territory shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submission as submission 175. Thank you. For the Hansard record, would you please each state your full name and the capacity in which you appear today, including whether you have any correction to your submission?
Thank you, Chair. Andrew Walter, Acting Deputy Secretary, Integrity and International Group, Attorney-General's Department, and no, we don't have any corrections. Thank you.
Stephen Still, Assistant Secretary, Employment Standards Branch, and Colin Minahan, Acting Assistant Secretary in the Human Rights Branch.
Welcome to you all. Do you have an opening statement?
We thought in the interest of time, we're happy to go straight to questions.
Thank you so much. We will now move to questions from senators, and I will give the call to Senator O'Neill.
Thank you, and I thank you for being here in person. It's so much easier. It's been a difficult day. By the time we get to you guys, it's almost impossible to hear. So I appreciate you being here, and it is very important.
They've got no excuses. I'm sure they are based in Canberra, so it's
yes,
very good.
Yeah. Yeah, they are today, which is great.
We learnt our lessons. We're here in person.
In relation to Section 12, well, perhaps have you been listening to the evidence that we've been receiving over the course of the last couple of days?
I haven't listened to everything, but we've been keeping notes. I've had staff keeping notes on it. So we've had,
so you've got a bit of an idea of what's been happening, or?
Yep.
Okay, so in relation to Section 12, which I'd have to say is one of the most contested parts of the bill, the Australian Human Rights Commission has submitted that it is not aware of any cases where genuine statements of belief have been held to be contrary to Australian anti-discrimination law, paragraph 55 of their submission. Can I ask, is the Attorney-General's Department aware of any example? And if so, what are those examples?
Thank you for the question. No, we're not aware of any examples at the Commonwealth level. The proviso I would put on that, which I think is quite an important one, is of course religion really isn't a question under many of our existing discrimination laws. It does come up in the Sex Discrimination Act, and it does to some extent under the Racial Discrimination Act in relation to ethno-religious groups. But so there's unlikely to be a huge number of examples where religion is going to be in play. So that's the only proviso I put. So we're not aware of any, but it's unlikely to have come up in for example, in human rights complaints.
And I have asked a number of participants in this hearing to provide any examples that they might become aware of subsequently. So if that does come to us, then we would seek your response to that. In the explanatory memorandum, you cite a scenario that, according to the government, is an example of how Section 12 would work in practice. Now, the scenario involves a manager of a business who sends his employees a Christmas greeting referring to his beliefs about the birth of Jesus, and the explanatory memorandum states that if Section 12 becomes law, the manager would have a defence to any potential discrimination claim. In paragraph 77 of its submission to this inquiry, the Human Rights Commission says that the fundamental problem with this example is that sending a Christmas greeting, whether it refers to the birth of Jesus or not, would not amount to discrimination under any anti-discrimination law, and the explanatory memorandum doesn't actually identify how that conduct could, in fact, amount to discrimination under any anti-discrimination law. So my question with that context is, under what existing anti-discrimination law is it unlawful for a manager of a business to send a Christmas greeting card to employees referring to his religious beliefs about the birth of Jesus? Because that's the one that's cited in the EM.
Yeah. So thank you for the question. It allows me to come to a critical point about Clause 12. The point of Clause 12 is the government intends it to be clarificatory in nature rather than the creation of new rights. And that's a very important core principle behind the drafting of the provision. We completely agree that it is unlikely, there will only be the most limited of circumstances where mere statements of religious belief are likely to amount to discrimination in and of their own right without any associated conduct. And I think this committee has heard evidence to that effect in some of the submissions, and we would agree with that as general proposition. What was heard during the Religious Freedom Review and what has been heard from some religious stakeholders during our consultation is that nonetheless the threat of action being taken against them is having an impact on how they feel they can manifest their religion in the public space. So the intention behind Clause 12 is very much meant to give people confidence that if a claim were to be made against them of discrimination, that it could be resolved very quickly because you could point to Clause 12 and say, no, I am merely stating a religious belief.
So if I heard you correctly, for 5 days in 2 different committees, we have been discussing the novel elements of this bill, which is clauses 11 and 12. Yesterday, I asked many, many questions about 11 and 12, and I think I'm not overstating the high degree of expectation and emphasis that Section 11 and 12 are going to alter significantly the reality for people of faith to articulate their view. That's how it's been constructed, and there's great hope for what this novel piece of the legislation is going to provide. But you have said to me that Clause 12 is not going to do anything other than be clarificatory and is not the creation of new rights.
That's right. So I don't want to say that it's doing nothing because that's not correct. It clearly has a legal effect, and should a complaint be made under a discrimination law to which Clause 12 applies. And perhaps, can I just proviso this, because I'm talking really in that discrimination space, and I might then talk about Section 17.1 of the, subsection 17.1 of the Anti-Discrimination Act in Tasmania. Remind me if I don't come back to that, please. If we're talking about discrimination law, what it is doing is giving confidence to people of faith that if they, happen to, mention their religious beliefs over lunch at work, or they have a cross up next to their desk, or they have the Lord's Prayer in the shop that they are working in, that there will not be any prospect that somebody would be able to ground a complaint on that basis. Now, we don't think...
So is this the equivalent of a little... Can I continue? Is this the equivalent of a little placebo pill for the religious people of Australia? Because it sounds an awful lot like it. And when I first noticed in the Human Rights, the Australian Human Rights Commission submission, that they said that the provision is symbolic rather than substantive.
I don't think
they were right.
No, it's about providing certainty, and we do this a lot in the law, that we say this issue comes up where people feel...
It creates uncertainty.
Sorry, Mr. Walter, continue.
So people, have been saying to us that this issue comes up where they do not feel confident that they're in a position where they can express those views. This gives them that confidence. I don't think that's a placebo. I think it is making the law clearer and more certain on its face.
So, to be clear, in practical effect, there is no need for clause 12.
I think there would be some very limited examples where clause 12 might have a very substantive, some substantive role to play. But given all those provisos that are around it in terms of the definition of religious belief, including the fact that it has to be in good faith, obviously we can't step into circumstances where the words are said maliciously or they amount to harassment, discrimination and so forth. If we just confine ourselves to clause 12.1, then we think it is clarificatory of the law as it is.
So could I ask you to provide me on notice any of those very few minor examples that you just said might have some impact? Because I get the sense there's a whole lot more that people think it's going to do than what you've made clear today it's not going to do.
So I agree. I think the expectations are separate to what the law as written does.
Which raises a whole lot of political questions about how it's been sold as a product to people of faith who are approaching this with a deep and genuine concern. Can I just go back to my question though, the example that was provided in the explanatory memorandum? Could you give me a careful response to the sharing of a Christmas card?
So the intention there is actually that confidence and clarificatory element of it, to say, if I say, radio, I'm going to send a Christmas card to my, my staff. My staff are multi-denominational, and I send out a Christmas card. No one can say, hang on, you didn't send out something when Hanukkah was on or during Ramadan or things like that. You're treating us as your employees differently to how you treat people who are Christians. So that's where you would be trying to, if you were trying to ground a discrimination complaint and you were grounding it in this case, you're grounding it in religion, which would have to be under this bill after it passed, then you'll be grounding it on the basis that you are getting different treatment as an employee to the treatment that you receive if you're of a different faith.
Okay. I thank you for your response to my question. And can I just ask this question? If Section 12 is actually not doing any heavy lifting work, despite the level of belief that this is critical for so many people who've submitted, why is it embedded in legislation? Why is it not covered off in the explanatory memorandum? If it's only symbolic and to explain, what was the rationale for putting it in the legislation rather than simply describing the sort of situations that you think it will address?
So there's a couple of things in there. One, as I've said earlier, it is not uncommon where where it's felt that there is uncertainty as to the law, to put clarificatory provisions in. The effect of clarificatory provisions is if a complaint is made, let's say to the Human Rights Commission, just to keep it easy, a complaint is made to the Human Rights Commission, the Human Rights Commission can very quickly consider and say, hang on, that's just a mere statement of religious belief. This complaint goes no further. And it can be dismissed on that basis rather than having to go through a more detailed process of analysing the situation and attempting to conciliate. So I think it does have some practical impact there at the complaints end, if complaints are made. The other thing that I think is just important to note is I don't think it could have just been done by way of inclusion in the explanatory memorandum because, of course, it applies beyond this bill. It applies to anti-discrimination, all the Commonwealth anti-discrimination laws and the state and territory anti-discrimination laws. So you couldn't give that clarification just by saying in the explanatory memorandum setting that out because it wouldn't be.
What about if it was embedded in a second reading speech by the Minister? Again, I don't think it deals with that first point, that people, if somebody feels they've been discriminated against, regardless of whether there's a foundation in law for that, they can nonetheless lodge a complaint which has an impact for the person
against whom that complaint is lodged, regardless of whether it's got a foundation or not. This allows for things to be, I guess, dismissed or disposed of efficiently. And if I can just make one other point, which is...
How is that going to lead to efficiency?
Oh, because if a complaint is made, again, let's use the Human Rights Commission as an example, a complaint is made, it's clearly just in relation to the mere statement of, your Christmas card example. The Commission can look at the law and say, well, hang on, Section 12 applies, Clause 12 applies in this instance, so there is no foundation for this complaint and it can be dismissed on that basis, rather than going through a more detailed inquiry into the facts and the situation. So it provides some upfront clarity there. And if I might, I think it's really important that I do note that I've been talking about 12.1a, that's the discrimination laws. In 12.1b, the provision obviously has an impact in terms of subsection 17.1 of the Anti-Discrimination Act in Tasmania, and that would have the practical effect of limiting some of the grounds of complaint that can be made under that provision. So it is a much more substantive effect in relation to subsection 17.1.
Senator O'Neill, we will need to move to Senator Pratt because time is marching on. Could you put any other questions you have on notice?
Look, Senator O'Neill's asking the same question.
Oh, so you're happy for Senator O'Neill to continue for another 2 minutes? Okay.
Thank you. Thank you very much, Senator
You have the
Pratt.
course, Senator O'Neill.
Look, it's been suggested that Section 12 is going to somehow prevent unmeritorious anti-discrimination claims from being made under state and anti-discrimination law. But the Human Rights Commission, again, notes in paragraph 56 of its submission to this committee that the establishment of a new defence cannot prevent unmeritorious complaints from being made. And this is really a critical point because one of the key rationales for the provision is to prevent complaints from being made under Section 17.1 of the Tasmanian Anti-Discrimination Act. And some submitters have pointed to the complaint against Archbishop Porteous, it's been discussed both yesterday and today, which was ultimately withdrawn as an example of a complaint that would not have been made if this law had been in place at the time. Will Section 12 prevent, and indeed can the Commonwealth Parliament prevent complaints being made to state anti-discrimination tribunals, meritorious or otherwise?
So there's a couple of questions in there. So the short answer is you can't, the legislation will not stop somebody actually physically making an unmeritorious complaint in the same way as, it's very difficult to limit, somebody making an unfounded, bringing an unfounded court action against someone. What it does assist with is the disposal of that in quick time. So when it lands with whichever body it is, whether it's Commonwealth or a state and territory body, and maybe it's easier to stick to the Commonwealth for the moment. If it lands with the Human Rights Commission, it gives them another tool with which to dispose of that kind of unmeritorious complaint very quickly without going through the other procedures that they would otherwise feel compelled to follow.
Yet this law is going to have to interact with state jurisdictions, and you're seeking examples all of the time with the Australian Human Rights Commission. But we have had a lot of evidence about the challenges of the intersection between state and federal jurisdictions over this, and the novel dimensions of the way in which this bill's been constructed, particularly with 11 and 12, and how it's not actually going to be practicable. What do you have to say about the concerns, very substantial concerns by very learned people, about the practicable nature of these commissions at state level and federal level should this legislation pass?
That's the last question, Senator O'Neill.
So thank you for the question. It's a very important one. You're quite right. The relationship between the legislation and particularly state and territory tribunals, as in bodies that, or complaints bodies that are not courts, there is a challenge there, and it's a challenge that's caused by Chapter 3 of the Constitution. And there are a number of mechanisms by which the challenges thrown up by Chapter 3 can be overcome. They're more or less efficient depending on which jurisdiction we're talking about. However, that is a genuine problem. There is no way of drafting our way around that part of the Constitution, unfortunately. I mentioned in the Parliamentary Joint Committee on Human Rights, there is currently a case before the High Court which may resolve some of these difficulties, who knows. I don't hold out high hopes because it's a very technical area of Chapter 3 of the Constitution.
That is the case that was referred to by the Law Council.
That's right, the SITA case.
Yes.
And it relates to the Disability Discrimination Act and the disability standards. So there may be some resolution to some of those problems that come out of that decision, but there is no way of drafting our way around the fact that the interaction is complex with state and territory tribunals or complaints handling bodies.
Yeah, look,
Senator
there's so
O'Neill,
much more we need to ask of the department, Chair. Like, to have found out today, as the last witness, that Clause 12 is merely clarificatory, to get that on the record at this point of time is quite shocking. Can I just put on notice, you make it clear in your answer to me today, Mr. Walter, that there are very substantial differences in the way that this might work from jurisdiction to jurisdiction around the country.
More in the practical element,
yes,
rather than the interpretive element, if I can put it that way.
And the practical element matters because discrimination is, it's happening to me now. I want to get it in. I don't need to pay for it. I need to just advance it and get it sorted. This is going to change that whole nature of interaction. You've also made a claim that the way that this is structured will allow things to be dealt with in quick time, but I cannot see how things can be. An unmeritorious claim is going to be dealt with in quick time when there's such complexity in the structural entity into which it's being put.
So I think the answer to that is when we think about the way these complaints handling bodies work in particular, they're not like they try to avoid the court-like proceedings that we're all familiar with. So they're trying to, they sit down with people who are making...
Mr. Walter, can I just put to you that there's a lot of people in Australia who have no familiarity with what court-like proceedings are, and when they get to a discrimination hearing, it's very court-like to them because they never deal in sort of an adversarial context. They've got no literacy about it. So already there's huge impediments. That's what we've heard for people even going to a discrimination hearing.
So let me concede that point, but let me rephrase slightly. That when a complaint is lodged with a complaints handling body, there is a more informal interaction with those bodies about the nature of the complaint, whether the prospects of it proceeding, and whether you're in the right place and all those types of questions. Clause 12 gives those bodies a tool to say, we don't think that you're going to be successful in this and this is why. Maybe you should consider whether you withdraw it or take a different approach to the complaint. So even...
Take a different approach, does that mean take it to a federal jurisdiction?
Not necessarily, no. Because, and what I was thinking of there is the fact that it's often, complaints are often grounded in a range of different grounds of discrimination. So it's not necessarily just, so it might be race and sex, it might be disability and gender.
Let's just stick to religion.
Okay, so it might be religion.
Senator O'Neill, I do need to...
and gender, for example.
Close off at this point.
And it might be there's a better course of action for them to take to bring their claim under a different ground.
Senator O'Neill, could I ask you to put any other questions on notice to the department?
Chair, we have to because the time demands that. But I think at the close of this hearing, I do want to say, as I said before we started, this is a complex piece of legislation. And despite the fact that you have provided opportunities for many witnesses to be here for a half-an-hour session, this is such an important piece of legislation, and it's just not able to be interrogated properly to get to the truth. get to the truth of what's going on with this
well,
legislation.
that's why we have the important questions on notice process. I'll now...
I'd like to move that from the department again next week.
Senator Pratt, I'm sorry, look, you don't have the call. I am now going to go to Senator Scarr. Senator Scarr.
Thank you, Chair, and Mr. Walter, good to see you again. I've got a number of questions for you, and of course our time is limited, as has been noted. An issue was raised by the Australian Muslim Advocacy Network, and no doubt you're aware, the government is aware of the increase in acts of Islamophobia and also indeed the increase in acts of anti-Semitism. And we had the dreadful events in Christchurch recently. The concern is raised that there is insufficient anti-vilification protection against people where they're vilified on the basis of religion. And under the Racial Discrimination Act, people of the Jewish faith are, for example, protected because being Jewish is seen as going to ethnicity as well as religion, whereas someone of the Muslim faith, the same principle doesn't apply. And a quite evocative example was given of someone who, and we've had a recent influx of, and it's a good thing, of humanitarian visa holders from Afghanistan. And someone could arrive from Afghanistan, and if they're subject to vilification, it depends whether or not the word Afghan is used in the vilification as to whether or not they have a remedy, which doesn't seem to me to be an acceptable state of affairs. Can I get your view as to what is the law that applies, the anti-vilification law that applies, for example, for people of the Muslim faith, Buddhist faith, and we heard quite disturbing evidence from a number of witnesses of the Buddhist faith yesterday in relation to vilification at a federal level?
Thank you for the question. So I'll provide you with the provisions on notice because I think it's a very important question. However, vilification, we have general anti-vilification provisions in the Criminal Code, which provide substantial criminal penalties for these types of crimes, including against people on the basis of their religion. So they sit in the provisions that relate to human rights atrocities and so forth. So we'll get you the exact, I can't remember off the top of my head the exact provisions, but they're in the Criminal Code. And states and territories, there's a comprehensive suite of vilification laws in the states and territories as well. I want to be, I'm deliberately using the word vilification, and that has a particular meaning. Because it's commonly conflated with what are more colloquially known as hate crime laws. So vilification is about, it's all about the audience of the statement. So vilification is about inciting someone else to hate a religious group, for example. Whereas hate crimes are about hate speech directed at an individual who is of that particular religion. So vilification, there's comprehensive coverage. Hate speech provisions are much more patchy. So Section 18C of the Racial Discrimination Act is, I think, what you're probably referring to. That is the main hate speech provision in Commonwealth legislation, and quite right, as you've described it, it would apply to some ethno-religious groups. People of Jewish faith, probably Sikhs are another good example, but wouldn't apply, for example, to Christians. Then there's other provisions in state and territory legislation that's a little patchier. But we've got quite a good table of all that, so we'll dig that out and make sure that it's all up to date, and we'll provide it to the committee because I think it might be of value.
Okay. In addition to the table, I'm interested in the department's view, given what the Federal Criminal Code says, that as to whether or not there's a lacuna here, whether or not there's a gap here, in terms of the sort of speech, and I refer you, we got very moving testimony from Ms Markwell. I refer you to the submission from the Australian Muslim Advocacy Network. I'm interested to know whether or not there's a gap here in the law. You referred to it, the hate speech law as being patchy. My concern is it so patchy that certain elements of our society aren't protected by it at the moment? And that really goes to the nub of the issue, and whether or not the patchiness needs to be evened out. Does that make sense?
Yeah, I completely understand. We will do that. We'll need to consult with our colleagues in the Department of Home Affairs who have more general responsibility for these types of issues. So we'll do that.
Okay. My next question relates to the question has been raised, submissions have been made that there should be a reasonable adjustments clause in this bill. So, for example, if you have a large employer who maybe has 1,000 staff, for religious reasons, a number of the staff must, as a result of their religious sensibilities, their religious faith, must participate in prayers at a certain time during a week, or must respect the Sabbath, then there should be some sort of provision or some sort of mechanism which requires the employer, to the extent reasonable, to make adjustments, for example, to rosters, I'd imagine, to try and accommodate those genuinely held matters of faith. Does there need to be a reasonable adjustments clause in this bill to accommodate those concerns, in your view? Or is it covered elsewhere through, for example, the operation of the indirect discrimination provisions?
I guess the whole point of the legislation is that if you are are a person of faith, are you being discriminated against because you're, say in the employment context, for not being able to practice your religion? And so there's probably two elements to that. One is just straightforward direct discrimination examples where we just don't employ Christians, Muslims, Jewish people in this place. Otherwise,
that's easy to understand.
Yeah, otherwise, yes, you're into the indirect discrimination rules, which is more about saying, actually, we want to, put in place, general policies that have a particular impact. And again, the question there comes down to reasonableness. So if you are implying a general prohibition on people, doing fairly, mundane things like, wearing a cross around your neck or, going off to a prayer room every now and then. If you're putting general prohibition that there's going to be no engaging in those types of activities, and you might say, well, that applies across the board. The question is that reasonable or not? For example, in the jewellery case, like wearing a cross around the neck, there's European case law that says in some circumstances, yeah, that can be perfectly reasonable. If you work in a hospital, there's a risk somebody will grab your necklace and injure you or themselves, then that might be perfectly reasonable. But if you're working as, I think there was a British Airways case, as an attendant on a check-in counter, well, that's not a reasonable restriction on your faith. I'll just check with Mr Minahan if he thinks there's anything else I should add to that, but I think it would be picked up in the general discrimination laws. That's the whole point of the bill, essentially.
Okay. In relation to that example you gave of the flight attendant, someone working at a check-in desk,
yep.
Having a manifestation of their religious faith, as opposed to a worker where there's a safety risk, health and safety risk associated with some part of religious garb or religious manifestation. Does the bill make clear who bears the burden of proof in terms of demonstrating that is a legitimate health and safety matter which cannot be otherwise accommodated? Because I must say I have a concern in those cases that really the burden should be on the employer to demonstrate that it is an essential safety requirement, as opposed to the employee who's obviously in a less powerful position.
Thank you for asking that question, because it is actually a very important one. So there is an omission in the bill in relation to burden of proof in relation to that provision, and we're working with the attorney to rectify that. That was literally our fault in the drafting. It was in, you'll see it in the exposure draft, and it disappeared as we were going through iterations of the draft. So we are working to correct that burden of proof element.
Oh, excellent. Okay, thank you.
And sorry, just to add, and that will make it consistent with all the other indirect discrimination provisions in the other Commonwealth legislation, discrimination legislation.
Excellent. Excellent.
Are there any other? Are there any other drafting corrections that you're making?
That's the one we have approved. Yep.
Sorry, what one have you approved?
Oh, so it's in relation to the indirect discrimination provision. It's related to the burden of proof of, in relation to the reasonableness of the imposition of a general rule. And what we accidentally, and I apologise to everyone for this, and I've apologised profusely to the attorney for this, we managed to drop the burden of proof provision between the exposure drafts and the draft that was introduced into the Parliament, so we're working to correct that.
Thank you.
And that, as I said, brings it into line with the
Thanks, Mr Walter. Look, I'm just wanting to ask if you would be happy if we extended the session with you for another half an hour until 5:30. Would that be convenient for you? Obviously, we've got a little bit of leeway, and after consulting with all senators, that will work for everyone. So thank you for giving us another half an hour of your time. Senator Scarr, do you have any more questions?
Look, I've got two more little questions, if I can. I'll try and be as quick as possible. We heard evidence today from employer groups, and noting that in many cases employers are going to be burdened by the obligations flowing from this bill, and it's their workplace, their employees, who are going to be governed by some of the provisions of this legislation. And the point was made that from the employer perspective, there should be clarification through a reasonable management clause, if I can put it like that, which makes it clear that an employer is entitled to, in the context, say, of statements of religious belief, to have a rule that basically says, well, that's fine for the reasons you outlined, Mr. Walter, that sort of interaction at some level in the workplace in terms of Christmas greetings, etc. But our employees are not permitted to go around putting statements of religious belief on their fellow employees' desks, or to proselytise the customers of the business, or to ask inappropriate questions of customers or fellow workers. And from the perspective of the employer groups, and you could take this on notice in relation to their proposed amendments, there was a concern that there needs to be some clarification in relation to the employer's ability to ensure that they can take reasonable management steps to make sure that the social cohesion of their workforce isn't negatively impacted. Do they have a legitimate concern in that regard from your perspective?
Thank you. I might ask Mr Still to address that.
Senator, we're aware of that submission, and we've given some thought to it. I suppose our initial view would be that, of course, clarification will always make things clearer, but the conduct that was discussed in terms of employer action seems unlikely to be unlawful under the bill as it's currently constructed for a number of reasons. So, in relation to direct discrimination, if the employer put in place a policy that was not discriminatory between any particular group, but did impose kind of rules around kind of respectful workplaces, the kind of materials in general terms that could be placed on people's desks and so forth, it would be quite unlikely to offend the direct discrimination prohibition, because if you apply the comparator test, if you treat materials that relate to perhaps political opinion in the same way that you treated materials about religious belief, then it simply wouldn't be discriminatory to impose that condition. And of course, in relation to indirect discrimination, if you impose a facially neutral condition, requirement or practice, that will always be okay, provided that you can establish that it's reasonable. And of course, one of the key elements of that proposal around reasonable management action was reasonableness. So in a sense, the reasonableness defence to indirect discrimination and the reasonable management action proposal are doing much the same work in relation to facially neutral policies. And I suppose the other observation, another initial observation I would make is that in relation to employers' very legitimate interest in providing a safe workplace, which may be related to this, the bill doesn't affect either employers or indeed employees' obligations under work health and safety law to provide a safe workplace. And so anything that employers did I suppose that they considered to be necessary to comply with their duties under work health and safety law would be not unlawful under this bill.
So I understand those arguments. I guess the concern I have, in my background, I'm ex-general counsel of a company with 4,000 employees, and you've had a dispute in the lunchroom or something, and someone comes in and says, well, I had the right to say that because it's my religious faith, and I'm protected under the statement of belief clause, and or someone says they didn't have a right to say that because of X, Y, Z. You can see the practical situations which employers, from their perspective, want to make sure that there is sufficient clarification in this bill to make it clear what is permissible for them to say, so that they get to their employees, so they can say to that employee, well, you're not entitled to make, and you've heard some of the examples, a certain statement to a customer with respect to their religious affiliation, or a statement to a patient in a hospital bed in relation to why they might have a particular disease. There's a real concern there that the bill isn't clear enough around those sorts of statements, and it needs to be, it really needs to be tightened to provide clarification that the intention is not, and I understand the intention is not, statements which go, or behaviour which goes beyond the bounds of acceptable workplace behaviour for any of the reasons that you outlined. Can you see that concern, and perhaps the department take on notice whether or not there is an opportunity to accommodate some of what I believe are legitimate concerns to make sure that that's made clearer in the bill?
Yes, Senator, I think we can take that on notice.
Thanks, Senator Scarlett. Just conscious that while we've got more time, we still need to keep moving.
I'm done, Chair. Thank you.
Thank you very much. Look, I've just got a quick question of the department in relation to Clause 12, the statements of belief. There's been, as we've discussed, a lot of concern raised about the statements of belief provisions, and including in relation to this won't stop harmful or inappropriate comments being made. Can I ask you to respond to those concerns?
So I think that it's important to... Clause 12 is very circumscribed, and it is on a number of levels. So firstly, the starting point is it has to be a statement, and it doesn't extend to conduct, which could be a course of conduct. So it's a mere statement of belief in and of itself. And that's a critical, narrowing to begin with. Then if we actually go to the definition of what a statement of belief is, and just for ease, so we don't take hours over this, I'll just stick to religious beliefs because it also works for non-religious belief. Has to be a religious belief held by the person. That's really important. You can't, you don't get to take advantage of this by saying, Muslims think X, Y, and Z if you're not a Muslim. So it has to be a religious belief that you actually hold. It must be made in good faith, and I might come back to that because it's probably in some ways
things like you're in a wheelchair because you don't believe in God, for instance, if there's been a reference to that type of example.
So maybe if I unpick that a little bit. And the third element is you have to genuinely believe that is part of the doctrines and tenets and beliefs of your faith. So you don't get to just make up things and say, I'm a Christian. And
So
I
do
think
you
X,
have to
Y, and
do you
Z.
have to believe that it's part of the doctrines and tenets of that religion? There's got to be a factual basis for that belief. You can't just subjectively believe that.
So it's a test of whether the individual believes it or not. It has to be, well, there's a couple of elements here. It needs to be a religious belief in the first place. So if it doesn't meet the threshold that the High Court has set down in terms of what constitutes a religious belief or not in. Secondly, you subjectively have to genuinely believe that it is part of the doctrines and tenets and beliefs of your faith. And that's necessary because faith there's of course established religions, and perhaps I'm displaying my Protestant background, but for Protestantism and many other religions, it's about your personal relationship with God or with the Bible, for example, which means that others may not share that common interpretation. But it has to be genuinely held. So there needs to be some demonstration that you have held that belief and do hold it and have held it on over time.
But does it have to be genuinely held in relation to, you've got to factually be able to demonstrate that what you hold as your genuine belief reflects the doctrines and tenets of that religion. Your so-called relationship with God can't be separated or not connected with the doctrines and tenets of that religion.
Yeah, it's...
So in other words, you can't just make something up.
Well, you can.
Well,
If
that's
you
what
genuinely believe
well,
that
that's what I'm seeking
so,
to
you
clarify,
can.
because that's been a genuine concern that many have expressed during these 2 days of hearings.
So what it doesn't do is it doesn't apply an objective test of saying, for example, I believe X, and then you would go to the codicils of the particular religion and say, yes, we can find it here, those two match. It is about, do you genuinely believe, and there's a lot of jurisprudence from the United States about this, about how you establish that. Do you genuinely believe that this is part of the doctrines and tenets beliefs of your faith? And if the answer is yes, then the third element is good faith, and that is, I think that's the real nub of the issue when it comes to those things like you're in a wheelchair because of you're godless or you're homosexual.
And just let me say
that
that's an abhorrent, horrible thing from my perspective.
Of course,
for anyone to say.
Of course, I think.
But that has been an example raised.
So good.
I mean,
sorry, can I just mention good faith very
Mr.
briefly
Walter.
there, because I think it is very important. Good faith in that context means, A, are you saying something there's a fidelity element. Are you actually saying something is consistent with your religion? But that's picked up in the other elements. The critical bit here, drawing on the decision in Brofo, which is a federal court decision of Justice French, it's about exercising that effectively right to free speech in this instance, conscientiously having regard to the aims of the legislation that is impacted, which in this case is, say, the Religious Discrimination Bill or the Disability Discrimination Bill as another example. So if, for example, you're talking about a care worker of some sort saying that type of abhorrent statement, it's simply not protected because you would not be able to get over the good faith element. So it grounds the statement in the factual circumstances in which it's made.
So just to give you an example, could someone who is pro-euthanasia and made some comments in relation to that issue genuinely consider that such a position was in accordance with the doctrines and tenets of Catholicism, for instance? So the concern is that when you start to rely on the individual's
That's how it's drafted.
the individual's belief as to, or their genuine belief, which might not be connected in any way with the doctrine or tenet of that particular religion, then isn't there an issue with an objective test not applying?
I think in that particular example, in theory, yes. However, that person needs to establish they genuinely believe that. And so you're going to be looking for, a pattern of evidence that they've held that belief for a long time or they've expressed it in many ways.
But surely that doesn't make sense because that's not consistent with the Catholic doctrine. So how can they genuinely believe that that's part of the tenet of that faith when it clearly, on its face, does not accord with the doctrine or tenets of Catholicism? So how could that...
And that's before we get to the religions that are new and don't have such a body of evidence.
Well, and that's what makes this obviously very complicated. So again, I say, is there not a difficulty because there's not an objective test, it's a subjective test?
So I think there's 2 points to make. The first has already been made for me by Senator O'Neill. Yes, it has to reflect the fact that there are a wide range of religions and religious practices, and as I mentioned, different ones have a different relationship to institutional religion, if you like. The second point is, I think it would be quite difficult for somebody who said, "I'm a practicing Catholic. I go to church every week. I go to confession. I do all the things that a good Catholic does." I think they would struggle to get over that, be able to say, and I genuinely believe that that is part of Catholic doctrine. Because
what if you're a bad Catholic? There's a lot more of it like that. Right?
Senator O'Neill,
how pure do you need to be to actually use that defence?
Speaking for yourself,
seriously.
Not many others.
But I think it becomes a factual analysis there. I think you're going to struggle if you really are doing those things all the time and saying that is my genuinely held religious belief. If you are a non-practicing Catholic or not particularly religious or whatever, again, you're going to struggle to establish that that's your genuinely held religious belief because you're going to struggle to establish that you have religious beliefs.
Chair, I'd like the call at some point, please.
Yes, I will move on. I'm going to give the call to Senator Rice.
Thank you.
And then I'll move back to Labor. Senator Rice, if you could try and maintain, keep about 10 minutes, please.
I thought you were going to give me 15. So, look, I know we discussed this last week at the Parliamentary Joint Committee, but I wanted to get on the record for this committee what the department knew about the so-called deal with the Liberal moderates, and in particular, prior to the beginning of December, so prior to the 1st of December, prior to when we saw the bill, had the government sought any briefing from the Attorney-General's Department on changes to the SDA, Section 37.3 in particular?
38.3.
38. Can I be really annoying and take this on notice? But let me...
Even though it was the same question, basically the same question we asked you last week.
Well, we have that question, we're considering the answer to it. The reason I am saying that is, so let me say two things. We, after the bill was introduced, we identified the problem with the indirect discrimination provision, which I mentioned earlier, and we got approval to develop amendments to correct that. We have also been in regular communication on a range of other possible changes to the legislation, taking into account what's been said in these committees and so forth. So we have that kind of dialogue all the time, including with the Attorney's Office. We do not have any approved amendments to this package of legislation apart from that indirect discrimination one I mentioned. The thing that I am being cautious about is because if we were to make any, there's a range of them that are potentially in play. If we were to go down that path, that's a decision that goes into the Cabinet process, and that puts me in a difficult bind because I can't talk about that because it's in the Cabinet process.
And I don't want you to talk about the content. All I want to know is whether you were consulted on potential changes to the SDA prior to the media coverage of the deal on the 1st of December.
Before the 1st of December.
Yeah, so understood. I don't know, as I think I said in the last hearing, we don't know the details of any discussions that may or may not have taken place and who they were with. I can confirm we've had discussions with the Attorney's Office. I've not spoken to the Attorney myself about a range of amendments that could possibly be made to the bill. I'd like to think about whether I can give you more detail.
But that's to that bill, but how about to the SDA too?
Oh, if you would...
we're talking about the deal,
I understand.
The deal that, the moderate Liberals would pass this bill as long as there were the changes to modify or remove section 38.3.
So at the risk of irritating you even more, if we just put a hypothetical that if the government was to amend section 38 as part of this process, they would do it through an amendment to one of these... well, it wouldn't be the main bill, it'd be probably the consequentials bill.
Right.
Or the other bill.
And so can you tell me whether there have been discussions about that, about doing that?
That's what I'd like to take on notice, as to whether I can give you more detail about the types of things we have discussed.
Mr Walter.
Go on.
Senator Rice, have you
If I can.
finished your questions?
No, I haven't finished my question, but I'd
Senator
also
O'Neill wants to take it up.
Senator O'Neill
Just
ask
very conscious that
clarification,
Senator...
supplementary.
Exactly, on the same matter.
Yeah.
If I can, it is a week since this question was asked. We're not asking in the general, we're asking a very specific question, which I think has been well ventilated, certainly by me many times in the course of this hearing. Did you draft any amendment to section 38.3 prior to the 1st of December?
So
it's a yes or no, I'm not asking for detail. Did you do it or did you not do that?
So what I can say is there are no approved amendments to section 38.
That's not what the question.
No, I said that's what I can definitely say.
Okay.
There are no approved amendments to section 38. Can I take the
did you draft
I need to
one?
consult with the attorney.
So, Senator O'Neill, if I can just interject here, Mr Walter has already indicated that in response to Senator Rice's question, he is going to take that question on notice. Do you have any other question?
Well, I think Senator Rice believes she still has the call,
Thank
and
you,
I think...
All right, okay. So,
and
obviously,
are you able
Senator
to
Rice,
answer,
you have the call.
have you drafted any amendments since the 1st of December, or do you need to take that on notice as well?
When did we draft the amendment to 16?
It was the Monday after introduction, so that was...
That's not the one you're interested in.
No, but that's the one. Any amendments to 38.3 of the
so
SDA?
That definitely has been drafted and approved. Sorry, not to 38. You're only interested in 38.
I am.
There, as I said, there are no approved amendments to section 38.
But have you drafted any?
Again, I would like to take on notice what I can tell you about amendments that we've been considering.
Have you been asked to do any work on amending section 38.3 of the SDA?
We have undertaken work in relation to the legislation, but nothing has approval. We are still considering amendments.
Have you done any consultation on any potential amendments to section 38.3?
I think I can safely say no. I think without giving anything away, I think that no.
And so it's your view then that, so is there any, from the Attorney General Department, is there any substance at all to the so-called deal that was in the media on the 1st of December?
I simply don't know. It's as simple as that. You'd have to ask the attorney. And I think you have asked the attorney, and really it's a question for her.
So
I just don't know.
So basically at this stage we haven't got any progress at all of modifications to 38.3 as part of this package or separately?
No, I don't agree with that because
there's been a referral. There has been a referral to the Australian Law Reform
to report
Commission.
back 12 months after we get this legislation through.
That's correct. Yes.
So, which makes it so if this legislation happens to get through, in the next couple of months, we're looking at mid-2023 that the Attorney General, the Law Reform Commission reports back.
Yeah, that's fair.
Can you just remind us? It was 2018 that the Prime Minister basically said in response to the risks to LGBTIQA plus kids that their PM understands is going to take action to fix it.
Yes.
So it's a broken promise, isn't it?
4 years ago.
It's been put off for...
Senator Rice, that's not a question which is in order to a member of the department. Could you ask your next question,
the Attorney
please?
General's perspective, some of the stories that we have heard from young people as part of this inquiry and previously I mean, one of the stories, when I came out as trans, they already had caused a student to voluntarily leave and told my mum they'd do the same to me if I didn't quiet down about being trans. I was unable to go to the staff about what I was experiencing because I knew it would not be taken seriously and that I was likely to be expelled. I mean, how much longer do students have to face discrimination, homophobia, transphobia at school because the government is not taking this seriously? Because you have to take on notice even whether you've been, consulted, whether you're doing any work on 38.3, and in fact the Law Reform Commission isn't going to report on it for yet another year.
Senator Rice, I'll just remind all senators that it's not in order to ask an opinion in relation to a particular provision or law of any departmental officer. So Mr Walter is probably quite constrained in how he can respond. I would rather, I really would rather that you rephrase your question so that it is properly in order.
Senator, can I do this? I understand the questions that the committee is interested in, clearly understand those. We will go back and we will see what detail we can provide the committee about the nature of matters we've considered since the bill was introduced.
Okay.
Thanks,
I
Mr.
do
Waller.
want to note that someone who wasn't even in high school in 2018 is going to have finished high school by the time the Law Reform
Do you have
Commission
another
review
question,
is
Senator Rice? Because
completed.
actually we've really reached the end of your
I do. I want
time.
to go to just go back to the issue of Clause 12.
Senator Rice, I'm going to give you only one more minute
Okay.
because I do have to go back to Labor senators.
Okay,
Just
where you said
one
that it was
strict minute, sorry.
clarificatory, most limited of circumstances other than the override of Section 17.1, which you said is more significant. Given my time, can you just take on notice why it is important and why the government thinks it's important to override Section 17.1 and that is more significant? And just reflect then on the evidence that we've heard. For example, in the submission from the Discrimination Law Experts Group, they said the balance between federal discrimination laws on the one hand and state and territory discrimination laws on the other hand would be thrown into disarray by Clause 12. Huge impact for something that you were describing as just being of limited circumstances, clarificatory, which the Human Rights Commission say is unnecessary. Why is it considered necessary to do that for such limited outcome and throw out the state and territory, state versus federal balance of laws into disarray, as Adleg described?
Thank you, Senator Rice. That question will be taken on notice. I'm now going to give the call to Senator Pratt and then to Senator O'Neill. Or would you rather go to Senator O'Neill? Yes, Senator O'Neill.
So first, can I indicate, Chair, I appreciate we're going out to 5:30, but I fear that the questions that I need answers to and that I think are very, very important that we get a response to are unlikely to be able to be completed in that time. So I foreshadow that we may need to recall the committee and have a further session with the Attorney General's Department to get to the bottom of the matter. Can I also indicate that if the bipartisan bill that was proffered by Mr Morrison 3 years ago had been introduced, we would have avoided this kerfuffle. But right now, I want to go to the indirect discrimination error just to be 100% clear about your evidence this afternoon, that the government spent 3 years on a bill and the bill it finally introduced into the Parliament in the last sitting week of last year, after those 3 years, contained basic drafting errors. Is that correct?
That's correct. And once again, that is entirely the department's responsibility. I've apologised to the attorney. I apologise to the committee.
But it means that if the Prime Minister, the practical reality is if the Prime Minister had got his wish and rammed this bill through the House of Representatives in the final week of 2021, the House would have passed a bill which, by the government's own admission and your evidence today, contained basic drafting errors with regard to indirect discrimination.
Senator O'Neill, if I can just interject here, I think Mr Walter has obviously corrected the record in relation to this drafting error.
Yes,
can I encourage
you answer
you?
the question, please? Is that correct?
No, I don't think that. Well, I can't comment on the commentary element about ramming it through, but I can say we picked it up pretty fast after introduction, so I don't think so.
So after introduction, what time did you pick it up? If you can take that on notice, that would be of most interest. Could I quickly go to once again ask for a very simple answer. Was there an amendment drafted by the department in the course of that week to deal with Section 38?
Senator O'Neill, that question's been taken on notice. Could I ask you to ask your next question?
I'm not asking for detail. Did such an event occur?
Senator O'Neill, as you know, once a question has been taken on notice,
Well,
it's
that's
not
your interpretation.
it's not
Mr.
in.
Walter must have the answer.
It's not in order to. I mean, Senator, if I can
It
just make it
matters.
very clear,
It matters a lot,
It does.
Chair.
It does.
It
But the
matters that
rules-
this answer gets.
But the rules of the
gets
Senate, the
liberated
rules
here today.
Senator O'Neill, the rules of the Senate are that once a question has been taken on notice, unless there's a change and the department is able to answer any element of that question, then I would ask you to ask your next question, please.
All I can do is repeat the statement I made earlier, which is that there are no approved amendments to Section 38.
Okay. The problem is, apart from the commentary that's being run to prevent clear and quick answers, Mr. Walter is quite happy to say no directly to a question about 38.3 when he was asked if he consulted with stakeholders, but you are preventing him from answering my question about whether a draft amendment was considered, developed in the last week.
Senator O'Neill, sorry, if I could just ask you to pause. I would ask
We're
you not to.
definitely going to be back next week, Chair,
I would
if
ask
this
you
keeps
not
going.
to reflect
Seriously, it's
Senator
a simple
O'Neill,
answer.
could I just bring you to order for a minute? I would ask you not to reflect on me as chair. I'm just reminding you of the rules of the Senate, that once a question has been asked and it's been taken on notice, then
You've already said that, Chair.
It's not open to you to ask
This
it
is too
again.
important.
So just please, if
My
I can
time
invite
is
you.
dripping
Your
away
time is
everywhere.
very precious, so please ask your next question.
Senator, I've taken that on notice. We will endeavour to get you an answer as soon as we can about the nature of any amendments we considered.
With regard to 38.3 in the last week of Parliament. I want to be very clear, not
Understood.
since. Can I also clarify, based on what you've said this afternoon, that as of the commencement of these hearings, last week and this week, you have now begun to work on a range of amendments?
No, that's...
A range of
sorry,
amendments are under construction, was what I heard you say.
No. Well, if I'd said that, let me clarify. We have ongoing discussions as both committees have been meeting, as evidence has come up. We, of course, discuss the evidence that is being led and whether there's something of substance to it, and whether amendments, may or may not be required. We have not done any drafting.
Are you having discussions about drafting?
No, not at this stage.
You're just
no.
having general discussions about the evidence that's emerging?
Well, a good example was the discussion we had a short time ago with Senator Scarr around issues raised by business that we, of course, when that was led and was in the submission, we've, of course, had discussions about whether we think the bill adequately addresses that problem, as you would expect us to.
And did you have similar discussions about, disability access and the union's concerns about workplace?
We've talked about a whole range of issues, yes.
Can I go to constitutionality, because I've asked a number of questions about that as well. You're probably pretty aware of where I'm heading, but Professor Toomey's submission, despite her being unable to attend and give voice to it, raised concern about Section 109 of the Constitution, which does provide that the Commonwealth law prevail over any inconsistent state law to the extent of the inconsistency. She says in her submission, in the last paragraph, it is confounding to contemplate why these provisions of a highly contentious bill will be drafted in such a provocative manner. Professor Aroney and the Law Council have also expressed doubts about the constitutionality aspects of this bill. And Professor Toomey and Professor Aroney to this committee and Joint Standing Committee and asked what, in light of the evidence, this bill is the bill on a firm constitutional footing? And that's my question to you. If not, why not? Is it? What is your view about Professor Aroney's amendments to what has been drafted?
So there's a couple of things I can say. Yes, we believe the legislation is on sound constitutional footing. We received advice on a range of the provisions in the legislation some of them are very clear cut, so we didn't, but there's other provisions in the legislation that, of course, we got legal advice on, and we have shaped the legislation in accordance with that legal advice. There is nothing that we've heard or seen in the submissions or what we've heard so far that has caused us to rethink our view. And just in relation to Professor Aroney's suggestion, again, we don't see anything there that causes us at this point to think that we need to rethink how we've done it. I think the committee's also heard evidence that it may have other consequences as well, and so if we were to head down that path, we would want to go and get our own independent legal advice on how his approach to the legislation works, and of course we have not done that at this point because we think the bill's on sound constitutional footing.
So basically, a huge amount of yesterday, and key faith leaders across a range of denominations in the Christian tradition and other traditions expressed concern about clause 12 and the drafting, and they all supported, or most of them supported, clause 11 and clause 12 as drafted by Professor Aroney. You did see that evidence yesterday.
Not everyone did.
Not everyone, but yeah, that's why I clarified that. Thank you, Senator.
Sorry, what's the question?
So the question is, did you see that evidence yesterday?
Sorry, no, I did not see Professor Aroney. I've read his submission, but I didn't see it on clause... So are we talking about clause 11 and 12?
Yes.
So I'm aware of the general tenor of the arguments he made, and once again, in relation to those provisions, we obtained legal advice. We're confident that it's on a sound constitutional footing.
So...
One more minute, Senator O'Neill, then we do need to close the hearing.
As I said, I foreshadow that we may need to get back.
Well, we can deal with that in a private meeting, but we have to
given
close
that you've given
5:30.
the evidence to this committee today that clause 12 is merely clarificatory.
It's not.
And not substantive.
In Section 17(1) override.
In your view.
Why you would override things if it's...
And Professor, and the evidence that we received yesterday of a preference by many of the faith groups and their leaders for an amendment to clause 11 and 12, I would ask you to give formal consideration to that, have a much closer look, and to provide this committee with confidence by addressing the concerns or the hopes that were raised, I guess, by people who were putting their hopes on this Aroney redrafting, to give us advice about that, and also for those who said that it should be just disappearing, which is the contrary evidence. Could you provide a response to that as well?
Thanks, Senator O'Neill. We are going to have to finish.
I do want to just put one on notice.
It'll need to be in 20 seconds. Sorry. Or you can put them in, or you can put your questions on notice in writing, because I'm sorry, I had to be very strict about finishing at 5:30. So could I ask that senators, if they have any other questions on notice, could they please do so in writing to the department? And I want to thank our officers today
Chair,
for appearing.
Not enough time.
No, I hear what you
time.
say, but for today, at the very we have agreed that we need to finish at 5:30. So thank you very much to the officers for appearing today. We are very grateful. That concludes today's proceedings. The committee has agreed that answers to questions taken on notice at today's hearing must be returned by close of business Thursday, 27 January 2022. Thank you also to Hansard Broadcasting and to the Secretariat. I declare the hearing adjourned. Thank you.
Thank you.